Court officer. Court officer. Court officer.
Sir, ಹೇಳಿ sir.
16.
Sir, ಹೇಳಿ.
ಹೌದಾ? ಹೇಳ್ಬೇಕು. ಅದು ಇದು ಸಂಜೆ ಕೂಡ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಬೇಕು. ಈಗ 13 ಅಲ್ಲಿ ಇದ್ದೀನಿ, ಬಂದಿಲ್ಲ.
Sitting late ಇದೆಯಾ ಸ್ವಾಮಿ?
ನಾಳೆ ಅಂದ್ರ ಸರಿ
ಇಲ್ಲ, ಬರ್ತಾ ಇದಾರೆ ಸರ್.
ಇಲ್ಲ ಏನನ್ನ ಯಾವ್ದಾರ ಮೀಟಿಂಗ್ ಫುಲ್ ಕೋರ್ಟ್ ಮೀಟಿಂಗ್ ಏನೋ ಇದೆಯಲ್ಲ.
ನೋಡ್ರಿ ನಮ್ಮ ಮಾವು ಇಲ್ಲೈತೆ.
ನಂಡೆಲ್ಲೂರ್ ಪೇಪರ್ ಅದು
ಇದ್ಯಾವ್ದು ನೋಡಂತದೆ.
ಇದೇನು ಇವಾಗ ಆಫ್ ಮಾಡಿದ್ರೆ ಏನಾದ್ರು? ಇದ್ರದ್ದು ಆನ್ ಆಯ್ತು. ನೀವ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರಲ್ಲ ಅವಾಗ್ಲೇ ಆನ್ ಆಯ್ತು ಇದು. ಆಯ್ತಾ? ಇಲ್ಲ ಫೋನ್ ಮಾಡೋಣ ಅನ್ಕೊಂಡೆ, ಅದಕ್ಕೆ. ನಮ್ದು ಸೇರ್ಸಿ ಇಂತಿಂತ ಡೇಗೆ ಅಂತ ಬರದ್ಬಿಡು ಅಂತ ಬೇಡ. ಆಯತ್ ಕೊಡ್ಬೇಡಿ, ಕೊಟ್ಬಿಡಿ, ಕೊಟ್ಬಿಟ್ಟು ನಮ್ದು ಇಂತಿಂತ ಡೇಟ್ ಕೊಡು ಅಂತ.
Sorry. That's one election matter. Election is on Sunday. Tomorrow. Rest. Same matter. Permission to pay examination.
As a flat owners, respondent 3 is claiming to be an association. We have flat owners, my lord. Respondent 3 is claiming to be a association registered under Karnataka Societies Act, my lords. So,
for vacating interim order. Well, it's a consumer matter which is no state. Anytime in the next week. Anytime in the next week, man. Next week or.
It's a writ petition. It got dismissed for non-compliance of officer. Non-compliance of officer, but pertaining to same apartment, plan for the to take the of 2020, 22.
Next, my lords, serial number 28. There are two connected matters, my lords. Parties have settled, my lords. In respondent's petition, they have sought for quashing, whereas I didn't. So I'm filing a fresh petition for quashment also, so that it can be clubbed, my lord. Please, my lord. My lord. Yes. Great. Yes, my lord. Yes.
if the writ has been become infectious, there is a matter between in the Tata Housing Finance Capital. The matter must be posted on next week. Next month. GMRS.
Society not able to conduct the election. His petitioners are putting objections on the election. And we are corresponding. They are not letting us conduct the election. Pending man.
My lords.
Existing elected bodies, political influences appointed tomorrow. Resign ಮಾಡಿದ್ರು ಅಂತ is appointed administrator. Already existing elected body ಇದೆ. 7 members ಇದ್ದಾರೆ. Quorum is ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ 3 ಜನ ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ appointed administrator ಮಾಡಿದ್ರು ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ. Existing 50-50 ಇದೆ quorum ಇದೆ. Bylaw is very clear. So how many 10 members is the elected body member. ಅದರಲ್ಲಿ 3 ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ. 7 members present ಇದ್ದಾರೆ. The bylaw is very clearly says that 50-50.
My lords, memo in education matter, my lords. This honorable court has ordered for relaxation of requirements for petitioner schools to obtain renewal of recognition, my lords, despite which the respondent authorities are not opening the online portal to apply for renewal of recognition, my lords.
Nothing else.
Yes, my lords, but we have filed an IA requesting to open the online portal, my lords, to apply for renewal of recognition.
Everything else you are complied?
Yes, my
The
lords.
property tax?
Yes, my lords.
You
We
are
are
complied
filing.
then only, otherwise please verify and then move the matter, otherwise don't move it.
Okay, ma'am.
This is with respect to disobedience of the order passed by this honorable court, which is of senior citizens matter.
Contempt.
How so? Already it is filed before this honorable court, and it was last Wednesday itself, it should have been listed. At the last occasion memo kottide, in spite of memo list agilla swami.
So it is 6th, 3rd.
Adjournments. List number 1, page number 11, serial number 26 to 28. Page number 12, serial number 30 and 31. Page number 13, serial number 32 to 35.
Thirty-two.
Already moved in the.
32, the party in person who is present in person submit that he is not well and he seeks for an adjournment. Relist on 13th December?
Because I'm not keeping the, I got arthritis.
Arthritis will not go away. So
So it's aggravated right now.
the interim order idea? January alone date.
January 23rd,
Serial number 37, my lord.
Just a moment, please.
page number 14, serial number 36 to 42.
36, my lord.
Yes.
I appear for the respondent number 3, my lord. My senior is not feeling well, my lord. Weeks time.
ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
Inform ಮಾಡ್ತೀನಿ sir.
ಮಾಡ್ತೀವಿ ಬೇಡ. ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ.
Page number 15,
My lord,
Serial number
serial number 37, my lord.
Yes, Mr. Rao?
But I had little fever in the night. I could not come to the court.
Have all the respondents been informed?
Not only Indian Statistical Institute, I'll call up and tell him.
No, ask one of your colleagues to be present. We are not adjourning now.
page number 15, serial number 43 to 45. Page number 16,
Serial number 45.
Hmm.
Next week, Lord,
ಯಾಕೆ?
for the petitioner. Mr. Sabrat appears in this matter, Lord. He has some inconvenience. Next week, Lord.
Have we informed the respondents?
Yes, Lord.
45 at the request of counsel for the petitioner relist on 6th. It's made clear that no further adjournment will be granted considering the matter is of the year 2016. If
Seven.
arguments are not
Seven.
advanced on that date, petition will be liable to be dismissed or not.
7th or 9th?
7th, ನೀವೇ ಬರ್ಬೇಕು.
Allah, sorry, 9th.
9th is a education day, 6th only. Yes.
page number 16, serial number 46 to 51. Page number 17, serial number 52 to 55.
Swami.
In serial number 52, there's one more connected matter which has not been posted. 1242 of 17.
The next
1242
matter
of
is
17.
1242 of 17 and relist on 6th.
Much obliged.
ಹಿರಿಯೂರು ಯಾರಮ್ಮ?
I appear for the Commissioner review.
You will accept for R4 and R5 also, Mr.
Yes,
Mahesh?
yes, my lord.
Yes, Mahesh,
Yeah,
will
one
enter
and
appearance
this
for respond number 3, accepts notice for respond number 4 and 5 also. Registry is directed to print his name as such. Yes,
Much obliged.
48.
48.
Yes.
ಏನಮ್ಮ?
ಇಲ್ಲ ನಂಗೆ ಲೈಟ್ ಆಗಿ ಪ್ಯಾರಾಲಿಸಿಸ್ ಆಗಿದೆ, ಅಡ್ಮಿಟ್ ಆಗಕ್ಕೆ ಹೇಳಿದ್ರು. ಸೊ ನಂಗೆ ಅಡ್ಮಿಟ್ ಆಗಕ್ಕೆ ಹೇಳಿದ್ರು. 6th ಇಂದ ನಾನು ಸಫರ್ ಪಡ್ತಾ ಇದ್ದೀನಿ. ಸೊ ನನಗೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾಗಿತ್ತು.
ಅಡ್ಮಿಟ್ ಅಂದ್ರೆ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗ್ಬೇಕು.
ಇದು ಪ್ಯಾರಾಲಿಸಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀನಿ.
And AGA accepts notice for respond number 4. Also, registry is direct print his name as such.
And
The petitioner party in person submits that she is unwell. ಯಾವಾಗ ಬೇಕು?
ಸ್ವಾಮಿ ಬರ್ದಿದ್ದಾರೆ ಅಡ್ಮಿಟ್ ಆಗಿ.
ಜಾನ್ವರಿನಾ ಫೆಬ್ರವರಿನಾ?
ಫೆಬ್ರವರಿ ಕೊಟ್ಬಿಡಿ, ಯಾಕಂದ್ರೆ MRI ಎಲ್ಲ ಬರ್ದಿದ್ದಾರೆ.
ಫೆಬ್ರವರಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಸ್ವಾಮಿ.
Interim order ಇದೆಯಾ?
ಇದೆ.
February.
19th February.
Interim order earlier granted is extended till next date.
ಥ್ಯಾಂಕ್ ಯು.
Page number 18, serial number 56.
ನಿಮ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಯಾರಿಗಾರು ಹೇಳಿ ಅಂತ ಹೇಳಿದೀವಿ, ನೀವು ಆಗಲ್ಲ ನಿಮ್ ಬರಕ್ಕೆ.
6th ಇಂದ ಸಫರ್ ಪಡ್ತಾ ಇದೀನಿ, ಇದಕ್ಕೋಸ್ಕರ ಅಡ್ಮಿಟ್ ಆಗ್ಲಿಲ್ಲ ನಾನು.
ನಿಮ್ಗೆ ಆಗಲ್ಲ ಬರಕ್. ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಒಂದು ಲಾಯರ್ಗೆ ಹೇಳಿ, ಯಾಕೆ ಕಷ್ಟ ಪಡ್ತೀರಾ? 3ನೇ ಸತಿ ನಿಮ್ಗೆ ಇದು ಕಷ್ಟ ಆಗಿರೋದು ಯಾಕೆ ನೋಡಿ. Hmm. 59. You for respond number 5. You are Aditya Singh, SR Dodward. 59 at the request of counsel for respond number 5 released on 13th December.
65.
Page number
55.
65.
65 ಇನ್ನ ಕರೆದಿಲ್ಲ.
Page number 19, serial number 61. Page number 20, serial number 62 to 66.
Yes, 65.
I am for the respondent. For the petitioner. 2 weeks time.
ಏನಕ್ಕೆ?
Paper ಸಿಕ್ಕಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ objection.
ನೀವು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ ಮಿಸ್ಟರ್ ಚಂದ್ರಶೇಖರ್?
ನೋಡಿ ನನಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ ಪೇಪರ್, ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್.
ಏನ್ ಪೇಪರ್ಸ್ ಬೇಕು?
ರಿಕ್ವೆಸ್ಟ್
Petition papers ಬೇಕಾ?
ಅದಕ್ಕೆ ಹೇಳಿದೆ ಕೊಡ್ತೇನೆ.
Counsel for the petitioner undertakes to furnish one more set of the petition along with annexures on the counsel for respond by end of day 2nd December. Counsel for the respondent seeks for and is granted 2 weeks time thereafter to obtain instruction, make a submission. Released on 18th December. Interim order earlier granted is extended till next date.
Page number 21, serial number 67 to 73.
70. Inform ಮಾಡಿದೀರಾ? ಅದೇ. So all dates, all matters date will be fixed as long as you have no objection. At the request of counsel for respond number 1 to 6 released on 13th December.
Page number 22, serial number 74 to 79.
Serial number 76, madam, for the petitioner, intimate to respond counsel also, madam. I will turn after 2 weeks, madam. So, senior citizen. I already
ಏನಕ್ಕೆ?
intimate the respond also, madam.
ಏನಕ್ಕೆ? What is the reason?
I'm inconvenienced today, madam. So,
The request of
matter
counsel
is
for the petitioner released on 13th December.
Page number 23, serial number 80 and 81. List number 3.
ಏನಂತ ಹೇಳಿದಾರಮ್ಮ?
ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಮೇಲೆ
ಅಲ್ಲ ಏನಂತ ಹೇಳಿದ್ದಾರೆ? ಯಾವತ್ತು list ಮಾಡಿ? Thursday. All these matters will be repeated on Thursday.
ಬಲಾಡ್ ಅದರ ಸಮ್ RSA ಮ್ಯಾಟ್ರು ಇದೆ ಇದರಲ್ಲಿ, ಅದರಿಂದ
ಎಲ್ಲ
ಐ ವಿಲ್ ರೀಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
full list number 3 will be repeated on Thursday. 15. ನೀವ್ಯಾರಿಗೆ? 15. ಇಲ್ಲ, they are all part of the same matters. We can't segregate.
ಅಲ್ಲ ಕಿಂಗ್ ಫಿಶರ್ ಸೇಮ್
It will be on the same date.
Number
Late
27, my lord.
27.
27, my lord. I am for the respondent, my lord. Thursday, my lord, senior father,
Ceremony, my lord, can you issue 24 hours after that, my lord?
You're for the respondent.
Yes, my lord. On 9th or 10th, my lord.
Petitioner,
Mr. Deepak, my lord, I will inform.
Shrikant Patil antide.
Shrikant Patil, please. Deepak has appeared.
27 at the request of counsel for the respondent.
So,
Yavattu company petitions yavattu antare? Thursday. So Thursday would be 5th,
fifth, array.
12th, 12th,
12th, please.
27 or 12th.
Serial number 24, Madam.
Yes.
It has to be posted for admission. 2 days back, it was posted for payment of deficit of court fee.
Ah.
I had paid the court fee. Now, next step is for admission. It has come up for orders. 24. I am for the appellate.
Interlocutory application ಇದೆ ಅದಕ್ಕೆ.
It has to
Pay
be,
and directions ಇದಾವಲ್ಲ. That is why it's come up. Stay bedwa.
it has posted for admission first, my lord, along with the IS.
Consider both of it together. Thursday it will get repeated. You're for? Who is for the petitioner? ನೀವ್ ಹೇಳಿದ್ರೆ ಪ್ರಯೋಜನ ಇಲ್ಲ. Petitioner ಹೇಳ್ಬೇಕು. Twenty-eight, counsel for the respondent. Submit that settlement talks are in progress. Given 2 weeks' time, settlement would be reported. If settlement is not reported by 12th December, is directed to. Yes, if you are not serious about settlement, then don't make your submission. Are you going to report or no? There's a company petition. We won't give you time on that. You owe money 2013 matter. Then we won't adjourn it. Repeat on Thursday.
Bit number 1. Order serial number 1. Muralidhar C.
For petitioner, my lords, all objections are complied, my lords, except one particular document. I have
So on
applied for a
15 ಇನ್ನ
certified.
compliance ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀರೇನ್ರಿ?
No, my lords, we had filed for restoration. It was earlier dismissed for non-prosecution. I've also filed for condonation of delay, my lords. Those two applications may kindly be considered. In the meantime, I'll furnish certified copy of that particular document, my lords.
ಏನಾಗಿದೆಯಮ್ಮ ಇದರಲ್ಲಿ?
One page of the lease cum seal agreement.
Incomplete copy of the sale deed
Yes, my lords.
are not forthcoming. You have to rectify it.
Yes, my lords. We have applied for certified copy of that particular registered document, my lords. In a week's time, we shall furnish. In the meantime, if the applications
What
may.
is this matter about?
My lords, because of change in use of purpose of land, additional sum of rupees 2 crore was recovered from the petitioner, my lords, which is sought to be recovered. The allotment and the building plan approvals were for putting up a hotel and restaurant. Later, subsequently, once the occupancy certificate is issued at the
You
time
don't
of
want
sale
the
date,
property anymore.
we are in possession of the property, my lords, but it was paid under protest.
You
The
can't
petition
have
is-
the property if it is not converted.
My lords, the allotment,
Return back the property, we'll return back the entire amount.
lords, huge sums are invested and construction is put up with due approval
You
from
put
the.
it up without a change of land use.
My lords, it was.
You did not take any permission.
No, my lords, it's a electronic city plot, my lords. It was meant for the purpose of putting up a commercial complex.
According to you, you have used the property as a commercial complex and you're using it from that time.
Yes,
And now you
please.
want the refund of the money because the change of land use has not been done, which was the basis for you to put up the construction.
No, my lords, if I may submit, my lords, the purpose for which the property was allotted to me was putting up, was for the purpose of putting up commercial complex, and I have put up commercial complex. But that particular commercial complex is being utilized for hotel and restaurant. And the request to that extent was made as part of the allotment process itself.
You are using it,
Yes, my lords, I am using it, my lords.
Then
When the
there's no
demand
refund.
was made,
there's no refund.
my lords, when the demand was
You
made, I
want to
paid it
surrender
under
the
protest.
property, we'll get the entire amount refunded to you.
My lords, if the petition may kindly be restored, my lords, I'll seek instructions and I'll make submission.
Not for this prayer. Once you say that you are using the property, why should they refund any money to you?
My lords, it was
You want it virtually free
not, my lords. I have paid almost 20 lakhs, my lords, in the year 2004.
and you
But
want
when it
2
comes
crores to be
2015,
returned. That is why we are saying free.
No, my lords, at that
You
time,
want
it
only for 20 lakhs, you want this plot of how many acres?
was, 0.5 acres, my lords.
Not
My lords,
possible,
I've
Mr.
produced
Counsel.
my application which I had filed and also the demand which was made.
We'll
The demand also
restore and
makes a
dismiss on the next date. You comply with it. 1 week's time is finally granted to the counsel for the petitioner to comply with the office objection. Relist on 12th December. This prayer won't be sustainable. Only for your recalling, for your benefit that it is recalled and dismissed.
Serial number 2, Prakash D. Hebbar.
During course of the day only I'll carry it. During course of.
Pass over.
Serial number 3, P.S. Kumar.
Kodi. ಅದಕ್ಕ an affidavit of the Deputy General Manager KSIDC has been filed stating that Wakalatnama on behalf of respondent number 2 and 3 could not be filed since there is no post of the Deputy General Manager as indicated in the cost list, cost title. And that the said industrial estates are headed by Assistant General Manager. If that be so, it was required for the respondent to have brought it to the notice of the court when the Wakalatnama was filed and not continued the matter without appearance. The respondents are put on notice to henceforth file Wakalatnama for all the officers who are shown of the same corporation. Yes. Petitioner.
Even the interim order was also vacated. This is covered by judgment. Tentative price.
Covered now madakagala bari dismiss. Despite the order dated 14/11/2024, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Serial number 4, T.P. Vivekananda.
Sir, there are certain office objections on the reply filed by the respondent.
4. Yes, madam, you don't want to sign your objections. Your instructing counsel doesn't want to sign. We can't hear you. We still can't hear you. Pass over, sign mad.
Serial
Can
number
it be
5.
taken up on some other time? Let's,
Let them comply with 2015 matter.
My
Let
lords,
us
in
see
a
what
week's
matters for
time,
them.
if my lords can hear
Not a
me,
week's time, madam, let it be signed today.
party, I believe they are not able to contact him, some difficulty. Give us 2 days' time at least, my lords, 2 days' time.
It's to be signed by the council, madam.
Even an affidavit was one more requirement. That was, the council is there,
Affidavit
that
date.
he will do it today itself. Council is already in court.
Affidavit to be filed by either.
Yes,
Counsel for the petitioner, respondent, number 1 seeks for and is finally granted a week's time.
grateful,
Comply
grateful.
with the office objection. If the same is not complied with by 12th, the statement of objection will be struck off and the matter proceeded with.
Grateful, my lords.
Relist on 12th.
Serial number 5.
My lord, I appeared for the respondent, my lord, in all these matters.
Petitioner
For
in
the-
5.4.
in 5.4, my lord,
Yes.
there is a proposal, my lord, for settlement by the petitioner. The rest of the matters, my lord, there is no,
Apartments, Allah.
how the apartment purchase.
The other petitioners are not
Not
appearing,
come,
so
Lord.
we'll dismiss those.
Yes,
Only surviving will be 5.4.
we will, my lord, we have, his proposal has been sent, my lord, to the MD, my lord, for approval. As soon, my lord, we receive it, my lord, we will communicate to him.
Can
Despite the order dated so and so, none has been appearing for the petitioner. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Either 5, 5.1, 5.2, 5.3. Separate orders. Daily orderly, dealing 5.4. Learned counsel for respondent number 1 submits that the proposal submitted by the petitioner has been forwarded to the managing director for approval, given 2 weeks' time. The
1
outcome,
week, 2 weeks, your lord.
outcome would be reported. Relist on 12th December. Please.
Interim order may kindly be.
Interim order earlier granted is extended till next date of hearing.
Great.
ಇದು 5, 6 and 8 ಏನಪ್ಪ ಆಯ್ತು? ಬೇಕಾಗಿಲ್ಲ ಅವ್ರು ಅಪ್ರೂವ್ ಮಾಡಿದ್ರೆ.
Yes, my lords, it's there.
Dismiss ಮಾಡಿದ್ರಲ್ಲ.
Great.
Remaining matter, your lordship. Remaining matters, your lordship.
Dismissed.
Dismissed.
ಯಾರು ಬರ್ತಾ ಇಲ್ವಲ್ಲ?
They had an interim order, not that interim order stands vacated.
ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಇನ್ನೇನು ಮಿಸ್ಟರ್ ಮಲ್ಲಿಪಾಟ್?
Great.
ಡಾಕ್ಟ್ರಿ ನಮ್ಮ ಮರ್ಜರ್.
ಹಿಂದ್ಗಡೆ ನಮ್ಮ ಕಲೀಗ್ಸ್ ಹೇಳ್ತಾರೆ ವಿಕೆಟಿಂಗ್ ಮಾಡಿಸಿ
ಅವ್ರು ಹೇಳ್ತಾರೆ, ನೀವ್ ಯಾಕೆ ಹೇಳ್ತೀರಾ?
Serial number 6.
6 may be dismissed, not as withdrawn, my lord.
Petitioner is before this court seeking for the following reliefs. A memo dated 28/11/2024 has been filed, signed by the counsel for the petitioner accepting the memo and submission.
Yes, sir.
Petition is dismissed as withdrawn.
Serial number 7. Swati Ashok.
Respondent 1, my lord.
I appear for petitioner, your lordship.
Yes.
Your lordship, I have taken steps with respect to respondent number 3, 7 and 11, 11 and 12. For 7, 11, 12, they are not necessary parties. They were in the suit, so they were made party here. As of, they were some social workers.
Now, have you taken steps or you want to dispense?
Filed
Want
memo
to
for
delete them?
delete, memo for deletion I have filed.
Memo for deletion is 23/11. Memo dated 23/11/24 has been filed by the counsel for the petitioner. Seeking for deletion of respondent number 7, 11 and 12 from the array of parties, accepting the said memo and submission of counsel for the petitioner. Respondent number 7, 11 and 12 are deleted from the array of parties. What is this about respondent number 1 you said?
Respondent number
I
3.
appear for respondent number 1.
Yarella.
for
What
res-
about 4, 3, 4, 5?
4 and 5, we have taken steps, your lordship. For 3, the government has accepted notice.
Yes. Three is the deputy commissioner. And AGA accepts notice for respondent number 3. Registry is directed to print his name as such. Counsel for the petitioner submit that she has made payment of necessary process fee. And furnished copies in respect of unserved respondent number 4 and 5. Registry to verify if needful has been done, issue notice to respondent number 4 and 5, returnable by January end
30th January.
In the meanwhile, office objections to be complied with. If not complied with by next date of hearing, the petition will be liable to be dismissed for non-prosecution.
Interim order to be
Interim order earlier granted is extended.
obliged.
Interior madam status quo, my lord.
ಏನಿದೆಯೋ ಅದು
ಏನಂತ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ.
ಏನ್ ಕೊಟ್ಟಿರ ಇವಾಗ ಅದನ್ನ ನೋಡಕ್ಕಾಗಲ್ಲ.
Obliged. Your Lord.
Serial number 8. Kumar A.
Appearing for petitioner, my lord. My lord, we have furnished the copies and made the payment, my lord.
3-1 and 3-2 to 5.
Yes, ma'am.
Counsel for the petitioner submit that process fee has been paid.
On 25th July, it will be furnished.
25th July.
The return
ma'am.
with the insufficient address.
ಅದು ರಿಟರ್ನ್ ಆಗಿದೆ. ಇನ್ನ ಒಂದ್ಸತಿ ಕೊಡಬೇಕು.
Will do it.
The petitioner, learned counsel for the petitioner submit that given a week's time, she would make payment of necessary process fee and furnish copies in respect of the unserved respondent. If needful is done, registry is directed to issue notice, return out by February on date,
February 15th.
15th
obliged.
February.
For the respondent in this case.
For regarding the flats, my lord, which on the last date, my learned friend said he'll take instructions where my flat was attached.
Filing the memo, my lord, the entire surface action has been withdrawn by the bank in the year 2020 itself.
My lord, prayer,
Third a copy.
Yes,
I
yes.
already given copy, my lord.
What survives?
my lord, prayer B will, prayer C, my lord, where the order of the magistrate, my lord, will have to be set aside.
The
That
consequential
order
effect.
still remains.
That is 14 order. is it?
Yes,
Yes, my lord.
So you withdrawn the surface.
Entire
then
surface
14 will
action.
also go.
Yes, my lord.
Yes.
Petitioner is before this court seeking for the following reliefs. The respondent number 1 has filed a memo dated 28/11/2024, which reads as under. The submission of learned counsel for respondent is that the surface action against the borrowers has been withdrawn on 20/2/2020. And as such, the respondent bank does not wish to proceed as regards the property under the Surface Act. If that be so, then the orders which have been passed in pursuance of the action taken under the Surface Act by respondent number 1 bank would stand as a nullity. In that view of the matter, I pass the following order. Writ petition is partly allowed. A certiorari is issued. So and so at Annexure B is quashed. So and so at Annexure C is quashed.
Grateful.
Serial number 10.
Pending is
Appearing on behalf of the petitioners, Your Lordship, I seek a week's time for compliance with the office objections, Your Lordship. And
who is R11?
I appear for R10, my lord, bank. In this case, what happened, my lord? They are due to the bank more than 1 crore 20 lakhs. And that bank filed an OA before the debt recovery tribunal. OA has been decreed. Then the recovery officer has issued the demand notice. When the demand notice was issued, then petitioner filed the written petition. No. This property is subject to partition and all these things. And this honorable court has granted interim stay.
interim order has been granted.
This matter has to be
Heard.
argued, my lord.
A week's time, Your Lordship.
Because this
Respondent number 11 being the debt
matters
recovery officer, 11 is dispensed with.
Lords, if I may
Yes.
comment. Lords, I appear for R6. Notice I'm told is dispensed with. I have been given instructions.
2/9 is dispensed with.
Yes, late last evening, I've just received instructions. If my lord may have it anytime after a week or so, I'll file my wakalat. My lords, the petitioner may kindly be directed to serve a copy of the papers.
Who are 1 to 9?
Lords, I am instructed in so far as respondent number 6.
Who are you?
It's not, I am yet to see.
You don't know
Lords,
anything.
no. Late last evening, I've been instructed. Lords, therefore-
Yeah, Mr. Muthurna, you're 1 to 9. No? You know, madam, who are 1 to 9?
1 to 9 are in the partition, Your Lordship, as far as I
Then
read.
how
Even
can
I am.
notice be
a
dispensed with against them?
Your Lordship.
6 GR Manjunatha.
They'll have to be heard unless they are colluding with you.
My lord, this matter is pending for last about 10 years, 15 years.
Unless they are colluding with them.
I'm a proxy
Exactly
counsel.
happened, my lord. It is only collusion. Because it is not only in all cases what my lord secure creditor, those people will collude.
So
And
you
that's why
notice
this matter will
ಕೊಡ್ಬೇಕಾ?
drag on for years.
Notice ಕೊಡ್ಬೇಕಾ? ಈ dispensed with stage ಅಲ್ಲಿ ನೀವು argument ಮಾಡ್ತೀರಾ?
ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ.
ನೀವು ಮಾಡ್ತೀರಾ?
A week's time, maybe,
I
Your Lordship.
don't know. I have not even received the petition papers.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಫೈಲ್ ಮಾಡಬೇಕು. ಅದಕ್ಕೋಸ್ಕರನೇ.
Persona non grata. Counsel for the petitioner.
At least let me.
You file it.
No, petition papers may kindly be directed to be served.
That counsel for the petitioner seeks for and is granted. So this is already heard, either.
Heard, my lord.
Heard and
because
then
heard
interim
and-
order was granted, Your
Heard
Lordship.
and then ultimately the order was not passed for inconvenience of the honorable court. Then this again rehearing of the matter, my lord.
This ಎಲ್ಲ ಆಗೋಗಿದೆ. That counsel for the petitioner seeks for and is granted a week's time to comply with the office objection. Relist on, if same is not done by next date of hearing, petitioner would be liable to dismiss for non-prosecution. Relist on 12th.
Much obliged.
Dismissal ಆಗತ್ತೆ. Copy.
Sorry.
Serial number 11.
For the petitioner, this.
Yes.
For the
Interim order earlier granted. 11.
Not for the petitioner, this matter, my lord, Parliament. An early hearing application, which today is, because the matter is listed, but the matter is, but the matter is a very narrow compass. They filed objections, pleadings are complete. It's the only question was insofar as membership to an insolvency professional agency is concerned. The only disability that they contended that I had was that there were disciplinary proceedings against me before the ICAI, and therefore they could not consider my membership application as an insolvency professional. Those disciplinary proceedings have now been closed. So nothing remains now against me.
So you make a fresh application, it's been rejected.
My lord, the insolvency regulations mandate that my application should have been made within 12 months of having completed an examination. I had completed that examination, made the application. They reject my application on this ground. Now, today I'll have to again do the whole, complete the whole procedure, whereas my appeal itself, I have challenged my lord may kindly look at
for the petitioner submit that the disciplinary proceedings which had been initiated against the petitioner have ended in?
Closure, my lord. I have filed the order.
Where is it?
On 20/11/2024 by way of a memo.
Where is the order?
Lord, I have filed a memo, my lord,
Where
along
is the
with
operative portion of the
operative portion of the order at page number 38 of the memo of the. May I read, my lord, this? Page 38, paragraph 7. Thus, in conclusion, in the considered opinion of the committee, the respondent firm so-and-so with members answerable so-and-so, my lord, C.A. Ravindra, he is the
not
petitioner,
guilty.
are not guilty of professional misconduct, falling within the meaning of so-and-so.
Have ended in dismissal. And as such, he submits that the reason for rejection made by the reason for rejection of the membership of the petitioner as provided by respondent number 1 no longer survives for consideration, and as such, the application filed could be considered. Learned counsel for respondent seeks bond is granted a week's time to obtain instruction and make his submission. Released on 6th December.
Much obliged. Grateful.
Serial number 12.
No, the
13%.
early hearing application. Otherwise,
Come in that stage, it will get allowed.
great.
I appear for my lords, respondent 13 and 14. My lords, I was directed to file objections. I have served it today, my lords.
Today.
It's ready, my
Oh,
lord.
ಈ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Okay, party in person now. ಸಿಗಲ್ಲ.
ಸ್ವಾಮಿ ಮೆಮೊ ಹಾಕೋತಾ ಇದ್ದೀನಿ.
ಏನ್ ಮೆಮೊ ಹಾಕ್ತೀರಪ್ಪ ನೀವು?
ಯಾ-
ಎವ್ರಿ ಟೈಮ್ ಒಂದ್ ಮೂರ್ ಮೆಮೊ
ಸ್ವಾಮಿ,
ಹಾಕ್ತೀರಾ ನೀವು?
25ನೇ ತಾರೀಕು ಅಟ್ಯಾಕ್ ಮಾಡಿದ್ರು. ಕನ್ಸರ್ನ್ ಇವ್ರೆ ಎಲ್ಲ ಕೆಪಿಟಿಸಲ್
ನೋಡಿ ಏನ್ ಮೆಮೊ ಕೊಡ್ತೀರಾ ಕೊಡಿ.
ಬಸ್ನಲ್ಲಿ ಅಟ್ಯಾಕ್ ಮಾಡಿದ್ದಾರೆ. ಬಸ್ನಲ್ಲಿ ಅಟ್ಯಾಕ್ ಮಾಡಿದ್ದಾರೆ. ಪಬ್ಲಿಕ್ ಎಲ್ಲ ನೋಡಿದ್ದಾರೆ. ಫುಲ್ ಎಳ್ದಾಟ. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಎದುರು ಜವರ್ಗಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಎದುರುಗಡೆ ಅದನ್ನ ಹೇಳ್ಕೊಂಡ್ ಬಂದ್ರು. ಆಮೇಲೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕೊಟ್ಟಿದ್ದೀನಿ.
ಏನ್ ಹೇಳ್ತೀರಾ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಬೇಕು, ನಮ್ಗಂತೂ ಅರ್ಥ ಆಗಲ್ಲ ನೀವು ಹೇಳಿ.
ಸ್ವಾಮಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್
ಅದೆಲ್ಲ ಏನಕ್ ಬೇಕು?
ತುಂಬಾ
ಇರೋದು ನಿಮ್ಗೆ ಸೇಮ್ ಇದು ಅದೇ ಮೆಮೋನ ಉಲ್ಟಾ ಪುಲ್ಟಾ ಮಾಡಿ ಮತ್ತೆ ಆಗ್ತಾನೆ
ಇಲ್ಲ
ಇರೋದು.
ಸ್ವಾಮಿ, ಇಲ್ಲ ಆತರ ಏನಿಲ್ಲ. ಏನ್ ನಡೀತಾ ಇದೆ, ಏನ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಆಗ್ತಾ ಇದೆ ಅದಕ್ಕೆ ಮಾತ್ರ ಇಂಪಾರ್ಟೆಂಟ್ ಇದ್ರೆ ಕೊಡ್ತೀನಿ. ಇಲ್ಲದೆ ಇದೆ ಅನ್ನೆಸರಿ ನಾನು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಕ್ ಹೋಗೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Learned counsel, the petitioner party in person has filed 2 memos.
3 ಮೆಮೊಸ್.
3 memos. ಇನ್ನೊಂದಿದೆಯಾ? 3 memos. The same are taken on record. Learned counsel for respondent number 13 and 14.
Yes.
Has filed a statement of file it in the registry.
Yes, my lord.
Submit that statement of objection will be filed during the course of the day. Copy thereof has been served.
Yes.
On the party in person. ನೋಡಿದೀರಾ? ನೋಡ್ಬೇಕಾ? ಎಷ್ಟು ದಿನ ಬೇಕು?
ಇನ್ನ ನೋಡಿಲ್ಲ ಸ್ವಾಮಿ. ಆಯ್ತು, ತಾವ್ ಏನ್ ಟೈಮ್ ಕೊಡ್ತೀರಾ ಆ ಡೇಟ್ ಒಳಗಡೆ ನಾವು ಮತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರೀ ಆರ್ಗ್ಯುಮೆಂಟ್, ಈ ಮೆಮೋಗಳೆಲ್ಲ ಬೇಡ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
ಯಾವತ್ತು?
ತಾವ್ ಯಾವಾಗ ಹೇಳ್ತೀರಿ ನಾ ಅವಾಗ.
Party in person seeks for and is granted 2 weeks time to go through the same and make a submission. Released on 12th December.
Great.
Thanks.
13. Kavita D.
My lord, in this case,
For the respondent.
my lord, only the concern about interest portion, my lord, they have charged 15.5%. If they have ready.
ನೀವು OTS ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lord.
71,25,795 ಇದೆ.
I'm
commercial
I'm
loan,
ready to deposit, my lord. That
ಎಷ್ಟು?
earlier OTS it was there. 41 lakhs earlier OTS I have to
ಅದ್ರ
deposit.
ಮೇಲೆ ನೀವು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರಿ.
Interest ಕೊಡ್ತೀನಿ
ಅದು
ಸ್ವಾಮಿ.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ
ಅವರು
71 lakhs.
29 lakhs interest ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಏನಾದ್ರೂ ನೆಗೋಷಿಯೇಷನ್ ಮಾಡಿದ್ರೆ ಟುಡೇ ಇಟ್ ಸೆಲ್ಫ್ ಐ ಆಮ್ ರೆಡಿ ಟು ಡೆಪಾಸಿಟ್ ದಟ್ 42 lakhs ರಿಮೈನಿಂಗ್. ಇಂಟ್ರೆಸ್ಟ್ ಪೋರ್ಷನ್ ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ
42 lakhs ತಗೊಳ್ಳಿ ಇವಾಗ.
ಅಲ್ಲ, 2 crores 93 lakhs is the dues as on date.
42 ಬರ್ತಾ ಇದೆ.
ಅಲ್ಲ, 42 was given to them. 90 was given to them. They paid part of it. 42 is what is left. After calculation of interest, it is a commercial loan, please, my lord.
ಇವಾಗ 2 crores ಎಲ್ಲ ಆಗೋಯ್ತು. 71 is what you are making. Let's not shift the clock back. So 71 ಅಲ್ಲಿ they are giving 42. 29 ಇದೆ. 29 ಅಲ್ಲಿ ಇನ್ನ ನೆಗೋಸಿಯೇಷನ್ ಆಗತ್ತಾ?
ಇಲ್ಲ
ಆಗಲ್ಲ.
71 ಗೆ they're not ready.
ಸ್ವಾಮಿ
Submission ಮಾಡಿದೀರಾ?
ಅಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಕೊಡಿ ಅಂದ್ರೆ ಕೊಟ್ಟಿದೀವಿ ನಾವು. ಬಟ್ ಈ ಬ್ಯಾಂಕ್
What amount is the bank ready to settle?
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಅವರು they will have to make a proposal that will be considered by the bank, please.
Last time there was, the submission was there, there were.
Due
accepted.
amount as on 21/11/24 is 71,25,795.
Yes,
So your lordship directed me to file two statements, one regarding the actual balance due and one in accordance with the OTS with interest. I have filed the statements, please, my lord. But for revival of OTS, bank is not accepting for the simple reason that there are several similarly placed borrowers.
If, my lord, if any order from the court, then they'll accept, my lord, when I'm ready,
If
my.
you are negotiating on 71,
No, my
you
lord,
can't pass any.
if time is granted, I'll ready.
No
Today
time
itself,
can be
no, my lord, that 42 lakhs today itself, but if passed over the matter, within 2 hours, I'll deposit and I'll
42
come.
ಅಲ್ಲಮ್ಮ 71 ಹೇಳಿ.
Remaining interest portion, I have to arrange, my lord. Some
ಯಾವಾಗ
time is
arrange
granted,
ಯಾವಾಗ ಅರೇಂಜ್ ಮಾಡ್ತೀರಾ?
2 months' time is. Because 30, 20 to 29 lakhs is there.
The
my lord.
second time you are coming before this court, earlier you are defaulted. We can't give you that time. The bank cannot be expected to do that.
1 minute, my lord. My lord, 4 weeks finally, 4 weeks, my lord, to deposit that 29 lakhs, 42 lakhs today itself will deposit.
Maximum we can do is 3 weeks for you. So that we can persuade Mr. Tulsi Kumar to do it within this roster. Otherwise,
Please, my lord.
But ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ we'll, ನಿಮ್
Entire
42
OTS
lakhs
will-
ಹೋಯ್ತು.
Yes, my lord. I know.
Please
that.
remember that.
Yeah, sure, my.
Let it be an order of the court, please, my lord.
Let that 42 come. Learned counsel for the petitioner submitted an amount of rupees 42,
Today itself, my lord.
round figure,
Yes, my lord.
42, comma 00, comma 000 will be deposited with the bank by end of the day today. And insofar as the balance amount is concerned, the same would be paid by 18th December. Released on 18th December.
Please.
Serial number 14.
My lord, interim order may be extended.
Interim order earlier granted. Joseph?
Please, my lord.
This 25% has been paid?
No, my lord. Yes, partially complied the order of this honorable court. 50 lakhs was the amount that was directed to
10
the
lakh,
deposit.
your lordship will kindly see annexure. Page 47.
You filed your statement of objections.
Statement of
filed.
objection has been filed.
Ready? Kindly see, Beda, if you are not complied, argue the matter. You also know the general result.
Yes. Before making my submission on merits, my lords.
Yes.
According to the statement of objection, the sum and substance of the statement of objection is that first is that writ petition is not maintainable in view of section 17 of the Surface Act.
Yes.
My lords, whereas in this case, my lords, before going to merits, my lords, the prayers that I've sought are outside the jurisdiction of the learned DRT. And my first prayer, part of it is covered by your lordship's judgment in Velang and Information Technologies. The second, my lords, is the second contention that has been raised in the statement of objection.
That has been watered down by the division bench.
Pardon, my lords?
That has been watered down in the division bench.
Only two out of several directions, my lords, in the division bench.
How you
were
come
directed.
under that?
Your lordship are directed the state to supervise the
Yes.
implementation of the COVID relief pack, extending COVID relief pack. That was set aside by the division bench. The second contention that has been urged by the respondent is that the petitioner's accounts have been classified as NPA way back in 2018, therefore not entitled to COVID relief package. Now, this submission is contrary to their own documents. Now, your lordship will kindly see, my lords, the prayers that have
yes.
in Your Lordship will kindly take up the companion writ petition, my lords. 7657.
What do you want us to take?
7657. Your Lordship will kindly take up 7657. It's a settled portion of law that when the questions of law arise for determination, I cannot be relegated to alternate remedy of appeal.
Yes.
Now, the questions of law that falls for determination is whether secured creditors' right to securitization crystallizes under section 21J or 21O of the Surface Act. The second is, if the securitization is held to be only under section 21O, definitely it is so, then proviso 5 to section 14 of Surface Act is liable to be declared as invalid. Third is, before classifying an account as NPA, whether the principle of adi alteram partem is excluded. On that point, my lords, only the division bench of the Punjab Haryana High Court has given an order judgment.
The bank has to hear the borrower before declaring anything.
Before declaring, because it's an order that is passed, it is settled. They create a dispute. Therefore, the Punjab Haryana High Court division bench, following the judgment of the Jharkhand High Court, has held that before classifying the account as NPA, the parties must be given a minimum hearing, at least a show cause notice.
Surface Act. Yes.
Now, whether the fourth question is whether COVID-19 relief package directed by RBI to be extended to all by all commercial banks is discretionary or exempting the respondent bank from extending the. Now, my lords will kindly say my prayers, my lords. The first incorrect statement that has been made by the respondent bank in the statement of objection at para.
Objection filed in which matter?
At page, statement of objections filed by the.
In which matter?
Page 5, my lords, first paragraph.
Is it 765?
No, they have filed a common statement of objection.
Page?
Page 5, my lords, para 1.
5 is the verifying affidavit.
Statement of objection.
Is the verifying affidavit.
Para 7, my lords, page 5.
Is the verifying affidavit, Mr.
It's mentioned at the bottom. Page number is mentioned at the bottom.
ಯಾವ್ದು ಹಾಕಿದ್ದೀರಾ?
But it was filed on your Lordship 22/11/2024.
22/11/24.
They say.
My respond number 2 and 3.
Please.
5 is the verifying affidavit as per what we have.
This is the one that has
But it
been
should be
given.
page number 2, madam. Page number 2.
No, you are given different page.
Paragraph 7.
Para 7, my lords.
Is page 2.
They say that has been classified as non-performing asset on 30th June 2018.
ಎರಡು objection ಹಾಕಿದ್ರೇನಪ್ಪ?
I not have filed one common objections. Because so far as second.
Para 7 is reading a petitioner cannot claim the benefit of COVID-19.
Yes.
He's reading something else. Page numbers are not matching. Paras are not matching. What are you, from where are you reading?
Whatever copy that they have given.
Same thing I have given. But it's not. There's no change. Same thing. Paragraph 7.
Paragraph 7.
It's reading something else.
Start the petitioner cannot claim the benefit of COVID-19 package.
In the middle of the
Then you'll have to say.
after R1.
Start from the middle like that.
They say that classified as non-performing assets.
Where are you reading from? You'll have to tell us. Para 7.
page number 3, my lords.
Yes.
And the court file, page number 3.
Hmm.
First line.
Yes.
Has been classified as non-performing asset on 30th June 2018.
Yes.
Now, if your lordship will kindly see, come to page 156. 156. This is an application filed under section 14 of Surface Act before the London Magistrates Court. Now, at page 2, internal page 2, para 5. Now, classified as NPA on 20th January 2021. This is the correct position, because if your lordship will kindly see para 5 of the writ petition, in 2019, if it has been classified as non-performing asset on 30th June 2018, they would not have given me additional loan of 30 lakhs in 2019, within 6 months.
Yes.
They are silent about it. The statement of objection is silent about the sanction of the loan in 2019. Therefore, the statement that it was classified on 30th June 2018 is incorrect. If your lordship will kindly see, my lords. Annexure E at page 58.
Annexure E at page?
Page 58.
58.
This is addressed to not only to the banks, but also to the primary urban cooperative bank. In this case, it is an urban cooperative bank. The economic fallout of para 2, my lords.
Yes.
The economic fallout of on account of COVID-19 pandemic has led to significant financial stress on borrowers across the board. The resultant stress can potentially impact on the long-term viability of many firms, otherwise having a good track record under the existing promoters, due to their debt burden becoming disproportionate related to their cash flow generation abilities. Such widespread impact could impair the entire recovery process, posing significant financial stability risk. Next paragraph, para 4. The lending institutions shall ensure that the resolution under this facility is extended only to borrowers having stress on account of COVID-19. The stress is, my lord says, my profession is logistics and transportation logistics.
Yes.
Because of the lockdowns, there was my business was affected. Further, the lending institutions will be required to assess viability of the resolution plan, subject to the prudential boundaries laid out in annexure. Towards this end, each lending institution put in place a board-approved policy detailing the manner in which such evaluation may be done and the objective criteria that may be applied while considering the resolution plan in each case. I do not know, my lords, whether the respondent board has got this board-approved policy. Now, accounts which do not fulfill the required eligibility conditions to be considered for resolution under this framework may continue to be considered for resolution, even if according to them, my account stands classified as NPA, assuming that, but without admitting, may continue to be considered for resolution. Now, next page, my lords. Conditions for the resolution framework of COVID-19 related stress. The framework shall be applicable to eligible borrowers, corporate persons otherwise, subject to the conditions specified in herein. Part A of this annexure pertains to requirements specific to resolution of personal loans And part B pertains to resolution of other eligible borrowers. I come under part B. Part B, my lords, your lordship gets it at page 63. This part shall be applicable to all other eligible exposures of lending institutions not covered by part A. Only those borrowers' accounts shall be eligible for resolution under this framework which were classified as standard but not in default for more than 30 days with any lending institution as on 1st March 2020. Now, your lordship had seen that the classification of my account at page 156, it is in March 21. I'm eligible.
What was the period of the moratorium? When did the moratorium end?
That was not given to me.
No, when was the moratorium end? Like
Moratorium, it was extended as per the judgment of the
Honorable accept your
Court.
submission for now that your loan became NPA only in 2021.
Yes, my lords.
This moratorium which was declared on August 6, 2020.
Yes, my lords.
Did it cover March 2021? Or was it only until 6th August 2020?
No, I am not only on the moratorium, my lords, but also on the other packages. As per this, restructuring of the loan.
So your
moratorium is one.
You're not asking for moratorium.
Moratorium, my lords, I think.
Yes.
It has spent itself. Yes.
So you're not given moratorium, you did not ask for moratorium, you are on the restructuring. I did not ask for it,
but without my request also, they ought to have considered.
Restructuring also is, till when was this applicable? It was issued on 6th August 2020.
Lords, they classify my account and deny the, my lords are aware that the RBI guidelines have got statutory force, White Karnataka Central Bank of India versus Ravindra. Now that they should have followed it.
Accepting that your NPA was in March 21. This particular policy was in force for what period?
That period is not prescribed there.
Is RBI a party here?
Yes, madam.
Who appears for RBI?
Union of India.
Union of India.
Yeah, is there? RBI
Union of India have made party because
this has been
to
issued
answer
by
this
the
question.
RBI. Will you be making, till when was this policy in force?
Which is COVID policy. COVID policy only during the COVID period from March to August 2021 February.
Where is the document saying the period? So that becomes most relevant for us to examine. Because if it was March 2020, there's no problem.
2 months.
March 2021 cover ಆಗಿದೆಯಾ ಅಂತ ಆಗಿಲ್ಲ ನೀವು ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೂ ಇರಬೇಕು.
2 months.
And they may not be in a position to say that.
I will get that document from the ministry minutes. I'll place it on record.
What is the period for this?
That is why I made Union of India party, my lords, is they have to justify, they have to come out with an explanation. When does the right to securitize crystallize?
Correct.
Whether it is under 21J or 21O. It will definitely be under 21O.
Based on the
It is
factual
provided
aspects.
on the package.
No,
that is determinant on the restructuring package. So if you are entitled for the restructuring package, you are entitled for it till what period of the NPA loan being declared NPA?
No,
if their policy is that it is only till December 2020, then you won't be entitled.
Say this, if your lordship will see para 16, it will say the resolution under this framework may be invoked not later than December 31st. That is the cutoff.
That is why we are asking you.
Yes.
So it looks like it is applicable till 31st December 2020.
They should have,
But is there a date fixed? This is neither here nor there. It's not very clear.
It's not clear.
Though it says 31st December 2020, that means it could be only for NPA prior to 31st December 2020, not post.
Prior to, yeah, please.
You are post 2020. You are in March 2021 accepting your submission.
That's my NPA was on March 21. It has to be rescheduled for purpose of facilitating this stress.
Ms. Joseph, this is a largesse of the state. It is to be specifically complied. If the date from what we read in clause 16, that is why we asked you that, is what is the period? They'll have to come
I'll
up
get
with
that
what is the
notification, what
period.
is available during that COVID period.
If your date on which you are declared NPA is covered by that period, you will be entitled for restructuring. Then the interpretation of 210 will have to come in. But if the period is only until 31st December, you being declared NPA on March
The
2021, that will
circular
not
says
arise.
it has to be implemented on or before 31st December.
That means
I
NPA has to
understand my
be-
lords, the court question, my lords,
means
whether
NPA has to be
whether
before
I am
that.
eligible within that period.
I'll get it.
Place the
Next
proper document.
Yes, sir. I'll place it.
Lord, there were totally 4 loans. 3 loans, my lord, were classified as NPA in the year 2018 itself. That has been communicated to him, that is within his knowledge. In respect of 1 loan, probably, my lord, he may come under that COVID package. But
So
not
3
in the-
loans were classified NPA in 2000?
No, the RBI circular would say if you're classifying the accounts, it should be classified all the accounts, not one, not account wise. I'll produce that circular, not account wise.
Learned counsel for respond number 1 seeks for and is granted a week's time to place on record the period for which the what is this called? The COVID-19 regulatory package as produced at Annexure D was applicable,
Was annexed.
clearly denoting the start date and the end date thereof. Learned counsel for respond number 2 and 3, na?
2 and 3.
For the bank.
Next name is-
Respond number 1 ಅಲ್ಲ, Union of India ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. Learned counsel for the bank seeks for and is granted a week's time to place on record a statement indicating the loans which have been availed of by the petitioner and the date on which they were treated as NPA with supporting documents. Released on 6th December.
8th or 5th could be done.
8th ಅಂತೂ ಆಗಲ್ಲ. 5th ಬೇಕಾದ್ರೆ ಆಗುತ್ತೆ. 5th ಇದಿದೆಯಲ್ಲ, ಏನೇನಲ್ಲ ಬೇಡ. 5th ಆಗಲ್ಲ. 12th.
Not 12th, not 11th or 12th, because I got some fixed matters on that. I can out of station of there because the 12th, 6th could ಆಗಿದೆ ಸಮಸ್ಯೆ. Maybe
5th at order.
5th,
2:30.
2:30.
Sorry for the interruption. It's Annexure E, my lord, it's not Annexure D. It's Annexure E, not Annexure D. Page 58 will be Annexure E.
Annexure E
Please, ma'am.
to WP 7657 of 2020.
Meantime, let him comply that interim order, the partial amount which he has paid, because that is going on this.
ಇದು ಹೇಳಿದ್ರೆ if it is covered or not is the crucial point. That will decide everything.
Interim order, interim order.
Interim order earlier granted is, how can we extend? You're not complied.
No, no.
Not complied, we can't extend that. That
That's
we
one-
can't extend.
One other aspect, commencement
No,
of
well,
2O or
that's-
2J or 2O. It's a matter based on the factual aspects of each case. There cannot be any standard formal where we can.
That is why it depends on.
That's the 15 lakhs.
This
which
I
was
will-
ordered. I undertake to pay that amount, my lords, within 2 weeks' time, internal order.
That was interim
Because,
order
Manoj-
conditional. You'll have to file a fresh application. Don't
Apply.
do this.
Hearing on IA, serial number 15. Captain Arvind Sharma, party in person.
My lord, I am the petitioner.
Waiting for
Manpillai, Krishna Bolla,
The sec-
BB Patil. ಅವರು ಬೇಡ. ಯಾವ್ದಮ್ಮ ಇದು? ಇದು ಬೇರೆ. Form C has come. Form C. Issued.
They did an interview on 25th.
Has it been issued?
And they said they'll clear it.
Yes.
May I pass on the synopsis and all the relevant references? For me not to wander away from the argument.
Yes.
All have got it. My lord, the proposition of law.
What is this matter about? What are the facts?
Yeah, I just put forward the law proposition supported with facts. The Aircraft Act 1934, in principle, provides a very unique protection to all aerodromes and airports, wherever aeroplanes land or take off and are at low height. The problem with aeroplanes at low height, which is while taking off and landing, is they should not have a collision with a vertical structure, whether it's a tree, a structure, a tower, or a concrete building. So that protection is given under a particular section of the Act. It gives the power to the aerodrome owner to regulate vertical construction through an NOC process up to a radius of 20 kilometers. All people involved in real estate and development of real estate are very familiar with this. Especially in a city like Bangalore, where there were 5 airports at one time. You have the old HL airport, the new airport, Jakkur aerodrome, and Jalali airport, which is now defunct. So this refers to an airport called Jakkur aerodrome, which is a historic aerodrome owned by government of Karnataka, which operates a flying school operated by the government of Karnataka and has got certain tenants and people like me who fly aeroplanes out of there. For almost 6...
For a tenant of the place?
Yes, my lord. So for almost 60 years, the regulation was being handled very well till a new phenomena started happening, my lord. This started in Bombay, where a lot of private building developers started corrupting the system by obtaining false NOCs. And then came an issue where certain people would not even apply for an NOC and go ahead with construction. So the law for that, what Parliament has provided, the one is the preventive under Section 9A. One is, even in the event a illegal structure comes up, priority is given to the aerodrome operations and it can be demolished under certain rules. May I request my lords to kindly look at Section 9A of the Aircraft Act 1934. It's a very short act, my lord. It just turned pages, I'm not. Page 10. Page 10 Act. Yeah, this is rules. Page 10.
Section 9?
9A, my lord, 9 alpha. Power of central government to prohibit or regulate construction of buildings, planting of trees, etc. Without this legislative protection, no airport is safe, my lord. That's the importance of this. And to whom is this applicable? My lords, may kindly look at 9A subsection 4. Every person shall be bound to comply with any direction contained in any notification issued. What I am emphasizing, my lord, a government project does not have any exemption of such a violation. Because one argument has been put forward, we are a public project, we are a public funded project. So every person shall be bound to comply with any direction issued under Section 9A, subsection 4, my lord.
You are appearing for the state, Mr. Ravishankar. Chief Secretary, Deputy Commissioner, and Government Flying School.
The 3 agencies should have regulated this.
So you are appearing for
a civil suit also.
your appearance ನೋಡ್ತಾ ಇದೆ. Who to ask what question ಅಂತ.
ಈಗ ಅವರೇ ಹೇಳ್ಬೇಕಾಗ್ತದೆ. Out of the, because I was initially I support.
Manan Pillai is appearing for Minister of Road Transport and Civil Aviation.
Now, because initially our statement of objections, we supported the petitioner. We didn't want that to come. But subsequently, there were many things happened which my learned friend made.
It led to an officer being transferred.
Judgment of my lords, along with Chief Justice at an earlier point in time, but PMRC.
Now you are not supporting status quo. So you are appearing for the training school.
Yes.
NHA, you are appearing, Mr. Pillai, you are appearing. Who are the 7 to 11?
My lord, they are students of the government flying training school who had got scholarships and made payments to learn how to fly there. I think all of them have flown away now to different pastures.
So
Because the flying school has been shut for about 10 years, my lord.
yes, it's been shut for 10 years. Yes, 9A.
Would my lords want me to read? My lord?
What is it that you want to rely on?
My lord, this is the one which says that without a NOC or without permission of the aerodrome, within a radius of 20 kilometers, no structure can come up in violation of this act. And a notification is issued under this which regulates at what point in what side of the aerodrome, either in line with the runway or on the side of the runway, how much can you construct, how much you cannot construct. That power emanates from here.
Yes. What is the height restriction here?
My lord, it's a statutory notification under this section. I'll just take my lords through it shortly. Next is, my lords, the Demolition Rules 1994, which is page 211 here.
Demolition obstructions caused by.
Exactly, man.
Yes.
Now, in the event for some reason illegally a structure comes up, would that allowed to be stayed? With that, can that continue to stay or does it have to be demolished, my lord? Where is it? Caused by buildings, entries, etc. This derives its power under section 11A, my lord, of the Act. Sorry, section 11B of the Aircraft Act. The name itself is self-explanatory. This will apply to buildings, trees, and any structures. And the competent authority is an officer in charge of the aerodrome, my lord. So, after having pointed out the law, my lord, I'll take this honorable court through the factual position. So, what I'm trying to say is suddenly one fine day, an elevated structure, which is the present elevated highway to go from Bangalore to the Bangalore airport, from the city to the airport, comes up with a massive 20-meter structure running directly in line with the runway on the western side, which is the most sensitive no-go zone, where not even a sapling can be put up. A 20-meter structure comes up, my lord, which admittedly affects the runway by 40%, hence making it unviable for aeroplanes, unsafe for aeroplanes, almost half the number of aeroplanes which operate from aerodrome. And the National Highways Authority claim that they have the permission of Karnataka government and hence they do not take NOC from the competent authority. It just on this, our petition. Yeah. Now may I take this honorable court's attention through our petition, my lord. The table is given on page 3 of the written arguments. Annexure B to the writ petition, page 16.
Written arguments, what do you want to see?
Mirror written arguments, page number 3.
3. Yes.
Para 6. There's a table below, my lord. Each one of these documents support the factual matter. Turn page 16. My lord, I had queried under the act which are the details of the notification. So this gazetted notification is at page. Yes, my lord.
What is the height restriction?
At that location where the 20 meters come up, my lord, it's less than 4 meters.
Where does it say so?
My lords, may kindly see page 17. No, these are all admitted facts I'll show, my lord, rather than deriving mathematics from this.
Admitted between both of you, what are we sitting for? You'll have to tell us where. What does it say?
My lord, page 17. Para 1.
Yes.
No building or structure shall be constructed or erected, or no tree shall be painted or planted on any land and within the limits provided in Annexure 1 to this notification. 2 lines later, my lord, developed and notified by the competent authority in future where there is any building structure or tree or such land, the owner or the person having control of such building structure or tree shall demolish, please note, such building or structure, or as the case may be, cut such tree forthwith, but not later than a period of 1 month from the date of publication of this notification on the Gazette notice. This is 2008, and their violation is somewhere around 2010, my lord.
Annexure 1.
And para 2 of the same page, my lord, the last 3 lines of that para. Or tree shall forthwith, but not later than a period of 1 month from the date to publication of this notification, reduce the height thereof so as not to exceed the specified height. So what should be the action to be taken? Either demolish or reduce it to acceptable heights.
Yes.
My lord, para 3, 4th line from the bottom. Specific request with the confirmation from the local authority, state government, agreement with such proposal and have mechanism in place for ensuring the implement of height cleared through NOC. Now, the Honorable Court may look at page 18.
Para 3, what did you read just now?
My lord, para 3, 4 lines from the bottom. Jurisdiction wise.
Yes.
Whose jurisdiction the aerodrome is located, indicating that it is in agreement with such proposal and have mechanism in place, which is the NOC mechanism. So the state government in this particular case has a jurisdiction to have a NOC mechanism, which was admittedly bypassed.
So Sharma, you may know this thing. We don't know. So unless you pick up one line somewhere and read it, it will be hanging.
No, I'll slow down, my lord. As it is trying to go a little slow due to some disability.
What does that mean? It's a hanging line.
Means, my lord, HL Airport has got different jurisdiction. State government airfield has got state government jurisdiction to implement this mechanism. And airport authority, airports have jurisdiction of the airport authority. The mechanism being an NOC for a 20-kilometer radius.
So your contention is AI has to issue the NOC.
No, not AI, my lord. State government.
Shall be dealt by
Jakkur
AI.
is a Karnataka government-owned airfield. My lord, may kindly turn over to page 18. Para 4. This makes it even more clear. State government authorities
shall be dealt by AI. Is what clause 3 says, what you were pointing out. Provided the aerodrome operator makes a specific request with the confirmation from
that
the
is,
authority.
if the state government feels it doesn't have the expertise, it is welcome to fall back on airport authority, which is statutory authority, to help implement the same mechanism.
So your contention is the state government can issue it. If the
Can
state
do it
government
itself
is
or
going
outsource it
do
to AI.
then AI.
Yes, my lord. Para 4 will make it even clearer.
Yes.
State government authorities shall be responsible for taking action in respect of any building, tower, etc. That's why the district commissioner has been made a party, my lord. At least the execution and implementation of demolition is totally with the state government and not with anybody else.
Yes.
Any structures, 4 lines from the bottom, para 4, my lord, constructed in the surface after 1 month of issue of this notification should automatically be considered as illegal and has to be dealt with by the district administration, local authorities for removal, reduction of the height.
Where is the notification in respect of this airport?
This is the notification they are referring to, my lord. This has annexures with listing all the aerodromes which are statutorily given the protection, my lord. Later about annexure 6, 7, I'll take
This airport mentioned?
1 minute, my lord. Here, where is this? Aerodromes not necessarily meant in service state government. Just give me a second. I slowed down a lot. Let's see, Jakkur. List of privately owned, no. It's all part of annexure 7, my lord. I'll just pull out Jakkur there.
Annexure 7.
Where is Jakkur? Of course, my learner friend, Mr. Ravi Shankar's documents are there, which I'll point out, but I'll show. 48. What is this? List of aerodromes controlled by airport authority? No. After this.
Which part is it under? Part one is defense, part two is.
Part
control
two, section.
By AI.
I apologize, my lord. I should have
There.
been ready with this. Jakur, Jakur. Turn. What is it? Yeah, page number 58, my lord, of the writ petition. In that table, section, 32, my lord, on the left-hand side bottom. Third from the bottom, Jakur, Karnataka, latitude, longitude.
The state government aerodromes normally maintained in serviceable condition.
Yes, my lord.
Part four of Annexure 7.
Part four of Annexure, yes. Sorry. Para 5, my lord, which has not been done till today, again admittedly. A certified copy of the consent. Sorry.
Are the rules applicable to part 4 airports? Is there any specific?
To all the airports in that annexure, my lord. It's in the first para itself on page 17. Annexure 1. In respect of civil and military aerodrome existing as listed in Annexure 7. Para 1, third line, my lord.
There are different parts to this Annexure 7.
Entire Annexure 7.
Are these different parts governed by different rules or is the same rule?
No, same rules, but the authorities are different. Defense, state, airport authority. That's why they're listed in separate lists, my lord.
Where do we get that?
The heading of each one of those, my lord. List of defense, page number 45. List of defense aerodromes indicating elevation of airfield reference point. Then list of airport authority aerodromes, which is page 48, my lord. List of aerodromes controlled by Airports Authority of India.
Yes.
Okay, may I draw the court's attention to para 1?
Separate rules, same rules.
Same rules, my
Will
lord. The
be the same.
notification is common to defense, civil, state and union.
Yes.
And para 1, my lord, on page 17, which is the second line. The restriction of the height is in Annexure 1 and it is
Why we asked you this question?
We are going to go there, my lord, but and the applicability is to Annexure 7, all the aerodromes in Annexure 7.
In respect of civil and military aerodromes existing as listed in Annexure 7.
Yes.
So it restricts it to civil and military aerodromes.
Civil is non-military, it includes state and union, which is Airport Authority of
Where
India.
do we get that definition? It has to be legally classified.
Well, I don't know that has been mentioned anywhere, ma'am.
Why are they saying they could have just said as listed in Annexure 7?
No, the reason being the Aircraft Act is not applicable to the military flying, my lord.
But they still say civil and military aerodromes.
Only for aerodromes, NOC, because it's a civil matter for construction around an aerodrome. Probably that's why it is there. But when it comes to aircraft rules, none of them are applicable to military registration.
Because then it should have been Annexure 7. That's why we are asking you whether there are separate rules for each of the part, or they say because list of defense aerodromes they have given. Then they have given list of aerodromes controlled by AI. List of privately owned licensed aerodromes. List of aerodromes normally maintained in serviceable condition.
In R1, R5, R6.
Then aerodromes not necessarily maintained in serviceable condition.
Yeah, whether aerodrome is serviceable or unserviceable is immaterial, man.
So if the aerodrome is not maintained in serviceable condition, why should there be a restriction?
Because it may become serviceable at any point of time. A runway may be under repair.
But your clause 1 only says in respect of civil and military aerodromes existing as listed in Annexure 7. So the notification, so on and so.
The normal parlance is, military is a very specific area.
Yes.
This letter of Mr. Naveen Raj Singh, Where is that? Let me find out here. Letter of the Chief Secretary to Chairman. Can you take out this? R40. My lord, in the meanwhile, may I draw the court's attention to the statement of objections filed by R1, R5, R6. So far, we were at the writ petition. It's a thick compilation, my lord. R1, R5, R6 combined filed by senior Mr. Ravi Shankar. Yes. You have supported the survival of Jaipur Aerodrome.
By R1, 5 and 6.
Yeah. My lord, may I kindly peruse page 126, the annexure R40.
126.
Yes. Annexure R40, my lord. This is the letter written by the Chief Secretary Respondent number 1, representing State of Karnataka, to the Chairman National Highways Authority. The agency involved in the illegal construction of the elevated highway. If my lord permits.
Yes.
Second para, my lord, unfortunately, while designing the project, this is a clear admission, the existence of government-owned flying school at Jakur was missed by design consultants. Design is in the year 2008-9 after this notification. As a result, the elevated highway has become a major safety hazard. Aeroplanes flying in and out of Jakur Aerodrome. The government flying training school was started in 1949 by the late Maharaj of Mysore. Is the only school providing commercial pilot license to. It is therefore of historic value. Honorable Chief Minister is very firm that this aerodrome has to be preserved. I have conducted several meetings to sort out this issue. Many alternatives were discussed, like land acquisition and cross-run, etc. After all these discussions, the only feasible alternative which has emerged is the lowering of the elevated highway in front of runway for a certain height. When the issue was placed before the local representative of NHI, they expressed that this was beyond their power because they're only saying it has to go to the chairman. Before the local, they expressed that it was beyond their power since decision has to be taken at the highest level. In light of the above, a meeting with you would be required to resolve the issue as early as possible. This is, my lord, 2013. Till today, the issue has not been resolved.
For reply to this?
Sorry?
What has happened?
One of the early ones, he admits, he gives them a notice. R3 something.
Jorag Mata. If I may interject. At the midst of these proceedings, the Honorable Justice E.S. Bopanna wanted us to go back to the Chief Justice, what is that? All the bureaucrats had to meet. Along with National Highway, Jakur, the petitioner here, we all met. And the ultimate decision was to acquire another 3 acres of land towards the eastern portion of the Jakur. My lords are very aware of the topography.
They will push the runway.
Push this thing so that it doesn't come on the funnel zone, it doesn't get obstructed. Because my learned friend's contention at that point in time was they cannot land and take off because it falls in the funnel zone, this elevated expressway falls in the funnel zone of the aerodrome.
That is a zero tolerance zone for any construction.
They couldn't take off, they couldn't also land because of that. So that was a preliminary contention.
Have you acquired?
No, it is not acquired. We filed a civil suit because there was adjoining to this aerodrome, there is a cooperative society which had occupied a portion of our land. We filed a civil suit for declaration that got dismissed for default. Then we filed a miscellaneous.
Default.
All these things, yes, they didn't come to these are the facts that I'm placing before the court. So ultimate decision was to acquire a portion of the land. That's about 3 acres of land to the eastern side, the Jakur side.
Was that decision taken?
This was happened at the same time that the chief secretary.
What have we done in the last 12 years?
Nothing has happened.
Nothing has been done. My lord, may kindly see.
Because it,
Now, there are more and more
it
number
was
of.
embroiled in another civil litigation. Because the cooperative society did not want to leave any portion of land, for which a declaratory suit was also filed. And no further notification was made for acquisition of the remaining part of the. That's how it's, because the court was very keen that.
And Ravi Shankar, you should probably acquire extent of land for shifting this airport somewhere else and making it available.
They didn't want, madam, because.
That's the plan, my
they
lord.
didn't
Shut
want-
down the aerodrome.
They wanted to thwart the ideas of the politicians who involved in shifting this particular aerodrome to another place. They didn't want another marketplace to come there. They wanted a lung space there for the city. So that was the original idea, which.
That's even better. Maintain it as a lung space and shift this somewhere.
That was the original idea, at least to remain it, ensure that the lung space was there.
Make it into another Kaban Park. Dalbag.
Okay, then the many meetings took place. The chief secretary did make many meetings. At that time, then chief secretary changed and nothing happened. Kindly see the prayer that they saw. Now whether that could be allowed, because my lords have also passed an order.
What is your?
Now support ಮಾಡಿದ್ವಿ.
ಇವಾಗ ಏನ್ ನಿಮ್ stand?
ನಮ್ದೇನ್ ಈಗ almost, I mean.
My lord, that officer who took these bold steps suffered. May I request my lords to just see page 55 of the same compilation, R1, R5, R6 statement. It will make it crystal clear, my lord, the position of law and their action.
See, if the law is clear on the height and if it is for a moment, presume that it is the state government who has to issue the no objection. State government, instead of issuing the no objection, has objected to it.
Yes, madam.
Then
There is
the
an
NHAI
infraction
could never
of
have
it.
constructed it.
How?
Then there is a duty imposed on the deputy commissioner to demolish it. Whatever it may be. There's a violation of law, there's a violation of law.
Look peacefully, sit down.
That's the reason court did not want that to happen. ಅದಕ್ಕೋಸ್ಕರ ನಮ್ಮನ್ನು ಕಳಿಸಿದ್ರು to the drawing room.
ನೀವು ಮಾಡ್ಲಿಲ್ಲ ಇವಾಗ.
There is an order also.
That is an option given. If you don't exercise the option to resolve the matter amongst yourself by a viable resolution process and alternative. So now you are back to square one. So there's no point again telling you to go back and do things because you are not.
One opportunity ಕೊಡ್ಬೋದು now that the matter has come up.
My lord, NHAI later has even refused to pay for the acquisition. I'll show that document. So it was only to avoid the court. State government went to the extent of shutting down Jakur Aerodrome by an order of chief secretary. Thanks to this honorable court, a committee was constituted and the airport was reopened.
They shut down this and directed demolish.
That's what they said. It's too dangerous. We'll shut down the airport.
Until you plan for reworking and reducing the thing and a funnel zone.
There were some hangars that were operating. Then a friend knows. Some aircrafts,
If
they were
there is a
hangars, they
violation
were
of the
parking.
notification, subject to your pointing out that that notification does not apply. That's why we are asking Mr. Sharma about it. If that notification applies equally to any and every airport scheduled under Annexure 7, listed under Annexure 7, then nobody can overcome it, whether it is National Highway or
No exemption to any project of any kind.
or Union of India. That will also go.
Your lordship had passed an order regarding.
ಒಂದೊಂದು ಆರ್ಡರ್ ಇದೆ ಅದೇ ಹೇಳ್ತೇನೆ. My lords.
May I request my lord?
PIL.
There is an infraction of law. We will. What is this order? The order from UMRC.
This was on 27 July 21.
That's.
I'm not aware of this order, my lord. Copy there, friend.
The training school is part of it.
ಬೇರೆ ಯಾರೋ represent.
Your other friend, Mr. Ajay Kumar Patil, was the petitioner.
May I request the indulgence of the court to look at page 55, my lord?
Yeah, just one. But this is as regard BMRCL, this is not as regard.
That's what,
NHS.
please, ಇವ್ರಿಗೂ ಅದಕ್ಕೆ ಸಂಬಂಧ.
So in BMRCL, we don't know what has happened. Has all this been followed?
Maybe BMRCL has got exemption.
Moment, Mr. Sharma.
Sorry,
We're not,
Madam.
did we ask you anything?
No, sir.
I'm in the panel of BMRCL. I'll find out and make submissions.
This is for BMRCL, whether the NOC, obviously the same rules which are applicable to NHAI will be applicable to BMRCL. Explicitly from.
Compliances have to be done. Compliances ಆಗ್ಲೇಬೇಕು.
This is the one.
I'll make inquiries. I was not there in that suit.
ನೀವ್ ಯಾರಿಗೆ? ನೀವ್ ಯಾರಿಗೂ ಇಲ್ಲ, ಇವ್ರು ಇದ್ದಾರೆ. ನೀವು ಮೊದಲು is the council approved. 1, 2 and 5 special council. ನೀವು ಮಧ್ಯದಲ್ಲಿ ಮತ್ತೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಬೇಕು.
Query for respondent number 4, my lord. My lord, regarding the submissions.
Have you obtained NOC?
Please, my lord, regarding that, there have been letters written by the state government. Shall detail be make it in a written submission and file it before your lordship? I shall address that query. That shall.
If you have not obtained NOC, it will go.
Lord, just one submission, if I may be allowed to make. Page number 10 of my statement of objections, my lord. Respondent number 4.
Is the written argument
Yes.
gone?
Respond number?
4, my lord.
Forget that. Just
When
follow
did you
this.
file it?
So it was filed on 10/1/2014, my lord. My lord, the protection,
Objections to IA or objections to the main?
objections to the main petition, the statement of objection,
Objections to IA.
filed on 10/1/2014, my lord.
ಇದೆಯಾ ನಮ್ಮಲ್ಲಿ? ಎಲ್ಲ miscellaneous. Respond number 4, yes. Para?
Para 12, my lord.
Yes.
Lord, if I may be allowed to. Lord, this response, the Jakkur aerodrome has been deleted from the control of the Airport Authority of India / aerodrome officer by the notification number SO 84E dated 14/1/2010, published in the Gazette of India, Extraordinary Ministry of Civil Aviation, Government of India, which is annexed at R12, my lord. By virtue of this, the section 9A of the Aircraft Act,
R12 is page number?
page number, my lord, 59, 58.
Supersession of the notification on 30th, so on. So.
Is a detailed notification, my lord. By virtue of all these parameters,
So where is the deletion? Where has it been, where do you
Please,
say it
please,
is
please.
deleted? How do you say it is deleted?
let me look. Lord, I shall.
This is the addition of annexure 3A, B, C, D. There is no change made in
Pardon me.
annexure. There is no change made in annexure 7. We don't see any change here.
Please, ma'am. I shall make, along with my written submissions, I shall make good with the submission. I shall, by the next course of.
Either you'll have to show that this,
Please.
like what you are trying to show now,
Please,
that this aerodrome is not covered
please,
under the, under section 9A
please.
of the Aircrafts Act, Aircrafts Act. Or you'll have to show a no objection certificate.
Please, ma'am. I shall address.
In the absence of these two, we don't see any other third alternative available to you.
Please, my lord.
So if neither of these are there,
Please,
then prayer A will have to be allowed.
please. Please.
And not only prayer A will have to be allowed, you have violated law.
Please,
Whoever the officer were at that time
please,
will have to be prosecuted.
please. I shall make good with the,
Because in the face of the objection by the state government,
please,
who is the authority to give you the no objection?
please,
If you go ahead and build it,
please,
then there's no sanctity to your organization.
please. my lord. But in that regard, we have sought for the no objection certificate, but I shall produce it.
Seeking is different.
Please, please, I shall make good.
You may file Mr. Sharma may file a petition. That doesn't mean it is allowed.
Please, my lord.
If your statement is accepted, then it is allowed. You could not have done it.
Please,
You filed the application, it was objected to, they virtually rejected your application,
please.
despite which you have put up construction.
No, but I shall make good with the submissions your lordship has raised.
The submission of Shri Arvind Sharma, council, party in
Lord,
person.
I'm sorry to interrupt. May I just request that last reading of that one document
Which
by
one?
the competent authority, page number 55,
Of
will
your-
make it crystal clear, man.
Your petition or Mr. Ravi Shankar?
Statement of objection of R1, R2, R3, my lord.
Yes, page number?
Page number 55, annexure R2, my lord. This is the competent authority of Government of Karnataka to issue the NOC.
55.
A senior IS officer.
Yes.
My lord, the heading is Office of the Director, Government Flying Training School. This is the government itself. To the Director General of Civil Aviation, which is a statutory authority which implements the aviation rules.
That is for the deputy commissioner.
Sorry?
Remove it.
No, no, no.
Removal is by the deputy.
My lord, kindly read this, it will become very clear. Subject, removal of unauthorized construction endangering flight safety at Jakkur Aerodrome. Request for action under section 9A of the Aircraft Act, read with the Aircraft Demolition of Act, both the acts, preventive and post-operative. This has reference to your letter to the Principal Secretary Youth Services, copy enclosed. This is to bring to your notice the fact that MS NHAI Respondent 4 have constructed an elevated highway right in the no construction zone or runway 08 of the Jakkur Aerodrome. This has been constructed without taking the required NOC, that answers. For the construction as per statutory order, which my lords had perused earlier, which was the applicable statutory order of Government of India issued under Rule 9A of the Aircraft Act. At the time of construction of the elevated highway, the location and other particulars of this primary construction are as follows. He goes on to give all the details, the calculation as per the statutory order, my lord. And then thus the last para, thus the runway is almost rendered useless for most fixed-wing trainer aircraft. Situation will become even grimmer if you remember that the aerodrome is mainly meant for training of pilots. My lords, may go on to the next para. NHAI have totally ignored the requirement of NOC. So there's no application also from the aerodrome. The highway project was approved by the Government of Karnataka on so-and-so date, and preparations for construction started almost immediately. They had plenty of time to apply for an NOC. So nothing has been applied. If they had, they would have changed the design of the highway in the area next to the runway. By the way, my lord, in front of Yelahanka Air Force Base,
We are just about to ask you.
they were not permitted. So they have gone on the ground. There's no elevated portion to it. Those authorities did not permit them to build. Even BMRCL has not been permitted there. That they had, okay. They could have made the highway to run underground or at ground level, as they have done at several stretches. Example, near Yelahanka Air Force Station. They ignored this requirement of an NOC from the aerodrome totally. Thus, the elevated highway near Jakkur Aerodrome is constructed in blatant violation of the Aircraft Act. This is under oath, not by me, by the competent authority.
Do you need the army's might to stop you?
Sorry?
Pardon, my lord?
Do you need the army's might to stop you? And one Jakkur airport cannot stop you. Is that how you steamroll?
No, my lord.
That is what they have said in the statement of objection. Who is Jakkur Aerodrome?
No, my lord. I shall make good with the queries.
You are at the receiving end.
Please. Please.
Milord, the next para is even more important. Now it comes to the actual demolition.
We read that whole thing. Who is the, Mr. Ravi Shankar, who is the person who has to give the issue, NOC? Authority? State yaru, which officer? Chief Secretary has said so. So it covers everything. But in terms of the
Ministry.
which ministry or which department is supposed to issue the NOC on behalf of the state? Because this is not coming under the AI. So which is the authority?
Is managed by sports.
Allah, airport ke, who will be the authority? Is it the director of the Jakur
My lord,
Flying
it's the
Club
same authority.
or is it somebody else? If it is the director who has written this letter at page 58. Page?
In their statement of objection, they say we are the authority. May I point out that, my lord? Our petition, sorry, R1, R2, R3, objections. Here it is, illegally appointed, relevant law extracted, page, para 4, page 3. Para 4.
I said without taking the requisite, who is the concerned authority?
He himself is given, my lord, page 3 of the statement of objections of R1, R5, R6, para 3, page 3. Or probably end of the previous page, page 2. It is further submitted, that is 4 lines from the bottom, my lord.
From HAL and BIA.
Yeah, he says not only have they not taken from anybody else, they have not taken from me also.
Where
That
does
is
it
also
say
here.
Who is the authority for this?
I'll just point out that they themselves have submitted it there. Provisions are applicable, it is.
HAL is more than 20 kilometers away. So
No,
they
no, true.
don't need-
What people used to do, my lord, go to an airport which is beyond, take a NOC from them and pass it off at Jakur. I'll just answer my lord's query. No, 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 that is the authority. He himself says it.
You'll have to tell us, Mr. Ravi Shankar.
It's there in writing, my lord. I'll just point out.
Show it to us.
Just give me a minute. Sir, ನಿಮ್ಮಲ್ಲಿ ಇದೆ ತೆಗಿತೀನಿ.
I find the statement of objections. That time the senior counsel appearing for the national highways took objections to the director signing on behalf of the state 1, 2, and 6, saying that the authority had to be given by the state
Kaushik Mukherjee.
for this officer to sign on behalf of them. It's also noted by this honorable court in the order sheet. Thereafter,
But you are the special counsel appointed by the state. Notification is there. Issued by the director or by the state?
By the state. No, I'm not talking about my competency to represent the state. The affidavit that was sworn to director
Yes.
was order sheet dated 30/4/2014. ಆಮೇಲೆ earlier orders.
ಬೇರೆಯವರು ಯಾರು sign ಮಾಡಿಲ್ವಾ?
Preliminary objections were also taken.
1 and 5 have not signed.
19/2/2014 order sheet.
Do 1 and 5 also support this statement?
Yes, ma'am.
One
Because
memo.
ultimately we all went to the, we'll have to ask whether.
You will have to, you are the special, that's why we asked Mr.
He's the name, kindly see the order dated.
ಪೂರ್ತಿ ಮಾತಾಡ್ಬೇಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾವು ಅವ್ರಿಗೆ. ನೀವ್ ಹೇಳಿ ಅಂತ.
I was under the impression that lots will ultimately make all of us sit together, drawing room and sort it out. Flyover has come, the funnel zone is obstructed. All these things have happened. Now to go back to 0-1.
See, either you acquire the land, now we, after 12 years, We are not going to be attempting to try to reproach both of you. That time is gone. If you wanted to do it, you would have done it by now.
Jakkur Airport per se has no difficulty with the petitioner.
You said you are going to acquire 6 acres and give it, you have not done that.
That's there in the.
You are going to
court
shift,
record.
you haven't done that. So you have not done anything.
Nothing else.
They have gone ahead and constructed in violation. Unless the airport is deleted, the permission is required. You are not given permission unless you give it now. Post facto. If you give it post facto, Mr. Sharma is out.
Idea of the state at that point in time was to bring all together in one group and sort it out.
You have not come
Sort it
together.
out. That was the only idea.
We'll give you 1 more week's time to do that.
Repeatedly, in fact, the order sheet also speaks. They wanted the all the parties because the high-ranking officers.
Mr. Ravi Shankar, we'll give you one, without saying that, we'll give you a week, 10 days time or 2 weeks time, we'll give you. But after that, no. It's a 2013 matter. It cannot be, a litigant cannot be made to wait for 12 years.
Quite.
With all of you, if you are colluding with each other also, no.
The fence is eating the grass, my lord. That's a tragedy.
Can't do that.
We were not.
There's no post facto NOC which is contemplated. If there's a violation by NHA, NHA will have to face the music. Like any other private developer against whom we pass orders. If it was somebody else who had done it, we would have passed the same order. There cannot be any preference because it is the National Highway Authority of India.
Please.
You should be more in compliance than anybody else.
Please, certainly.
If you are not in compliance, how do we enforce it against a private developer?
Please.
They'll point out to NHA.
Please.
Any matter which comes about violation, they say, look, NHA has done this, you have not taken any action. Why are you taking action against us?
In that regard, my lord, I shall make good with the submissions.
You will have to face the music. Either you come forward and say that you are going to demolish it by yourself,
Please.
or reduce the height and do it within a time-bound manner,
Please.
or we'll direct it to be demolished.
In other case also, I shall, my endeavor will be to show either we, accordingly to, the NOC has been obtained accordingly and it is in accordance with the law.
You have not obtained NOC. You can never say NOC you have obtained. They are objecting there.
No, please, no, in accordance, but it has been done in accordance with law, or that the section 9A is not applicable to it. That shall be, my endeavor will be to show.
Yes.
To your lord.
Only section 9A is not applicable is your ground available now. They have objected.
Please. So that will, I'll make good with the submission.
That's the only thing that you have. Which as per the notification that you read, doesn't appear to be so.
Please.
The submission of the Shri Arvind Sharma, the party in person, petitioner party in person, is that there's a gross violation of section 9A of the Aircraft Act 1934, inasmuch as the Jaipur Airport being listed at serial number 32 to part 4 of Annexure 7 of the notification issued under section 9A, no construction could have been carried out in the funnel zone of the said airport. His further submission is that the state, which is the concerned authority to issue a no objection, having objected to the said construction, there being no objection, there being objection expressed, the question of respondent number 4, NHAI, having proceeded with the construction without obtaining a NOC from the concerned department of the state, is illegal, and as such the petition is required to be allowed. Learned Counsel for the state, respondent number 1, 5, and 6, submit that the state has categorically objected to the NHAI putting up the construction, and that there is no objection certificate has not been issued by the state. Faced with the above situation, Learned Counsel for respondent number 4 seeks for and is granted 10 days time to make his submissions. Released on 12th December at 2:30 PM for further hearing.
May I submit, my lord? The state may also be asked to answer. Who's the NOC authority? State itself can answer.
Anyway, they have to produce the NOC or not.
Okay. My lord, one last document.
No need, Ms. Sharma.
Okay, done. Obliged, my lords.
Obliged.
Serial number 16. Darshan Gowda Patil.
Lord, we can come at 2:30 irrespective of where it is listed.
Listed at 2:30 on that date.
Okay.
But in this matter, on the previous occasion,
Yes.
there was a direction to the ADLR my lord, to do a joint inspection.
I filed the report. You filed the report?
Otherwise, my lord, may I make one submission? Thereafter, my lord, we have filed a memo before this court on 11th November, stating that, my lord, the land, my lord, we are willing to accept on the as-is various basis, provided a year time is granted. For this reason, my lord, my case, the entire
And
case.
what is this, man?
Yes, my entire case is that, my lord,
Just one more. What is this? E69. Not being level and same having its
Please.
own.
that is the grievance made out by the petitioner then. This is a 2018 petition. Now, my lord, we had on 11th November, we filed a memo.
Yes. 11th November.
11th November, please.
Where is the inspection report? Where is Mr. Naik?
In abroad.
Huh?
Abroad.
Abroad. Neither.
Yes. At the time petition was filed, there were alternative lands. Now, my lord, I am told there are no alternative lands in the said area. Now, my lord, we are willing to accept the same, provided a year's time is granted. That apart, my lord, my entire case is this: 34B2 notice has not been issued. 34B1 notice came to be issued. Yes, that on that ground, my lord.
Mr. Naik conceded to remand.
Yes, remand
Went
also.
to the CEO, then
We are also willing for remand.
Remand ಮಾಡ್ತೀರಾ 12 months ಕೊಡ್ತೀರಾ? ಮುಗ್ದೋಗತ್ತೆ ಇನ್ನೇನಕ್ಕೆ?
As insist the court, we can give 1 year, 12 months. With the
12 to 18 months construction agate.
Now that my learned friend is
Sir, can you construct in 12 months? Don't again invite another issue.
That's in that case 18
Land
months.
sanction ಆಗಿದೆಯಾ?
We have to start the entire process, my lord, because no work has happened at all because of the undulation on the land. No work has been started.
The
Now,
12 months and how are you saying?
18 months, 12 to 18 months. Now,
18 months ಅನ್ನು ಮಾಡ್ತೀರಾ?
this is the undertaking we have.
ಮಾಡಿದ್ರೆ we'll employ your contractor for everything that is to be built.
Petitioner will be very
You'll
happy.
be a
in that
super,
case. Yes.
very efficient contractor you'll be.
Business
KDB will also use him for everything.
We're in the business of printing.
Huh.
Keeping that in mind, my lord, we'd sought for 12 to 18 months.
Petitioner is before this court seeking for the following release. The grievance of the petitioner is that without following without following the requirements under Section 34B of the KIADB, Karnataka Industrial Area Development Act, the land of the petitioner has been resumed. Apart therefrom, the contention of the petitioner is that the plot which had been allotted to the petitioner was a effective one, inasmuch as the said plot had not been leveled and was having a slope. And it is in that background that the petitioner had made an application for allotment of an alternative site, which was not, which instead of being considered, the plot allotted to the petitioner had been resumed without following the due procedure. Today, a memo has been filed. A memo has been filed by today, Allah. A memo has been filed by Nim report ಅಲ್ಲಿ?
I filed it on 20th November.
30th.
Copy I have.
This call.
Page 2.
They say there are undulations and there is a huge slope.
This court-wide order dated 6/11/2024 had appointed the ADLR to carry out an inspection of the property and submit his report. A report has been filed on 12/11/2024 stating that though the industrial layout has been formed, the plot number 269D allotted to the petitioner is a slope land and there are undulations. And further that though electric lines are available, the same have not been drawn to plot number 269 capital D. However, it is stated that there is an access provided to plot number 269D. The contentions of the learned counsel for the petitioner that the land is not a level land, is a slope land and does not have electricity and water connection is established by the report filed by the ADLR. The petitioner has however filed a memo on 11/11/2024 stating that if the allotment were to be continued and the additional time of 18 months, we find this not possible.
But it's been,
Is granted, the petitioner would make use of the land and comply with the requirements of the KIDB. In that view of the matter, firstly being of the considered opinion that the requirement of section 34 capital B have been violated inasmuch as no notice had been issued to the petitioner prior to the resumption of the land of the plot. And secondly, on account of the fact that the plot which had been allotted to the petitioner was incapable of being utilized by the petitioner at that point of time. Being of the opinion that there would be no purpose in remitting the matter back to the KIDB for fresh consideration as regard the resumption, when the petitioner has come forward to comply with the requirements within a period of 18 months, I have the considered opinion that that period is required to be granted to the petitioner. Hence, the reliefs which have been sought for are molded. The certiorari is issued, the order dated 26/4/2018, so and so at Annexure A is quashed. The time the petitioner is, you will level the land yourself.
Yes, or I'll take other contract, but the entire steps would be completed.
Everything is yours, you
Yes,
can't go
my
to KIDB.
responsibility, petitioner's responsibility.
It shall be the duty and it shall be the responsibility of the petitioner alone to level the land and make it usable without approaching the KIDB in that regard. A time of 6 months is granted in respect thereto. Thereafter, the petitioner is granted 18 months' time to set up the industry in compliance with the conditions imposed by the KIDB. The set period of 18 months to be calculated from the date of plan sanction by the KIDB. The plan to be submitted by the petitioner within 1 month of the 6 months granted to the petitioner to level the land. The above observation, the petition stand disposed. Pending IS.
Great.
18 months ಅಲ್ಲಿ ಇನ್ನೊಂದು petition ತಗೊಂಡ್ ಬರ್ಬೇಡಿ.
ಇಲ್ಲ. Great.
17. K. Shashikant Prasad.
For petitioner,
Yes.
last date of hearing, my lords, your lordship was direct
Last petition, this honorable court has directed me
submit a report.
secure the person who has issued annexure C, my lord.
30 to 50 years.
Yes, ma'am. I have written a letter on 29/10/2024 and which was also sent by email. They have not replied anything, my lord. The principal secretary to the Government Department of Tourism.
No reply.
No.
I've called, I have also intimated. I have
TCMS ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲಿ 29/10/24
DGA submit the DOE
letter
letter or
and
email?
mail. Letter and mail.
Letter dated
29/10/2024.
and email dated?
Email at the time 25 PM.
Or the
29
email of the same date
Same day.
has been sent to the Principal Secretary Tourism Department. No reply has been received. He submitted that the said letter has also been transmitted using the CCMS platform. One more week's time is learned. AGA is directed to send a reminder.
Yes.
If no reply is received by 12th December, the Principal Secretary Tourism Department shall appear before this court through virtual conference.
That's the interim order, my kindly.
An interim order.
ಇದೆ already. It
You
is
will have to-
enforced, my lord.
You'll have to hand over.
That's the,
In 5 years are over, long ago, and you have continued for another 15 years now.
it was being extended by the respondents themselves.
Because of the pendency of the matter and because of that officer who was in your favor. For 5-year lease, he wants to extend it to 50 years.
But it is in force, my lord.
Request for interim order, extension of interim order is refused. Released on 12th. Respond number 2. Registry Director print the name of Shri BL Sanjeev as that appearing for respond number 2 and delete the name of Shri BL Acharya as that appearing for respond number 2.
Figure number 18.
Appearing for the petitioners, my lord, sir. My lord, sir, these petitioners, my lord, sir, are before this court. That, my lords, on 15/2/2018, there was a collapse of building at Kasavanahalli, Bangalore, my lord, sir. Subsequently, these petitioners are construction workers, my lord. Some of them were injured and some of them died. Their LRs have made applications for grant of compensation, my lord, sir, which was declared at 5 lakhs for dead people and 2 lakhs for injured people, my lord, sir.
ಅದು ಸೆಸ್ ಇದೆಲ್ಲ ಒಂದು ವರ್ಕರ್ ಸೆಸ್.
Yes.
ಅದರಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಬಂದು actually there is a paper publication already having been issued by the department themselves, my lords, sir, at page number 23, my lords.
Yes.
That BBMP is wherein in this the BBMP was supposed to under construction building collapses, 3 dead, 9 trapped, my lords. In this, there was a declaration for payment of 5 lakhs for a dead person and 2 lakhs for injured person.
Yes.
Now, my lords, necessary representations have been continuously made, and they also asked me to file certain documents, my lords, which have been done accordingly. But since from 2019, communications are there. 2020, this petition came to be filed. Till date, my lords, no payment has been made.
5 lakhs ಕೊಟ್ಟಿಲ್ಲ.
ಏನು 5 ಪೈಸಾ ಕೊಟ್ಟಿಲ್ಲ. 5 ಪೈಸಾ ಕೊಟ್ಟಿಲ್ಲ, and I am completely in distress.
ಲಕ್ಷ ಅಲ್ಲ, 5 ಪೈಸಾನು ಕೊಟ್ಟಿಲ್ಲ.
ಇರ್ಬೋದು. Instead of Puttegowda, my lord, somebody else may be directed.
No,
ಇಲ್ಲ,
ಪುಟ್ಟೇಗೌಡ.
when the matter is getting dodged, my lord, say mandamus. ಅದಕ್ಕೊಂದು I'm sorry, my lords.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Somebody else may be directed.
Number of matters are, there are 9,000 matters before this court. ದಿನಕ್ಕೆ 100 matters list ಮಾಡಿ without repetition ಅಂದ್ರೆ it will take 90 days. Working days ತಗೊಂಡ್ರೆ it will take around 6 months for them to be listed without repetition.
I certainly understand the burden of this court, but
No,
court
it's not a
people,
burden.
they did not have
It's not a burden, it's a practicality.
BBMP maybe.
Pawan Kumar. The Pawan Kumar is directed to accept notice for respond number 2 and 3. Registry is directed to print his name as such and delete the name of Shri K.N. Puttegowda for respond number 2 and 3. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures on the said counsel. Shri Pawan Kumar is further directed to obtain instruction, make a submission as to whether any payments have been made to the petitioners. If so, with accompanying details. If not, with reasons as to why the same has not been paid. Relist on 12th at 2:30 PM. Sir, Madam.
Much obliged.
19, Ranganath Act.
Permitted to,
You're appearing for the petitioner.
I may be permitted to appear.
Yes.
But this is I've suffered an order by the Assistant Commission, Senior Citizenship Act. my lord.
Hmm.
Kindly see the order, my lord.
You
Ink
are the
page. I am the son.
son.
In fact, the parents stay with me.
Hmm.
We stayed in the same house.
Hmm.
Kindly come to ink page 23. Straight away.
17 one way, 5th cross, Gokul extension.
We stay, even as on today, I'm taking care of my parents. We're all, even the cost title, the impugned order at annexure, ink page 18 also.
Again, problem in.
Its problem is my sister, who has come from US. I'll just demonstrate. Ink page 23, man, whether this order could be sustained.
Yes.
In the background of the orders passed by this court shall be subject to final orders which may be passed in OS 88, that is a partition suit which the son had filed against the father, which he has withdrawn now.
Whose property is this?
The property in question belongs to the parents. I am living in my parents' house, taking care of my paraplegic mother. My sister doesn't take care. The remaining part of the house is rented. There are multiple properties to the father, which I'll demonstrate.
Mother is paraplegic.
Madam?
Mother is paraplegic.
Mother is paraplegic.
What about the father?
Father is fine. Father is fine. We are all staying together.
For respondent.
One in on that sentence. Sir.
I'm for respondent 2 and 3.
2 and 3. You are both. Yes.
Kindly see the next line. The petitioners being absolute owners entitled for eviction order temporarily, subject to approval of the above honorable civil court. Further, petitioners are entitled for monthly maintenance of 5,000 each till their death, these observations proceed to pass the order. So he asked me to leave the place. I am paying these 5,000 rupees to each of my parents. That's on record. I had not paid. This court came down very heavily on me. Thereafter, all the balance amounts are also being paid. Now kindly.
How old is the father? 70 years.
May
He can come to court?
May I pass this?
Yes, ma'am.
So he can come to court?
Please, ma'am. He will come.
Keep him present next.
Please.
Keep the petitioners also present. You are the husband and wife. What about the sister is not a party?
Sister is not. They did not make the sister as a party.
Residing at abroad, my lord, whenever.
She's here. She's here. She can be directed to produce. All the properties are going to her. Let's have demonstration.
She is residing at abroad.
ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತು? ನಿಮ್ಗೆಲ್ಲ ಚೆನ್ನಾಗಿ ಗೊತ್ತಿದೆ. You are appearing for.
ಎಲ್ಲ properties
You are
gift
appearing for the sister or the parents?
Parents,
Instructed by the parents or by the sister?
parents only.
Sure ತಾನೆ?
Please.
Sure ತಾನೆ? They're asking you a very pointed question. In these kind of matters,
Please.
the lawyer's role is very important.
Yes, ma'am.
I will present the respondent number 2, please.
When there's already sparks, don't make it into a fire.
Please. May I kindly see, he has filed a criminal complaint, not only police complaint, he has filed a PCR, and PCR regular trial has been faced and he is acquitted.
Against whom? Against whom?
Against the second respondent, father.
Father.
Please.
You filed a complaint
There is a
against
lot
the
of
father.
this thing going on between Ibrahim Karsada Walletso to give a finality to this. To give a finality.
The once you go to a criminal matter, everything goes.
Not only.
ಮುಂದೆ ಎಲ್ಲ ನಡೆಯುತ್ತೆ. ಏಕೆಂದ್ರೆ lawyers can play a vital role in sorting out.
A criminal matter ಹೋಗಿದ್ರೆ ego gets hurt very bad.
Dispose ಆಗಿದೆ, ಏನು ಆಗಲ್ಲ.
ಅಲ್ಲ, ಫೈಲ್ ಮಾಡಿದ್ರೆ ಸಾಕು.
ತಾವು ದಯವಿಟ್ಟು ಕರ್ಸ್ಬೋದು ಸ್ವಾಮಿ, ಎಲ್ಲ ಆಗುತ್ತೆ. ಇಲ್ಲ, I'm ready to argue.
Is the problem we see in senior citizen matters and matrimonial matters.
Yes.
A criminal case ಹೋದಾಗ ego gets hurt so bad that nobody wants to
Fact
settle
that
anything.
I'm taking care of my paraplegic mother
They are
on
not
a
bothered.
day-to-day basis, even as on today.
Ego becomes more important, Mr. Ravi Shankar, at that
True, man.
page and that this one. Criminal andre.
That may get diluted the moment they appear before my lords.
And counsel for the petitioner and respond number 2 and 3. It submitted that respond number 3. Mother is bedridden. Hence, to explore the possibility of amicable resolution, the petitioners, as also respond number 2, are directed to be present on the next date of hearing. Released on 13th December at 2:30 p.m.
Great.
Serial number 20, Manmohan PL.
Last occasion, my lords, lordship had asked me to, my lords, serve a copy on the counsel who appeared for the impleading applicant before the trial court. Lords, I have served.
Respondent number 7.
My lords, I am. Proposed respondent number
Oh,
seven.
this is that Swamiji matter.
Yes, I have filed.
Proposed respondent number 7, my lord.
Thank you for coming. Finally, Bandri. Yes,
File my objections. Paper, page.
and counsel for the so-and-so. Wakalatnama file madilva inna?
Wakalat nanne file ಮಾಡುದು.
The so-and-so submit that he has filed Wakalatnama yesterday. Registry is directed to verify and print his name as that appearing for respondent number 7. In that view of the matter, there would be no requirement to make any payment of any process fee, furnishing copies or taking out and summons in respect of respondent number 7. What about 1 and 2 bandidare?
Everybody now,
Now all
Everybody
of
is
them,
there.
please.
Lord, his matter has been heard, part, my lord, your lordship. Is part-heard matter, my lord. The question formulated by your lordship.
Released on 13th December.
Please.
21.
I'm appearing for the petitioner. May I make one submission in this? Yes. There is one more matter, my lord, is in similar, very same connected matter. Is 25-261 of 2022. It is not connected with this matter. In that matter is all the two matters has to
Connect
connect
the
it.
above matter with WP number 25.
25-261 of 2022.
What is this matter?
No, show cause notice has been stayed by the Honorable Court. That has been challenged. The scope of the writ petition is very limited. Kindly see the interim order passed by this Honorable Court, my lord. The question is whether the person who issued, the authority who issued the show cause notice has the jurisdiction. It has been confined to that.
When was that order passed?
My lord, on 17-2022.
Yavrali?
First order. In the very same writ petition.
3519.
3525.
3525 ಅಲ್ಲ?
ಹೌದು.
3525 and
Only what you read out, we don't see anywhere.
3519.
We don't see that order anywhere. Yavattu date?
My lord, 17-2022.
This is granted on the assertion so and so that has been generated at the hands of some officials named at page 45.
Please, my lord.
And not by the board of authorized, board as authorized by section 11B. That is what has been said. So page 45, who is the person?
Deputy General Deputy General Manager,
ಇಲ್ಲಿ
page number
designation-
30.
Designation ಎಲ್ಲಿದೆ?
In the show, from where it begins. My lord, the
Deputy
notice
General Manager,
begins from
investigation.
page 25, my lord.
It starts from 30.
25 in the show ಆಗತ್ತೆ.
30 in 3525. Deputy General Manager, Investigations Department.
ಹೌದೌದು.
Yes.
My lord, the power, the jurisdiction has been delegated to him. We have placed the delegation order before your lordship.
Page?
Our objections,
Page, delegation order page.
page number 59, my lord. Act. Section 19.
This show cause notice under what provision?
Under section 11B, my lord, of the,
11B of SEBI.
and the regulations.
1114, 11B. Page 59.
Page, at page 50, at the serial number 22.
Number 59, page 22 in the first matter.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ನನ್ನ ಇದ್ರಲ್ಲಿ, I think we are holding different.
351.
Senior is
Anyway,
appearing in
serial
this
number
matter.
22.
519. In any case, my lord, my learned friend,
Senior is appearing in this matter.
he wants a short accommodation. I am not,
Rao is, Mr. Rao is appearing.
Please, my lord.
I am not opposing it, but my.
But ಏನು ಇಲ್ಲ ಇದ್ರೆ. ಯಾಕೆ senior ಏನಕ್ಕೆ ಬರುತ್ತೆ?
Since beginning is my senior is appear.
Interim order ತಗೊಂಡಾಯ್ತು, ವರ್ಷ ಆಯ್ತು.
Investigation is not.
This is 11B is authorized.
At least connect along, ಎರಡು matter ಅದರಲ್ಲೂ ಕೂಡ
But your lordship may kindly see section 19.
Connect
my lord.
WP so and so.
25/261 of
Mr. Rao,
2022.
On behalf of Mr. Rao, this one is being, but ಅವ್ನ್ ಕರ್ಕೊಂಡ್ ಬಂದು ಅವ್ರನ್ನ ಎಂಬ್ರಾಸ್ ಮಾಡ್ಬಿಡ್ರು ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ.
My lord, I have no objection, but let it not be misunderstood by me.
Connect with
We are-
so and so.
We are good friends outside.
That is,
But your lordship may kindly see section.
that is
19.
as soon as you step out of this line, not even out of the door. ಅಲ್ಲಿ ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಕೂತ್ರೇನು ಫ್ರೆಂಡ್ಸೇ.
ಹೌದು.
ಇಲ್ಲಿ ಬಂದವಾಗ ಮಾತ್ರ.
Yeah. My lord, section 19, your lordship may kindly see section 19 of SEBI Act.
SEBI Act.
My lord, which is your lordship is holding which paper book, my lord, of
We are having 3525.
352. Section 19. my lord.
Hmm. General or special? Yes.
The board may by general or special order in writing delegate to any member, officer of the board or any other person subject to such condition, if any.
Yes,
as
Mr.
may be
Naik.
Specified. Delegation power is there. By virtue of that, my lord, this.
DGM and
delegation order has
CGM.
been passed. Because the board, my lord, can't be expected to take into all this, they work as a team.
Connect the above matter with WP number so and so. The interim order was granted on 17/2/2022 on the submission made by learned senior counsel appearing for the petitioner that the person who had issued the show cause notice at annexure A dated 22/9/2021, being a deputy general manager, investigations department, was not authorized to do so. Subsequent to the appearance of the respondent has produced a general order of delegation of powers dated 31st July 2019, issued in terms of section 19,
In the exercise of the powers under.
15 of so and so board is important. Section 19 of the Securities and Exchange Board of India Act 1992, whereunder in terms of CL number 22 thereof, a show cause notice under section 11 capital B could be issued, could be signed and issued by the CGM stroke DGM.
My lord, CGM is approval for issuance of the show cause notice.
Whereunder the CGM
Signing is-
is required to approve, and the signing and issuance of the show cause notice could be made by the DGM. The submission of Shri R.V.S. Naik, learned senior counsel appearing for respondent number 1 and 2. Respondents is that the show cause notice has been approved by the CGM and issued by, signed and issued by the DGM. Approval ellide.
No, approval ಅದು
Approval
ನಾನು
ಇಲ್ಲ.
ಹೇಳಿದೆ ಬೆಳಿಗ್ಗೆ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ.
Approval produce ಮಾಡಿ.
Is directed to place on record a document indicating the impugned show cause notice at annexure A has been signed and issued by the DGM. But however, the approval by the CGM has not been
It
placed
is
on
not
record.
challengeable. Only the issuing is. No, I will
That-
place it.
That will have to be part of
Of
it.
course, we will place it.
Learned counsel for respondent seeks for a week's time to place on record the approval issued by the CGM in respect of the show cause notice. Released on ಯಾವತ್ತು ಬರ್ತಾರೆ?
13th ಆದ್ಮೇಲೆ
13th December.
13th ಆದ್ಮೇಲೆ ಒಂದು
ಆದ್ಮೇಲೆ. Let him appear through VC.
ಅವರು
ಬರೋದೇನ್
ಇಲ್ಲ
ಬೇಕಾಗಿಲ್ಲ.
ದುಬೈಗೆ ಹೋಗ್ತಿದ್ದಾರೆ.
He is going.
Is out of
Released on 18 December.
interim order may be
Interim
extended.
order earlier granted is extended.
Both the matters, connected matters. Much of.
Grateful. In fact, my lord, I was asking my learned colleague, where is the approval?
Serial number 22. Abhishek Kumar.
Memo of retirement.
Second.
Memo dated 17/9/2024 has been filed by the counsel for the petitioner
My lord, I have
seeking
an
permission to retire from the matter.
My lord, I have an objection to that. If the wakalat is seen, it will be noticed that he has appeared without authority. Number one, no objection from so and he has signed it, not the counsel who is allegedly given the note. Secondly, there is a thumb impression said to be of my mother, which is not identified by anyone. She has not been keeping well, and her thumb impression has been misused left, right, and center. In the trial
Well,
court in one of the cases,
This was filed initially by,
P. Anu Chengappa.
first page, don't look at that.
May I
Anu
pass on
Chengappa
the
had filed.
certified copy?
So NOC Wakalatnama was filed by Abhishek MR.
Yes. And kindly see on the left, he says no objection from Anu Chengappa, and he signs. And no objection is raised. We get the signature of a party in English and they raise an objection saying, you have not said in which language it is explained to the party. The wakalat says, where the executant is illiterate, blind, or unacquainted with the language of the wakalat, but that objection is raised. Whereas for this, no objection is raised. The thumb impression on the right-hand side.
The memo, let us see this.
The earlier wakalat, my lord, bears the signature. My application for early hearing takes more than a year to come before the court.
ನೀವು ಯಾರಿಗೆ appear ಆಗ್ತಾ ಇದ್ದೀರಾ?
I am the second respondent.
Second, first petitioner is just see. And who is this Harish M. Fernandez?
Harish is my younger brother who is
Your
behind
brother.
all. He wanted to sell the property. I was the thorn in the flesh, so he manipulated all these.
This petition will go.
My lord, the petition going will not arise. Notice has to go to the party.
No, nobody has appeared, so why should we wait? They've taken the file back on 3/9/24. If nobody appears,
My lord, whether he took the file back or not is again a question mark.
somebody has signed, he has filed it.
Yes, but Mr. Abhishek himself had no authority to give a no objection. The council's name should still be shown as Anu Chengappa, not as.
She is not before us.
My lord,
She is not before us.
true. But her
Objecting.
name is not in the cause list. If her name is shown in the cause list, she'll come.
And what, she'll continue the matter.
I don't know.
Do you want the matter to be continued?
My lord, there is a clear finding here that Harish Fernandez has set up his mother because he wants to dispose of the property with vacant possession.
Listen, today we'll dismiss it. Or you want us to print the name of Ms. Anu Chengappa and list it again for
My lord,
consideration?
either that way or notice to the petitioner.
Why should we issue notice?
Because
Nobody has appeared.
My lord, may I put it this way? What has been happening is they're misusing her thumb impression all over the place. If she appears before the court and the court asks her whether she has voluntarily put it or not, I'm sure your lordship will know the answer.
She is mobile?
Yes, my lord. She was produced in the trial court in another case.
Who is she staying with?
They say she is in an old age home in Pothanur, but they refuse to say where she.
But both your addresses are shown to be the same.
Correct. She is no longer.
She is no longer staying with you.
Because she was removed from there by my brother. And what council has done is nothing short of a fraud on the court. Again, kindly see the cause list, my lord. I have here a certified copy of Form C which has been issued.
Hmm.
The cause list shows that my application is still pending to appear as party in person. I apply for certified copies. After a year, they're not ready. I have to move the registrar judicial and get the copies.
Okay.
Serious things are happening here.
Why is that happening in this matter like that? What is so special about this matter for that kind of
My lord,
allegation?
in all the matters which are pending now, where this council has appeared,
Hmm.
mysterious things have been happening in all the cases.
Who is this counsel?
One Mr. M.R. Abhishek. In a writ appeal, he files a wakalat exactly like this, without even accepting the wakalat. No objections. Application for early hearing was filed in September of 2023. And if your lordship were to look at it, you would see that I have sent a copy to him.
Hmm.
They refused to send it to the board branch without. The file goes back from the board branch in two parts. One part to the pending branch and the other part to the scrutiny. If they're doing this
Issue
to an
court
advocate,
notice
what would they do to them?
to the counsel appearing for the petitioner. The registrar judicial is directed to issue notice at the mobile number as also at the email address mentioned in the wakalatnama and the presentation sheet, indicating the next date of hearing as 13th December, released on 13th.
Okay.
Registry is also direct to print the name of Ms. P. Anu Chengappa as that appearing for the petitioner.
Serial number 23. Rajendra Iyer.
Okay, for the rest.
Yes.
Annexure,
ready?
yes, my lord. Annexure A, page number 17. This is the order passed by the DRT on the dead person. The third respondent herein, Moinuddin, is a dead person.
A dead person.
Yes, on the dead person, this award is passed and his death certificate is also submitted here, my lord, which is in page number. Page number.
39, Annexure F.
Yes. Once. It is
You
the
were-
annexure.
You were a
F.
party before the DRT.
Only the second, the Devidas Rangadal, he was in
And
jail.
Girish also.
He was in jail. And Girish B. Rangadal only
Respond
represented.
number 1 is Devdas, respond number 2 is Girish.
Girish, yes.
Both of you were party.
Yes.
Defend number 1 and 2 in TA number
Yes.
966.
Moinuddin expired on 23/12/2015 itself, annexure F, page number 39. Annexure F, page number 39, my lord.
Respond, defend number 1, 3 and 4 were placed ex parte.
Yes. So one is.
Expired on?
He is expired 23/2/2015 itself.
22/3/2015.
23/2/2015. Page
Even
number
before
39.
filing of this.
Yes, my lord.
Yes.
So.
Number?
Page number, this annexure F, page number 39 is a death certificate.
39.
The defend number 3, 23/2/2015.
Yes.
And the defend number 1, now who is the petition number 1 here? He was in jail from 2013 on, from 2009 onwards. That also I narrated, my lord, in my pleadings. Page number 7, my lord. Page number 7.
The defend number 2 had appeared.
Yes, only defend number 2 appeared.
Number 2 had appeared.
Yes.
Did he bring it to the notice of the court about these two?
Yes,
files?
sir.
Where did he, where and?
So,
When and how did he bring
The
it to?
counsel on record who was representing earlier, though he has submitted an ex parte order has been passed, there is no contention was made. Kindly, order may be.
Mr. Rajendra, question
my
is
lord.
simple. Did defendant number 2 in that proceedings, who is petition number 2 here,
Yes, my lord.
place on record that defendant number 1 was incarcerated and defendant number 3 had expired?
Yes, my
If so, how did he place it on record?
1, 3, and 4 remain absent and place ex parte. That is the order passed by the
Yes.
DRT. Those respondent number 2 has appeared. There is no whisper or liable to pay so and so. When defense were called out, only defendant number 2 appeared through his counsel, but in spite of sufficient written statement has not been filed. It means that only wakalatnama has been filed. Subsequently, the defendant number 2 never appeared, nor the counsel represented the case.
So it is just lookout.
Yes, my lord. Then,
My lords, one submission, I'm sorry to interrupt, one submission, my lords. As against this order, my lords, a miscellaneous application was filed for.
Let me complete, my lord.
That
no,
has
if I am
been
misleading the
dismissed.
court, no, I am misleading, no, everything I brought on record.
That has been dismissed and that order is not.
Everything has been brought on record. My lord.
Your shouting won't help.
No, I'm sorry, man. I apologize for that.
He can also hear on a speaker.
No, because he should not interpret.
ಇಲ್ಲಿಂದ ಅವ್ರು ಎಲ್ಲಿ ಕೂತಿದಾರೋ ಅಲ್ಲವರೆಗೂ ಕೇಳಿಸ್ಬೇಕು ಅಂದ್ರೆ ಬೇಕಾಗಿಲ್ಲ. ಮೈಕಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅವ್ರ ಸ್ಪೀಕರ್ ಅಲ್ಲಿ ಕೇಳತ್ತೆ.
No, my apologies.
ನಾವು ನಿಮ್ ಮುಂದೆನೆ ಇದೀವಿ ಕೇಳತ್ತೆ.
With you, my apologies, my. Here ಏನಾಗಿದೆ ಅಂದ್ರೆ.
Yes.
Miscellaneous application was also filed, which I have narrated.
I haven't answered our question.
Yes, my lord.
Did defendant number 2?
Yes, my lord.
Bring it to notice of the court?
Yes, my lord.
That defendant number 1 is incarcerated, is in jail, judicial custody, whatever.
After filing Vakalatnam, no written statement has been filed.
Why did you not do
He
it?
has not produced it.
Why you did not appear?
Your lordship.
You are the second petitioner.
Yes, second respondent here. He is the second petitioner here.
You are the second petitioner here.
Yes, my lord.
So why did you not appear?
No,
Why did you not bring it to notice of the court?
No, we are not making any allegation in my brother counsel. I admit that we are written statement also not filed. The counsel on record has not appeared, not filed this written statement. That is one aspect. Another aspect is when the bank has settled.
ಜೈಲಲ್ಲಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಾ ಹೇಳಿಲ್ಲ. ಇವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಾ ನೀವ್ ಹೇಳಿಲ್ಲ.
Bank is aware about all these facts, my lord. Bank is aware because in Gulbarga there is sensational murder was taken place, which bank also know through paper publication that so imprisonment is prison ನಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಎಲ್ಲ ಗೊತ್ತಿದೆ. Then that is the one more question, my lord. Annexure D, page number 36, my lord. Page number 36.
Yes.
That also agrees with my contention at
In page 36.
amount, page 36, Annexure D, typed copy, my lord.
Yes.
This amount is compromise settlement was made for 41 lakhs. And amount taken deposit 10 lakhs. The balance 31 lakhs to be repaid by you within 1 month. As per RBI guidelines, minimum 12 months should be given for and 3 months moratorium period will be given.
It was in the year 2010.
Then, in case of delay, bank would charge so and so.
2024.
I have deposited everything which the bank has also endorsed, which bank is also endorsed at page number, my lord, 50, Annexure K. Annexure K, page number 50. Annexure K, page number 50. 41 lakhs rupees. There is a delay.
2,80,000 was left out.
Yes. ಈ 2,80,000 rupees balance ಇದ್ದಾಗ in 2012 ನಲ್ಲಿ ಇದ್ದಾಗ the bank has filed
Total amount payable 8,38,555.
total 2,41,2,80,694 left.
Page 51, net amount payable.
ಇಲ್ಲಿ ನೆಟ್ ಅಮೌಂಟ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಬುಕ್ ಬ್ಯಾಲೆನ್ಸ್ ರಿಕಾಲ್ ಮಾಡಿದ್ದಾರೆ. OTS ಸೆಟಲ್ಮೆಂಟ್ ನ ರಿಕಾಲ್ ಮಾಡಿ ರಿವರ್ಸ್ ಮಾಡಿ ಈ ಅಮೌಂಟ್ ನ 6 lakhs amount they have included, which is a cash credit limit which is barred by limitation, that is not included in the OA.
This was issued in the year 2012.
12. ಇಲ್ಲಿ OA ಫೈಲ್ ಮಾಡಿದಾಗ in OA page number 55, last parallel page number 61 ನಲ್ಲಿ page number 61, the amount claimed by the bank, liability 25/1/2016 ನಲ್ಲಿ 31 lakhs 27 and 58,000 so and so, total amount claimed is 31,86,000 rupees. When the balance outstanding stood at 2,85,000 rupees, after making payment of that amount, the bank in their one-time settlement ಹೇಳಿದ್ರೆ para number 4 ಅಲ್ಲಿ, page number 36 ನಲ್ಲಿ, in case of delay, the bank would charge rate of interest as per loan agreement. In contrary, serial number 5 ನಲ್ಲಿ, the whole amount is not repaid within the prescribed period.
Counsel,
The
you
bank
should have
reserves the
argued
right.
all these things before the DRT, where you chose not to.
No, DRT
ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು argument ಮಾಡೋದು.
ಇಲ್ಲ contest ಮಾಡಿಲ್ಲ ಇವಲ್ಲ ಶಿವ. This is not expert.
ನಿಮ್ ಮಾಡಬೇಡ ಅಂತ.
ಅಲ್ಲಿ contest ಮಾಡಿ.
ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಲ್ಲ ಹೋಗಲ್ಲ.
ಅಲ್ಲ ಇಲ್ಲಿ ಅಪ್ಲಿಕೆಂಟ್ ಇದ್ದಾರೆ ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಮಾತ್ರ ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಆಮೇಲೆ ವಕಾಲ ತೆಗೆದು ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಐ ಆಮ್ ನಾಟ್ ಮೇಕಿಂಗ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್.
ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವರಲ್ ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಕೊಡ್ತಾರೆ. Don't try to take advantage like this.
No, you will on the death person one though. Second one 41 lakhs rupees when I have deposited,
Yes.
which bank has accepted it. Now they are claiming 67 lakh, but and miscellaneous application also I have filed. A miscellaneous application when I filed my lord, that also I have narrated page number 10 my lord.
Yes.
Page number 10 nalli, 23 nalli I have filed my miscellaneous application. I issued the notice to the respondent bank to appear on 4/2/2028, 11 a.m. and further submit that in view of the COVID-19, the council or any other person were not, and restrictions were imposed by the Honorable DRT Bank, and also the learner presiding officer was also on leave on 4/2/2020. The matter got posted to 2/6/20. On that day, the Honorable Tribunal order for reissued notice.
4/2/2020, there was no COVID.
Allah, learner presiding was also on leave, 4/2/20. The matter got posted to 2/6/2020. On that day, the Honorable Tribunal order for reissue notice by RPD and posted the matter on 16/9/2020.
The council, this is a fraudulent assertion made. 4/2/2020, you are saying due to COVID-19, council was not allowed.
No.
When did COVID-19 start?
23, the notice dated 23/9/29 informed the respondent to appear.
27th March was the notification, not on 4/2/2020.
No, notice was sent on 23/9/21 informing the respondent bank to appear on 4/2/20.
ಹೌದು, ಅದಕ್ಕೆ and further submitted that in view of COVID-19, the council could not appear on 4/2/2020. Is this a submission that you will make?
No, 4/2/20 ನಲ್ಲಿ they have appeared. Acknowledgement ತಗೊಂಡಿದ್ದಾರೆ bank, they have received the acknowledgement. Again, it was reissue ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದಾಗ second time reissue ಮಾಡಿದಾಗ we did not reissue ಮಾಡಿದ್ವಿ.
Where is the order sheet?
And the memo, order sheet will produce my lord.
Order sheet ಅಲ್ಲಿ.
Yes, order sheet will produce, but memo ಹಾಕಿದ್ದೀನಿ lordship.
Order sheet ತೋರಿಸಿ.
Yes, my lord. I will undertake to produce the order sheet also. And for that, I have filed a memo before the court also, my lord, stating that office submission has also been completed and the same may please be taken on record. The page number, my lord, 66, page number 67, typed copy. Page number 67, 67. It's the handwriting, 67 typed copy. This is a typed copy. But the court, my miscellaneous application got dismissed for non-prosecution. But office submission, everything I have complained. Dismiss or default ಅಂತ ಇದು ಮಾಡಿದ್ರು. Then I
order sheet ಎಲ್ಲಿದೆಯಪ್ಪ?
Order sheet I'll undertake to produce my with certificate copy I will produce my lord.
So not only annexure A which you have challenged here, but the miscellaneous file as regards annexure A has also been dismissed.
Dismissed for non-compliance, but we have complained. But notice ಮಾತ್ರ issue ಮಾಡಿಂತ ಬಂದಿದ್ದಾರೆ.
As regard that dismissal, you are not challenged here.
That order not challenged because of subsequently that I did not press this miscellaneous application. I filed challenging the main order, original application order.
It's already challenged.
Here before your lordship. That miscellaneous application I have not challenged. This is dismissed for default non-prosecution. But I approached the Honorable High Court.
Challenge that before us, you'll have to go before DRAT.
No, 41 lakhs when they already received. Only for 2 lakhs rupees.
Forum is DRAT, not us.
No, your lordship, here when they have agreed for to settle one-time settlement for balance 2 lakhs rupees, how the bank can file 31 lakhs rupees and now they are claiming 60 lakhs rupees as per their own agreement.
You produce the order sheet.
Yes,
what
my
you
lord.
are saying here is all not correct.
Yes, my lord.
Please decide what you want to do.
Yes,
to
my
face a adverse order and take into consideration those things, or you want to go to DRAT. Your DRAT go back.
No, that
We
I,
don't have jurisdiction over this.
but 41 lakhs.
We
rupees-
don't have jurisdiction in law. Jurisdiction ಇದೆಯಾ ನಮ್ಗೆ? ಏನೋ ಮರ್ಸಿ ಪೆಟಿಷನ್ ದುಡ್ಡು ಕೊಡಂಗಿದ್ರೆ ಹೇಳಿ, ಅವ್ರಿಗೆ ಹೇಳೋಣ.
That 2 lakhs rupees, what they are claiming, that interest, as per agreed terms, I am ready to pay.
ಒಪ್ತೀರೇನ್ರಿ?
I am agreed to pay, my lord. Not 70 lakhs rupees, my lord.
ಒಪ್ಪಲ್ಲ ಅಷ್ಟೇ. ನೀವು ಅಂತದ್ದು ಇಟ್ಕೊಂಡು ಬಂದ್ರೆ ಆಗಲ್ಲ.
Alla, 60, 70 lakhs.
They have
are claiming.
participated in the recovery proceedings. They have filed objections also there, my lord. They are contesting there.
They are taking advantage of that, that's all.
No, your lordship, 2 lakhs, they are claiming 60 lakhs rupees.
Mr. Counsel, if they are going to make any reasonable payment.
Yes, but 2 lakhs, whatever the interest they are going
ಅದು
to.
ರಿಜೆಕ್ಟ್ ಆಯ್ತು ಅವರು.
ಯಾವುದು?
ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅದು ಇಲ್ಲ, ದೇ ಆರ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟಬಲ್.
ನಮಗೇನು ಕರೆಸ್ಪಾಂಡ್ 2 lakhs.
ಇವಾಗ ಹೇಳಿದ್ದು ಅವ್ರು ಇಲ್ಲ ಬೇಡ ಅಂದ್ರು.
2 lakhs ಬೇಡ.
ನಿಮ್ಮಷ್ಟು ಜೋರಾಗಿ ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ. ರೀಸನಬಲ್ ಫಿಗರ್ ಕೊಡಿ, ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್. ವಿ ಕ್ಯಾನ್ ಟೆಲ್ ಹಿಮ್ ಆಲ್ಸೋ. ನೀವು ಅದು ಬಿಟ್ಟು ಅಲಿಗೇಷನ್ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಇನ್ನು ಮರ್ಸಿ ಪೆಟಿಷನ್ ಆಗಲ್ಲ.
No, one more submission. 6 lakhs rupees, how they
For
are.
what amount will you close it?
My lords, I'll take instructions and submit, my lords.
By next date you submit.
Yes, my lords, I'll take
If they are
instructions.
willing to, we'll see if we can close it.
Yes, my lord.
Otherwise,
I
they'll
can
have to
make
go to
that
the hearing.
submission.
I also undertake to produce the order passed by the DRT.
All those are irrelevant. This is a mercy petition. We don't have jurisdiction. Only for mercy we excise. Otherwise, all these petitions have to be dismissed.
No, your lordship, I am grateful to your lordship because 2
Like-
lakhs ಗೆ 60 lakhs rupees claim ಮಾಡೋದ್ರಲ್ಲಿ.
Like there's a circular issued in another court that don't post these matters anta.
No, your lordship.
There's an order passed in another high court saying that these matters where these are challenged should not even be accepted.
Your lordship,
number.
your lordship.
ಇಲ್ಲಿ ಮರ್ಸಿಗೆ ಇದು ಮಾಡ್ತಾರೆ, ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ತೀರಾ ಅಂತ ಹೇಳಿ ರೀಸನಬಲ್ ಆಗಿ ಮಾತಾಡಿ ಅವ್ರ ಹತ್ರ.
Please, my
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬಂದಲ್ಲ ಹೇಳೋದು, ಇಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ.
Please, my lord.
If you are reasonable and both of you agree, we'll facilitate that.
Yes, my lord.
If not, this is not sustainable.
Highly obliged.
Released on 6th December.
That's all.
24. If they settle.
Hearing for the respondent, my lord. I will tell Monday, my lord, senior is out of question.
Amount, ನೀವು ಯಾರು petitioner ಗೆ respond?
I am the borrower. In fact, what had
You
happened.
paid the money?
My lord, what had happened, my lord, one-time settlement has offered.
ಅಲ್ಲ ಈ conditional order you have
Okay,
satisfied.
I paid.
Conditional
In
use.
fact, I'm not. My lord, I'll just point out, my lord, only one document.
Good to see you on this side.
So nice.
ಈ ಕಡೆ ಬಂದವಾಗ ಗಲಾಟೆ ಮಾಡ್ತೀರಾ? ಇವಾಗ ನಿಮ್ಗೆ ನೀವೇನೇನ್ ಗಲಾಟೆ ಮಾಡ್ತೀರಾ ಅದೇ ನಾವು ಮಾಡ್ತೀವಿ.
Illa, it is not, my lord, my lord, I have a case before this one. What had happened, my lord, kindly come to page number, my lord, 24.
That is what every litigant feels that they have a case. So, ಏನಪ್ಪ, not well. I submitted that the counsel for respondent is unwell. Released on 12th December.
Paid from interim order is up.
Interim order earlier granted and extended.
25. Here Lakshmipati Reddy.
Yes, Mr. Reddy?
Last time I learned this
Valuation report.
valuation point. In fact, I just inquired about 2 sale deeds, I got it.
ಕೊಡಿ.
So no, the notification is 2005, my lord. 2004 notification, one sale deed is for a works out at 277 square rupees per square feet. Another sale deed, it works up to 750. Anyway, these sale deeds have not been produced. In fact, even the land acquisition officer, of course, before the land acquisition officer, no documents received from the petitioners. They based on the revenue inspector report, they passed that order granting 35 rupees per square feet. Then against that appeal was prepared, DC awarded an answer to 100 rupees, my lord. Again, they went on appeal and it has been remanded back. See, in the remand, 65 rupees has been fixed. And that has been challenged. Anyway, it's a national highway, my lord.
ಎಲ್ಲಿದೆ? Where is this property of the sale deed that you have?
It is just in the national highway after Chikballapur, just adjacent Bagepalli.
Nimma property is 15/1 Gantramvarli Palli, Kasba Hubli, Bagepalli.
In the just high. ಅದು same village, Milan, both side deeds. Adjacent to the road only, highway.
Ravolipalli 328/8. House list number. ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಇದು? $321 house list number. ಇವಾಗ ಎಷ್ಟು ನಿಮ್ಗೆ 100 rupees ಕೊಟ್ಟಿದ್ದಾರೆ?
100 rupees ಕೊಟ್ಟಿದ್ರು, ಅದ್ರ ಮೇಲೆ ಹಾಕಿ ರಿಮೈಂಡ್ ಆಯ್ತು. ಅವರು ರೆಡ್ಯೂಸ್ ಟು 65. ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡಿಸ್ಮಿಸ್. ನೌ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್
reduced to 65. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ರೀಕಾಲಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯೂಸ್ ಮಾಡ್ತಾರೆ.
This sale did show higher, much higher amount.
I have to take, and also national highway notice.
And AG accepts notice for respond number 1 and 2. Notice to respond number 1, 2 and 3. Shri R.V. Nayak accept notice for respond number R.V. Nayak alla? Ms. Shilpa Shah is directed to accept notice for respond number 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsels. Yes, released on 13th December.
Final hearing, serial number 26.
Petitioner.
Ashadi Joshi.
And for the respond number 1 and 2, madam.
Lord has given some directions to the.
Received instructions. Ready?
Yes, I received instructions and I filed the synopsis also yesterday.
We'll take it up in the afternoon. 2:30 or 1:30 ಆಯ್ತು.
ಅದೇ ಕರೆಕ್ಟ್ 2:30 ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಯಾವ್ದಿದೆ ಬೇರೆ?
ಇವತ್ತು
List number 2.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇದೆ. ಅದು ಬರೀ 7 ಮ್ಯಾಟ್ರ್ ಇದೆ. ಆಗೋಗುತ್ತೆ. ಅದಾದ್ಮೇಲೆ ಇದು ಬರುತ್ತೆ.
ಆಯ್ತು.
27.
ಆಫೀಸರ್ ಪ್ರೆಸೆಂಟ್.
ಬೇಕಾಗಿಲ್ಲ, ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದ್ರೆ ಬೇಕಾಗಿಲ್ಲ.
ಇದೆ ಆದ್ರೂ ಆಫೀಸರ್ಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್.
ಯಾರು ಆಫೀಸರ್?
3 ಜನ ಅದು.
3 ಜನ.
3 ಜನ. ಲಾ ಆಫೀಸರ್, ರಿಕವರಿ ಆಫೀಸರ್, ರಿಕವರಿ.
ಯಾಕಪ್ಪ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಲ್ಲ ನೀವು ನಿಮ್ ವಕೀಲರಿಗೆ?
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟೈಮ್ ಸರಿಯಾಗಿ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟೈಮ್ ಸರಿಯಾಗಿ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟೈಮ್ ಸರಿಯಾಗಿ ಯಾಕೆ ಕೊಡಲ್ಲ? ನೀವು ಟೈಮ್ ಸರಿಯಾಗಿ ಕೊಡಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಕರಿತಾನೆ ಇರ್ತೀವಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲೇ ಬೆಳಗಿಂದ ಸಾಯಂಕಾಲದವರೆಗೂ ಕೂತ್ಕೊಳ್ಳಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
27.
27.2 minutes.
My lord, 27.2, my lord.
The central government council.
My lord, I am for the respond number 4 and 5.
ಅವರು ಅದೇ ಹೇಳ್ತಾರೆ. 27.2. Yes, Mr. Shivkumar.
My
lord,
he
I
has
was
filed
not
a
keeping well.
counter. He
My lord,
told
I
me
could
that
not
the
hand over the
counter-
objections.
Oh, ಅಲ್ಲಿದ್ದಾರೆ.
My lord, I was not keeping well, my lord. I could not hand over the objections to the senior counsel, my lord. So a short date may be given, my lord. I'll share the objections with the learned senior counsel.
ಇನ್ನ objections ಕೊಡ್ಬೇಕಾ?
Objections I filed, my lord. A copy has to be served on them, my lord. I'll serve the copy on them.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ 27.2 ಅಲ್ಲಿ ಮಾತ್ರ ಇದ್ದೀರಾ ಶಿವಕುಮಾರ್?
House
ಬೇರೆ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
Only 20.
What about the other?
27.2.
Mine is 27.1. With the objections.
They have filed objections. 27 in 27.2. The counsel for respond number 10 submits that he would be filing the statement of objection.
He told me he has already filed, but
File
copy
ಮಾಡಿದ್ದೀರಾ
was not.
Mr. Shivar?
Already filed, Swami. We have filed.
Has already filed a statement of objection, copy thereof would be furnished to the counsel for the petitioner in 2
Mr.
days. time.
Srinivas.
Released on 13th December.
Much obliged.
Interim order to continue.
Interim order earlier granted is extended till next.
Serial number 29, your lordship.
Yes.
For respondent, my lords, objections to.
Lord, I appeal to the petitioner.
Objections are ready, my lords. I'll serve it and file it.
29 date was fixed, man.
29.
You are opposing.
Yes, because
Objections are
You are
ready.
opposing adjournment.
the reason is, I'm not opposing in this, yes. Last
Opposing ಅಂದ್ರೆ ಅವ್ರು reason ಕೇಳಲ್ಲ.
2:30.
Also, if a copy may be served, the object.
Copy.
Filing objections.
ಕೊಡಿ.
There is already an order by the Honorable Court. You have to file objection before 23rd, otherwise it will not be taken ಅಂತ ಬರೆದಿದೆ ತಾವು. ಅಲ್ಲ,
ಕೊಟ್ಟವಾಗ will take it as not.
ಅಲ್ಲ, ಆಮೇಲೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಕೊಟ್ಟು ಕಾಪಿ ಕೊಟ್ಟು ಮಾಡಿದ್ರೆ ನಾವು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ಬೋದು.
ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಅದಕ್ಕೂ ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತೆ.
ಹೌದು, ಮತ್ತೆ ಕಾಪಿನ ಕೊಡ್ತೀನಿ ನಾನು ಹೆಂಗಾರ್ಗೆ 2:30 ಲಾಸ್ಟ್.
Madam, none of your copy. Yes, none are referred.
1531.
Yes, both I am for main and.
This thing I have already filed. This thing I'm filing.
Yes, please. Corrected. Okay. I don't have to write a receiving.
ಇಲ್ಲ ಇಲ್ಲಿ you sign for receipt.
$230.
$38 adjourn ಆಗಿದೆ. 38 adjourn ಆಗಿದೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 38 adjourn ಆಗಿಲ್ಲ. ಬಿ ಗ್ರೂಪ್ adjourn ಆಗಿದೆಯಾ? ಇದೆಯಾ?
ಇದು ತಗೋಬೇಕು. 38 ಇದೆ ಸರ್. ಇದೆ.
ರೀಚ್ ಆಗುತ್ತಲ್ಲ?
ಆಗುತ್ತೆ.
61 ಆಗಿದೆ.
61 ಇದೆ. ಹೇಳಿ. ಬೆಳಿಗ್ಗೆ
Last. I'll look at it. Mr. Am I audible?
Court master नहीं है हाथी.
ಓಲ್ಡ್ ಅಲ್ಲಿ ಅವತ್ ಯಾವತ್ತು ನ್ಯೂ ಅಂತ ಬಂತು ಆ ಡೇಟ್ ವರ್ಗು ಮಾತ್ರ ಇದೆ. ಯಾವತ್ತು ಶುರು ಆಯ್ತು ಇದೊಂದು 26 ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು ಏನೋ ಆರ್ಡರ್ ತಪ್ಪಾಗಿದೆ ಅಂತ. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ ಸಾಕು, ಯಾರಿಗಾಗಿದೆ ಅಂತ ಅವ್ರ ಹತ್ರ ಕಳಿಸ್ಬಿಡ್ತೀನಿ. ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಅದನ್ನ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. ನಾನಿರ್ಲಿಲ್ಲ, ಅದೇ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಅದಕ್ಕೆ. ಯಾರು ಇನ್ಸಿಯಲ್ ಹಾಕೋರ ನೋಡಿ, ಈಗ ಇದನ್ನ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ. ಆರ್ಡರ್ ಏನೋ ರಾಂಗ್ ಆಗಿತ್ತು, ಅಪ್ಲೋಡ್ ಆಗಿರೋದು ರಾಂಗ್ ಅಂತ. ಆರ್ಡರ್ ಅದೇ ಅಲ್ಲಿ ಬಂತು, ಬೇರೆ ಏನೋ ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ್ರು. CS ಇತ್ತೇನಮ್ಮ 230ಗೆ. ಎಜುಕೇಶನ್ ಇದೆ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ. ಹಾಕ್ತೀನಿ ಹಾಕ್ತೀನಿ. ನನಗೆ ಕೊಟ್ಟರು.
Court master, am I audible?
Yes, sir.
Am I audible?
Audible, sir.
Thank you.
ಕಲಬುರ್ಗಿನ ಆಫೀಸರ್ ಪ್ರೆಸೆಂಟ್ ಗೊತ್ತಿಲ್ಲ.
ನಮ್ಗೆ ಟೆನ್ಷನ್ ಅಲ್ಲಿ
ನಾನಾ?
Why am I not appearing? No? Full screen करूं? Why am I not?
ಸಪೋಸ್ ಒಂದು 20 ಕಮ್ಮಿ ಹಾಕಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಆ 20ಕ್ಕೆ 40 ಜನ ಬರ್ತಾರೆ ಇನ್ಸಬ್ಮಿಷನ್ ಬೇಕಿತ್ತು ಬರ್ಲಿಲ್ಲ. ಅದನ್ನ ಯಾರು ಹೇಳ್ಕೊಂಡು ಅದನ್ನೆಲ್ಲ ಮತ್ತೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಅದಾಕು ಇದಾಕು ಅಂತ ಹೇಳೋದು ಯಾಕೆ ಎಲ್ಲ ಬಂದಿದೆ. ಅದನ್ನ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಅದಕ್ಕೆ ಯಾವ್ದು ಏನು ಹೇಳಕ್ಕೆ ಹೋಗಲ್ಲ. 4 ಗಂಟೆ ಜಾಸ್ತಿ ಇದೆ.
Have you informed the petitioner?
Lordships may recollect, the state government had to apprise the Lordships about the status of the investigation. In fact, our prayer was to transfer the investigation to the CBI. I also mentioned the last date that there seems to be some progress and the interim order was modified. Now, the state government can inform your Lordships what is happening.
We'll take it up when it reaches.
Whenever.
Not right.
No.
Yes. We'll consider their.
Dharwad bench matter. Serial number 1.
My lord, I appear for the respondents, my lord.
Yes.
Complaints report was filed on 20/11/2024, my lord.
2011-2024.
This is
Through a memo, it is filed, my lord.
The memo
All the
dated-
items are not made available to the public view, my lord.
The memo dated 19/11/24 has been filed. Enclosing the letter of letter dated 14/11/2024 addressed by the Principal Secretary, Minority Welfare, Hajj and Waqf Department. Based addressed to the Director, Minority Welfare Department. The submission of the learned Additional Advocate General is that all the details which are listed at CL number 1 to 16 in the said letter are now available for public consumption on the KPP portal, e-procurement portal of the KPP. His submission is taken on record, compliance being complete, petition is closed.
Please, my lord.
Kalburgi bench matters. Serial number 1, Ravi B. Patil.
So I appear for the respondent.
Yes,
There is a general direction in para number 20 of the order, my lords, that is yet to be complied since it requires some more time, my lords.
how much time
Sought
will
for
require, madam?
4 weeks this one. But it needs some more, but I'm
Some more time,
seeking
huh?
4 weeks, yes. Because
CGP submits.
Corporation of Land Tribunal order in the RTC.
Yes. Let CGP submit that the direction at para 20 of the order dated 1st October 2024 are under compliance. Given 4 weeks' time, compliance would be reported. Released on 19th December to ascertain further progress.
Yes.
So far as this petitioner is concerned, lands are already converted.
Yeah.
Any entries in the ROR?
Petitioner is concerned, Mr. Ravi Patil, you don't need to appear.
Please.
Serial number 2, Mantesh Patil.
Lord, in this case, I am appearing for the respondent. My lord, I pray for another 3 weeks time. My lord, we have returned it to the government. Illa, government in the funds like we are waiting. So I'll just consult one more time. My lord, what is the further progress and file further compliance report.
Funds ಇದೆ.
ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಈಗ. We have to collect funds from the government only. Government has to release the funds, my lord.
ಇಲ್ಲಿ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದು ಇನ್ನೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್.
ಇಲ್ಲ my lord. KBGNL hatra funds will come from government only, my lord.
That is there on 5th. We'll make mention of your submission.
KNNL, my lord. It is KNNL.
ಎಲ್ಲ ಒಂದೇ.
Please, my lord. Another 2 weeks time, my lord, I'll file.
KNNL, CNNL, all the NNLs are the same.
Now there are no funds, my lord. That's the reason government has to release the funds for everything.
When you appear
Another
in
2
that
weeks,
matter,
I'll
we'll
file.
tell you.
Another 2 weeks time, my lord, I'll file further compliance.
Counsel for respond number 1236 point is granted 2 weeks time to report compliance with the general directions released on 19th December.
Please, my lord.
Further hearing, serial number 3, SB Patil.
Appear, my lord. I have the petition, my lord.
Mr. Vijay Kumar, you will have to speak on the mic so that Mr. Yes.
Please. On 1st October 2024, my lord will please to issue a direction to the state to file a affidavit, my lord. We've done
Methodology of calculation.
Please, my lord.
Yes.
My compliance affidavit is on record, my lord.
It's filed? When was it filed?
18th or 19th. Filed in Kalaburgi.
It was filed on 19th,
Yes,
19th 11.
we have that.
Please. My lord.
Lord,
May I?
You received it, Mr. Jaikar?
Yes, it is.
yes, my lord. In fact, I've also filed an affidavit in reply to the compliance application, my lord.
You have filed it.
I haven't gone through that.
Then both of you are ready to address arguments.
No, I
Yes,
haven't
my lord.
seen the
Yes, my lord.
counter affidavit.
You haven't received the counter?
No, I haven't seen it. Maybe they've served it on the office, Advocate General's office there.
Oh.
Yes, I have.
Mr. Vijay Kumar has not seen your counter affidavit. It's filed on 22nd.
Please, I beg my lord's forgiveness. I do not.
On the
have
last occasion.
any day, my lord.
Learned counsel for the petitioner. It's been Advocate General office, it's been served.
Possible.
Madam, please give a copy of it to the Additional Advocate General. Learned Additional Advocate General seeks fund is granted a week's time to go through the counter affidavit filed by the petitioner to the methodology of calculation filed by the state and make a submission. Relist on ನಾಳೆ ಆಗತ್ತಾ?
My lords, could it be taken up on 10th or 11th?
Twelfth or 13th?
Please.
13th?
Please.
13th, Mr. Jacob?
Yes, my lord. Well, just one more thing I'd like to mention here.
Yes.
My lord's order was very clear. What they had to place on record was the mode and methodology of calculations, which is required to be uh, now, my lord, what they have done is all the documents, and I put it in my affidavit in reply, every document deals with the way they have calculated the bunds. There is not a word about the recalculation or revaluation of the lands. And this is what they had done on the earlier occasion,
No.
when they had given a whole bunch of documents, all dealing with funds. And there is not one document of these documents that they have attached here, which shows anything about either the mode, methodology, or otherwise. So, my lord, I'm ready to go on, but there is no compliance of my lord's
You
order.
can take advantage of it, Mr. Jaikar, if they're not produced.
Yes, my lord.
If his
In
objection
fact,
is
that's what
only
I've
with
taken
regard
in my
to-
reply.
Yes.
If the petitioner's objection is only with regard to the compensation mode, my lord, it's there in the statute. I'll point out the relevant provisions, my lord. So I can do it right now also.
We've been pointed out that.
Please.
Please. The upper limit is what you want to point out.
No, not only that, my lord, the methodology is also provided for there.
Now, have you placed on record only for the bunds
No.
or for the land also?
For the land itself, entire thing, made.
I think you are placed,
Entire thing.
according to you.
Please.
They say it is only the bunds, not,
I will
we have
be able
not
to
seen it.
demonstrate. Illa, illa.
We have not seen it.
In fact, my lords, what they don't want this honorable to go have a look at is, my lords, the maximum limit is prescribed in the statute. Over and above that, once they have suffered an order before this honorable court, they suppress that fact and they make a representation to the Honorable Minister of Revenue. They take the direction from him. Then from there, the records are built up. And I'll be able to demonstrate, my lords, it's because of that suppression of fact that they attained a favorable order in one of the writ petitions as a mandamus. We had
Yes.
challenged the same.
There's earlier dismissal by this.
Yes. Please, my lord. We had wrong, let's get affidavit. my
Take it
lords,
out for
please.
the first time now.
This is not first round. This is certainly not first round, my lord. This is third round.
We'll have it on
Page
12th.
annexure R5, my lord.
You have placed for both the bunds and the land.
Please, my lord. Entire extent.
If not placed, place it. That's all.
Please.
List on 12th, 13th.
Much obliged.
Much obliged.
No, 13th below the 12th.
13 December, Ms. Jacob.
Very well.
Please.
List number 2. Order serial number 1. Rachita Nanaya.
Compliance. From yesterday it came to us. So have you sent a proposal to the state? Have you sent a proposal to the state? You are for the state. But you are saying it is for the state to do it. It's for the government to amend. So have you sent any proposal to the government? Item number Roman 3. You are the state, so you are also. So what are you going to do about it?
The proposal will be good. I'll check with that.
And SCGP seeks for and is granted a week's time to, SCGP has filed a memo enclosing the letter dated 8/7/2024 addressed by the Director General and Inspector General of Police to the Registrar Judicial. Why was it addressed to Registrar Judicial? You are appearing. You can file it. Why are you addressing it to Registrar Judicial? The same is taken on record. He seeks for and is granted a week's time to obtain instruction, make a submission as to whether any proposal has been sent, is under consideration by the government in terms of para Roman 3 of the said letter, released on 6th December.
Serial number 2. K. N. Subba Reddy.
And we passed over, my lords.
Passed over for what?
Lords, they have filed an application under section 86 for rejection of the petition itself. Now, my lords,
Again,
again, saying that I have not duly.
Occasion, your lordship has held while allowing the application for production of the document. That, my lord, my objection is premature. My lord, even after the direction was issued by this honorable court to cure the defects, my lord, they have not cured it in accordance with law. That is why, my lord, I have filed an application now. Because it is for want of complaints under section 81, as well as the order of this honorable court, my lord, that,
so this is IA-10.
yes.
We'll have probably 100 IAs very soon. You have filed your objections.
Lords, we will file the objections, my lords, but please.
File your objections.
We'll file the objections. Yesterday it
The
was.
application that is filed will.
I will file, I'll file.
The head counsel for the petitioner seeks for and is granted.
Week's time, my lords.
Week's time to file the objections to IA-10 of 2024. Objections, if any, by 6th. Relist on 11th.
2 days time, my
Well-
lords. I'll file it by Monday itself,
2 days time to file his objection. Relist on 6th.
please.
Serial number 3. Gautam Chand, collected matter.
Respondents, please, Your Honor. I seek for a week's accommodation to report my further compliance, please. Your Honor.
You're appearing for Mr. Jagdishwara.
With regard to hydrological survey,
Yenaithu.
I have sought instructions orally, my lords. In writing, I have not secured. A week's time may be granted so that I will place the reports.
And the committee is formed. So as the committee met,
I have to seek instructions with regard to that.
counsel for respond number 1, 2, 3 seeks for and is granted week's time to obtain instruction, make a submission. More so as regards any deliberations of the committee and recommendations of the committee. As also any suggestions received by the committee from experts and or the general public. Relist on 6th.
Serial number 4. Gaurav N.
Mr. Gaurav. Received from the extension. Letter of the Chief Judicial Magistrate dated 6/11/2024 has been placed on record. The stating that seeking for extension of time by 1 more month. The Chief Judicial Magistrate is also directed to depute a person to verify the statements made in the letter dated 4th November 2024. The time granted is extended by 1 month. The inquiry report to be submitted by 20th of January.
Serial number 5.
This case, my lord, strict direction to the my lord, deputy registrar. Deputy registrar, my lord, to place before the my lord, registrar, my lord, same officer taken into consideration for inquiries concern, my lord. The order is passed, my lord. Week's time, my lord, that will be produced before the honorable court. Kindly see, my lord, page number 6, my lord.
The 6th one is granted a week's time to
Please,
report compliance. Relist on 6th.
please.
Serial number 6. Tina Kulkarni.
The petition.
For the respondent, kindly permit me to file a memo along with citations, which is covered by the matter is covered by the decision.
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
I received copy.
Yes. Ready?
Yes, ma'am.
Ready?
Yes, ma'am.
ಹೇಳಿ.
My lords, the petitioner appears the examination anatomy paper 1 and 2, my lords, where she gets 25
marks the first evaluation. Whereas after applying for a revaluation or a recalculation, she obtained 31.1 out of 100, and anatomy paper 2, she was successful enough to get 47 out of 100. After recounting or revaluation, she has obtained 38. Now the the overall calculation, she has a difference of 9 marks, my lords. Now the memo which has been given to me,
You are what, RS?
RS,
Seven,
RS,
right?
RS6,
6 or 7?
RS6.
Only 2 evaluations,
Only 2.
nothing more. ಅಷ್ಟೊಂದು judgment ಕೊಟ್ಟಿದ್ದಾರೆ. All the judgments you have produced.
Only she has given divisional bench and the coordinator. It's left to the honorable.
Petitioner is before this court seeking for the following reliefs. The petitioner is before this court aggrieved by the refusal of the respondent university to conduct a third evaluation after the first challenge evaluation reevaluation was conducted. This court has in its judgment dated 13th October 2023 in WP number 11688 of 2023, as also in WP number 8912 of 2024, 19th September 2024 in WP 8912 of 24 and other connected matters, categorically held that after 2 evaluations are done, a student of the RS6 batch will not be entitled for a third evaluation. The said order would be binding on the petitioner also. No grounds being made out, petition stands. ಇದಕ್ಕೆ ಯಾಕೆ ಪೇಪರ್ ಅಷ್ಟು ವೇಸ್ಟ್ ಮಾಡ್ತಿದ್ದಾನೆ?
Bill number 7.
CS sir.
I may be permitted to.
ಇವತ್ತೇನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಯ್ತು? ಟೋಟಲ್ ಮೂಡ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು?
Urgency 50 ಇದೆ. Auction ಇದೆ. It is like.
Big auction. Second we will be taking. Sorry, third. Relist on third.
Regarding the office objection.
At the request of counsel for respond number 2, relist on third. It is made clear that no further adjournment would be granted. Record it.
Office objection.
ಒಂದು ನಿಮಿಷ. Learned AGA accepts notice for respond number.
Okay. Respond on first.
1.
First
Third. AGA accepts notice for respond number 1.
2 and 3.
The Dayanandes Patil who has filed caveat for respond number 2 accepts notice for respond number 3 also.
Please.
Registry is directed to print his name as such. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures on the said counsels. What is your office objection?
Office objection regarding the
Annexure B to E.
annexure A.
Annexure B to E legible copies.
ಅದೇನು ನಾನು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ. That is only award, earlier award of 2017.
You won't refer to it at all?
No.
The counsel for the petitioner submits that you would not be referring to annexure B to E for any purposes. His statement is placed on record. Hence, office objection CL number 1 stands suspended. Annexure A, you know,
Annexure A.
who is Pratika
auction
and
notice.
Raj?
ಅದು ಪೇಸ್ಟ್ ಮಾಡಿದ that I removed it and I produced before this court. ಅದ ಕೆಳಗಡೆ ಟೋರ್ನ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾನೆ ಕೆಳಗಡೆ.
ಇಲ್ಲ, ಅದಲ್ಲ. As per Pratika and Raj not made party to the WP. Who is Pratika and Raj? ಎಲ್ಲಿದೆ?
Daughter.
ಅಲ್ಲಿದೆ ಅಲ್ಲ ಹೆಸರು.
ಇದೆ ಡಾಟರ್ ಅದು.
You don't want her to be a party.
Because ultimately she is also one of the beneficiary of the.
She is also a borrower.
Borrow. Yes. She is also
The
borrow.
order will be binding on her. She's a major.
Now itself I will make.
She's a major.
Major, married.
ನಮ್ಮ ಫೈಲ್ ಮಾಡಿ. Insofar as office objection serial number 2 is concerned, counsel for the petition submits that you would be filing a impleading applicant to bring the left out person as a party to the present proceeding, as also file amended cause title. Pagination to be done from 17.
That is already complied.
Counsel for the petition submit that office objection at serial number 3 has been complied, registry to verify. Relist on 3rd. At the request of counsel for respond number 2 and 3, made clear that no further adjournment will be granted.
Past door matters. List number 1, serial number 2. Prakash T. Hebbar,
Madidara.
Ahmed.
Counsel for the petitioner has carried out the amendment and file Madidara. Filed amended past title. Relist on 12th December.
Serial number 26. Harsha D. Joshi.
For the petitioner, madam.
Yes.
Direction has been given to the respondent to produce the documents indicating acknowledgement. Order dated 30/10/2024.
Yes, Ms. Joshi.
Yes,
Ready?
yes, yes, my lord.
Any document was to be produced? When was the order passed? Some document?
30/10/2024, madam. It is made clear that if no documents are placed on record indicating the acknowledgement of liability on the part of the petitioner.
Yes, Mr. Joshi.
Acknowledgement illa. Acknowledgement illa. But we have produced a document for showing that we have withdrawn the 32 notice on a particular date.
Yes. When did you withdraw the 13-2 notice?
But 2099, 2000
Property was sold.
were sold.
Hmm.
A legal notice came to be issued. Thereafter, notice was issued in 2007. Synopsis, my lord is got it, synopsis. Page number 2, serial number 7.
Synopsis.
It's there, fine.
Yes.
My lord has got it.
Yes.
Serial number 7. Notice under 13.2. Then letter issued for the rejection of reply because they have issued, they have made the reply and we have replied it.
2004, they replied saying it's barred by limitation.
It's only the 11th single judge passed an order, 2583. Then they have filed.
When is the single judge order? What order?
They have filed the writ petition on the ground that alternative remedy.
Yavaga. Which writ petition?
10/6/2009.
Yes, 13-4.
Yes.
Hmm.
Thereafter, the brother of petitioner did filed a suit in OS 763 before the bench
For partition.
for partition. Even though the properties cannot be looked into by the under section 34, which are covered under the under 34 of the SSA Act, Surface Act.
Joshi,
Yes, sir.
2000 you sold a property.
Yes,
You issued a notice on 21/4/2004.
yes,
Replied to it by saying that it is barred by limitation.
yes.
Your limitation period for claiming any money is 3 years.
No,
Then
no, my lord. 62, Article 62, may please. It's a mortgage property. For a mortgage property, to enforce the payment of money secured by a mortgage or otherwise charged upon a immovable property, Article 62,
Limitation.
limitation.
How is 62 attracted, AD? Yes,
It is 12 years, my lord.
to enforce a money secured by a mortgage.
Yes,
You have already enforced the mortgage. You bought the property
No,
for sale in the.
primary security is sold in 29.
Yeah,
In view of the Narasimha case, we have to sell it, the secured property, deposit title deeds. We are under the Surface Act. In view of the Narasimha case, Apex Court.
1999-2000.
Yes, that's
Yes.
the starting date of the,
You have, is there any other property which is available?
yes,
Yeah,
this property.
Property is mortgaged.
Yes,
Early the
for
mortgage
which
sourcing.
I have a, my lord, may please to peruse this documents. That is the reason I called all the officers.
ಇನ್ನೊಂದು mortgage ಇದೆಯಾ?
ಇದೆ ಈ ಪ್ರಾಪರ್ಟಿಗೆ
ಕೊಡಿ. ಯಾವ
my lord, flagged for perusal of the court. ಎಲ್ಲವಕ್ಕೂ ಕಾಪಿ ಇರಲ್ರಿ.
So this property which is available was not sold in
No.
2000. So there's another property available.
Machineries were sold. Primary assets were sold on 29. This is a collateral property which is available in the Coxstone.
Pertaining to scheduled property. 14/3 Coxtown, Bangalore.
Yes, it is available.
ಇದು ಇನ್ನ ಸೇಲ್ ಆಗಿಲ್ಲ.
Is sale ಆಗಿಲ್ಲ. So within 12 years is a period for which
No,
the
once a
apex court-
mortgage, always a mortgage,
Huh?
until it is done.
ಆಮೇಲೆ for this,
Until redemption is done.
yes, redemption, until it is redempted.
But there is no demand notice, man.
You have to redeem. Property ಬೇಡ ಅಂತ ಸುಮ್ನೆ ಕೂತಿದ್ದೀರಲ್ಲ ನೀವು ಬೇಡ.
My lord,
Not the situation.
my lord, there are two.
ಹೇಳಿ.
ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ 2015 ಅಲ್ಲಿ ಹಿಮಾಚಲ್ ಪ್ರದೇಶ್ ಫೈನಾನ್ಸಿಯಲ್ ಅಲ್ಲ ನಮ್ಮ
ಬೇಕಾಗಿಲ್ಲ.
ಗಮನಕ್ಕೆ ಇಟ್ಸ್ ಮೈ
If it
ಡ್ಯೂಟಿ
is-
ಟು ಅಸಿಸ್ಟ್ ದ
If
ಕೋರ್ಟ್.
it is not redeemed, your charge continues to subsist and your limitation
Yes.
continues.
Lord, the thing is, my senior is not in station, my lord, that.
ಇಷ್ಟು ತಾಂದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ.
Thanks ತಗೊಂಡ್ರು.
No, not a chance, my lord. Earlier occasion, the orders towards the respondent to produce some documents, my lords. That's why, my lords. Kindly have it on next week, my lords.
Learned counsel for the respondent today submits on instructions received from so and so or Esser Kotbudi, who are present before this court, that there's a deposit of title deeds made by the petitioner insofar as the property bearing number 14/3, new number 44,
ಆಫೀಸರ್ಸ್
Ramkrishnappa Road, Coxtown, Bangalore 4. This property not having been redeemed, there continues to be a charge, there continues to be a mortgage in favor of the respondents. And it is this security in terms of the mortgage which is sought to be enforced in terms of the notice which has been issued. And as such, you submit that there's the claim of the respondent bank so long as the mortgage subsists.
ಕೇಸ್
The KSFC, respondent KSFC would continue so long as the mortgage subsists.
and even within the 12 years, they have filed one writ petition which came to be dismissed. They have filed a writ appeal which came to be dismissed.
The submission is that.
Further,
similar
they
proceedings-
have filed another writ petition, another notice we have given, for which
ಇದು
they have.
last time ಹೇಳಿದ್ರೆ ಆಗೋಗಿರೋದು.
ಇಷ್ಟೇ
ಇವತ್ತು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇಷ್ಟೇ ಇಲ್ಲ.
Faced with the above situation, learned counsel for the petition seeks for and is granted a week's time to make his submission. Relist on 6th.
Grateful.
ಮಚ್ಚು ಅವ್ರೇನ್ ಬರೋದು ಬೇಡ ಆಫೀಸರ್.
But presence of the officers of the respondent KSMC is exempted for the next day.
Serial number 28 along with 213. Fast.
30 pass over.
Serial number 29. M. Chidanandaya, connected matter.
That's. Was filing my objections, my lords, in 29.1, your lord.
You're filing it now.
Please, I have served the copy, my lords, to them.
ನಾವು ಪೋಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡು ಇಲ್ಲಿ ಕೊಟ್ಬಿಡೋದು, ಆಮೇಲೆ ಅಡ್ಜನ್ ಮಾಡೋದು. ನೋಡಿದೀರಾ?
ಅದರಲ್ಲಿ ಅಲ್ಲ ಅವರು 29.1 ಅಲ್ಲಂತೆ, ನಾವು 29.2, ನಮ್ದು 29.2 ನಮ್ದು. ಇದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಇನ್ನು ಬರೀ 29.2. ಅದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ.
We have engaged a senior counsel, my lords, madam.
ನಮ್ದ್ರಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ. ನಮ್ದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಲ್ಲ. ಅವ್ರದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
In both, in two of your petitions, they have filed objections. In your matter is not been filed.
ನಮ್ದ್ರಲ್ಲಿ
You
ಹಾಕ್ಲಿಲ್ಲ.
don't want to file.
Sir,
ಅಲ್ಲ, ಅದು ಅವ್ರು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಅಪೇರ್ ಆಗ್ತಾರೆ.
Swati Ashok appears.
Yes. ಬರೀ 9 lakhs ಅಷ್ಟೇನಾ?
ಅವರು 9 lakhs rupeesಗೆ 20 crore rupees ನಮಗೆ ಬರಬೇಕು ಅಂತ ವಫ್ನವ್ರ ಡಿಮಾಂಡ್.
ಇವಾಗ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ತಾ ಇದೆ.
ಅದೇಂದ್ರೆ 9 lakhs rupees ನೋಡಿ, according to them, work property has been acquired and 9 lakhs rupees was compensation paid. The Mutawalli given 9 lakhs rupees.
ಇಬ್ರು ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಬರೀ 9 lakhs.
ಅಲ್ಲ, Mutawalli appears, they claim that Mutawalli has given loan to the trust, fourth respondent trust, for construction of the building.
Madam, where is Mr. Malipatil?
My lords, praise for next week, my lords. Kindly have it in the next week, my lords. We have engaged a senior counsel, my lords. She is not available, my lords. Anuradha, madam.
She is not well.
She is not available, my lords,
So
today.
she, in another matter,
Please, my
Anuradha.
lords, Swati Ashok's matter, she appeared.
she
Works
is not well. Some adjournment was taken to week after next.
Date
Matter ಅಲ್ಲಿ
the reason is this, Marat. This is the property was mortgaged to the bank. We brought the property to sale.
counsel is not well.
ಅಲ್ಲ, shortest date ಅಂತ. I am not opposing for any adjournment. She is not
Objections
well.
by respondent number 1 to 3 in 29.2. WP 3732 of 2021 have not been filed. Hence it is taken as not filed. Released on 12th December.
Please.
Interim order earlier granted is
ನಮ್ದ್ರಲ್ಲೂ
extended.
ಅಷ್ಟೇ ಮಾಡಿ.
Serial number 30. Kirisha TR.
I filed it with a memo that the complainant petitioner was not responding to the police notice. But I have placed it on record.
I don't have a copy of that, my lord.
Yes. ಏನಾಯ್ತು ಸ್ಫೂರ್ತಿ?
Stage is only with respect to the statement of the complainant, my lord. The entire investigation is over.
Over.
Only with respect to that, it is better.
ಬೇಡ ಅವರು.
Madam.
I have a submission.
My lord,
But I
my
have
instructions.
submission, the very complaint itself. They have violated Priyanka Srivatsava. Not, they have not approached police.
You are not the petition,
Not
you are
in
not
this
the
petition.
petitioner here, Mr. Balkrishna. You are not the petitioner here. You have
But
to
I am
challenge
fourth
it.
Respondent. I am fourth respondent.
So can we consider your,
Was filed to refer it to CBI for investigation. My submission, my lord, one allegation, 4 FIR, my lord, in 3 FIR in the same police station, 1 FIR Biri police.
we are not referring anywhere.
Please, look, I make.
They're not
I'll
referring
place
anywhere.
it on record.
Now, the Ms. Spurti is saying that they did not come forward to
In
record.
fact,
the
my
statement.
instructions are, we have come forward. I think only some witnesses may be, but be that as it may.
ಅಲ್ಲ, ಕಂಪ್ಲೇನೆಂಟ್ ವಿಟ್ನೆಸಸ್. ನೀವು ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರಿ ಇವಾಗ.
ಇಮೇಲ್ ಕಂಡ ಪ್ರಕರಣ ತನಿಖೆ
ಯಾರು ಬಂದಿಲ್ಲ?
ಮುಗಿಸುವ ಫಿರ್ಯಾದಿದಾರರಾದ ತಮ್ಮ ಮುಂದೆ ಇರುವ ಸ್ವಇಚ್ಛೆ ಹೇಳಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಸಾಕ್ಷಿದಾರ
ಕಂಪ್ಲೇನೆಂಟ್ ಆಗಿದೆ.
ಆಗಿದೆ.
ಸೊ ಅದು ಯಾವಾಗ ಮುಗಿಸ್ತೀರಾ? ಅವ್ರು ಬಂದಿದಾರಾ ಬರ್ಲಿಲ್ಲ?
ಈಗ
last date itself interim order is relaxed, my lord.
Huh.
If this honorable court directs, we will file a charge sheet.
ಬೇಕಾಗಿಲ್ಲ. Stay ಹೋದ್ಮೇಲೆ what is there? B report, C report, charge sheet,
The final report.
final report,
Final report.
final report ಅಷ್ಟೇ.
Yes, sir. Final report.
It could be anything.
Final report.
ನಾವು ಚಾರ್ಜ್ ಶೀಟ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
Final report.
ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಡಿ.
My only request is let this petition be pending, because if my lords were to dispose it of, then 4 years this is dragged on. So let them
ನಾವು
file
file
that.
ಮಾಡ್ತೀವಿ.
Let them file that.
Within two or 3 weeks.
2 weeks.
Much.
Then AGA submit that investigation is more or less complete. Some of the voluntary statements of witnesses have to be recorded, which will be completed at the earliest, and a final report filed given 2 weeks' time.
If at all, after notice also, they will not turn up. Let it be filed within. Later direction will be there for filing that.
ನಿಮ್ಮವ್ರು ಆಮೇಲೆ ಅದನ್ನು ಮಾಡಲ್ಲ, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಆಯ್ತು. 2 ವಾರ
ಅದನ್ನ ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಬಂದಿಲ್ಲ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತೀರಿ.
2 ವಾರ ಆದ್ಮೇಲೆ.
ಅಷ್ಟು ಲೀವೇ ಕೊಡಕ್ಕಾಗಲ್ಲ.
My submission is
ಇಲ್ಲ ಮಾಡ್ತಾರೆ.
not one allegation common in 4 FIR. That may also be taken on.
Let us see what report they file. We cannot instruct them during investigation. Let them file the report.
They dragged on the matter for 4 years. They want to refer it to CBI. Now they have withdrawn their submission. Now the petition has to be dismissed as withdrawn.
ಇವಾಗ ಡ್ರ್ಯಾಗ್ ಆನ್ ಮಾಡಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ. ನಿಮ್ಗೆ if you are entitled for B report, we'll get it filed soon. If you are
Submission is one allegation, 4 FIR. One B report is already filed. That was not challenged. Another FIR.
ನಿಮ್ submission ನೋಡಿದ್ರೆ you are expecting a
Anticipating.
charge sheet to be filed ಅನ್ಸುತ್ತೆ.
Or they are very influential, Martha.
You knew everything more than they knew on the last occasion.
They made a submission that the charge sheet is likely to be filed. And not this date.
Released on 18th December. Great. ಅಷ್ಟೊಳಗೆ ಮುಗಿಸಿ ಅದನ್ನು.
31. P. Prakash.
Peer petitioner. Only pass over, my lord. That's a senior is another.
Pass over.
Serial number 32, adjourn 33.
For the petitioner.
ಅದು book ಬಂತ? Did you get the? ಏನು Mr. 32 adjourn ಆಯ್ತು. ಅದು party in person had come in the morning. He is not well ಅಂತ.
23rd January.
ಅದು ಸ್ಟಾಂಪ್ ಆಕ್ಟ್ ಬಂತ?
Stamp act. My lord,
ಹಳೆ ಸ್ಟಾಂಪ್ ಆಕ್ಟ್ has on. ಇವಾಗದಿಂದಲ್ಲಮ್ಮ, ಹಳೆಯದು ಬೇಕು. When was the transaction, Mr.?
93, 96, my lord.
21/11.
21/11/1996.
96 ಅಮ್ಮ. ಹೇಳಿದ್ದಿಲ್ಲ. ಅದಕ್ಕೆ ಇದು ಬಂದವಾಗ. We had given you the time. ಇಲ್ಲಿಂದ ಸಿಗತ್ತಾ ಇಲ್ವೋ?
ಅಲ್ಲ, I got the material.
ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಅಷ್ಟೇ.
ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವ್ರು 1494 ಕೊಟ್ಟಿದ್ದಾರೆ, but I will like to give.
ಯಾವಾಗ ಕೊಟ್ರು ಅವರು?
ಆ ದಿವಸನೇ. Yeah, my lord. ನೀವು ಕೊಟ್ರಲ್ಲ ಆ ದಿವಸ?
ನಮಗ್ ಕೊಟ್ಟಿಲ್ಲ ಯಾರೂನು.
ಕೊಟ್ಟಿಲ್ಲ. ನೀವು ನನಗೆ ಕೊಟ್ರಿ. Anyway, I will.
The only reason why that got adjourned that day was because that.
I will share it, my lord. I will share it what they have given.
It is there. my lord.
We said either of you can give it to us.
ಅವ್ರು ಕೊಟ್ಟಿದ್ರು.
How was 5E on that date?
Yes,
on
yes,
that
my lord.
date.
Not coming to that.
Undivided interest and
Yes.
building was included. or
Yes,
not?
yes. My lord, coming to that, I'll take your lordships to.
What is the date of your agreement?
21.
Sale deed?
A sale deed is 21/11/1996.
21/11/1996.
21/11/96.
Yes, my lord.
96.
Sale deed at page number 50 to 68, my lord, 68.
Yes. Now, what was this is the amendment
68
in
schedule, maybe.
There is an amendment,
1994.
yes. There is also an amendment, my lord, with the expression first instrument, which is as of 1/4/2010, which I'll produce to your lordships right away.
We don't need 2010. We need it to be as on 21/11/96.
96.
Yes, my lord, yes.
Subsequent amendments, we are not concerned.
Yes,
So as on 21/11/96, this is what was there.
yes.
There's no dispute between both of you.
No, no.
So now we'll have to
It's
see how
1/4/94.
ಮತ್ತೆ 95 ಅಲ್ಲಿ ಏನಾಗಿಲ್ಲಲ್ಲ 96 ಫಸ್ಟ್ ಏಪ್ರಿಲ್ ಅನ್ನು ಏನಾಗಿಲ್ಲ ಬಜೆಟ್ ಅಲ್ಲಿ. So this was continuing to hold force in as on 21/11/96.
Yeah, but only thing, my lord, they have enhanced the rates. Rates ಅಲ್ಲಿ I have
Rates
produced
differ.
that to your lordships.
When did they enhance it?
ಅವ್ರು ಹೇಳ್ತಾರೆ 12/6/96 ಅಂತ. I have produced that to your lordships already to this honorable court.
Not produced anything. Where have you produced? When did you file it?
In the last occasion, judgment ಕೊಟ್ರಿ sir.
Judgment ಹಿಂದೆ ಇದೆ. I have given three, my lord. One is the judgments, list of authorities.
That 12/6/96 you
Yeah,
have put.
yeah, yeah. So ಇದರಲ್ಲಿ proposed ಅಂತಾರೆ.
Proposed.
Proposed.
So first we'll have to see this
Yes, my lord.
for
Yes. ma'am.
see. Karnataka ownership of flats 1972 and Karnataka Apartment Ownership Act 1970. Section. Yes.
Yes.
So it refers to clause A of section 3
Yes, ma'am.
of the Apartment Ownership Act and clause A of section 2 of the Karnataka Regulation COFA.
Regulations.
Yes.
So apartment means any part of the property intended for any type of independent use, including one or more rooms enclosed. So even on the building, it has to be paid.
Yes.
The rate would be 60 rupees
My
for
lord,
every
one-
1,000.
One submission, my lord. In this case, I have registered only for the undivided interest in land. As of 21/11/1996, my agreement was dated 9/3/1994.
Yes.
And thereafter, my lord, there's a covered judgment to this effect, my lord, which I have already furnished to your lordships to say
that the apartment cannot be considered when the sale deed is only for the undivided interest in land.
No, that was in 1990. That was in 1990. That judgment that you referred to,
Milord, that shall I have the place?
Judge
Distinction.
Ravindran's judgment, alva,
Yes, madam.
which you had referred to.
Only in the scheduled property, undivided interest has been transferred, my lord.
That's
In-
fine. Same in my case
my
also.
lord, in this case, it is not so, my lord.
No, I'll read out.
Well,
That was 91, 92.
yes,
Yes, my lord, but I will read out my schedule, my sale deed, which is very clear. If your lordship permit me.
page number 63, my
It
lord.
was a matter where the sale deed was registered in the year 91, 92,
Yes, my lord.
Yes.
much prior to the amendment. The amendment came into force on 1/4/1994.
Yeah.
Your registration is 21/11/1996.
Yes, my lord.
So this provision was not in existence when this judgment was rendered.
Yeah, but my sale deed clearly reads that I have only registered for the undivided interest.
Your sale deed can read whatever.
Yeah.
But what is the net effect is that the apartment is transferred.
Yes, my lord. But
So if they, prior to 94, the Stamp Act did not envisage stamp duty on a transfer of the apartment when the undivided interest was transferred. But post the amendment in the year 1994, irrespective of the transfer of the undivided interest, if any apartment is transferred, a separate entry has been made under subsection 2 for saying 60 rupees for every 1,000 rupees.
okay. So in that case, my lord, there is one provision I would like your lordships to be taken to with regard to the first instrument, definition of first instrument, where it says instrument of conveyance executed by a promoter, a landowner, or a developer, whatever name called. Now, this amendment has come into effect from 1/4/2010.
Here, this is 1994, where it says where it relates to first instrument of conveyance executed by a promoter.
Yes. So 1/4/2010, I've got the Stamp Act which clearly states that.
What difference would it make?
But this is in 2010, my lord, the amendment.
ಏನು?
First instrument ಇದು.
But 1994 ಅಲ್ಲೇ ಇದೆಯಲ್ಲ, where it relates to first instrument of conveyance.
That is subsequent.
Your instrument is the first instrument by the developer.
Yeah,
There's no doubt
no
about
doubt
it.
about it.
There was a leeway which was given for undivided interest during those times
Yes,
and for the building.
yes,
You are getting it at a reduced rate of 60 rupees for every 1,000.
yes.
That is, what would it be? It is 6%.
Yeah.
6% ಆಗುತ್ತೆ. So 6% has to be paid on the apartment value. Whatever you pay on the undivided interest is one document. Whatever you pay on the apartment will be another document. Both are contemporaneous to each other.
Yes, my lord. Now, the next point that I was also like to point out is the rates, my lord.
Rate to
My lord,
They have
with
come
regard
to-
to this, my lord, I read out few paras in the,
ನಿಮ್ ಫೇವರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲಪ್ಪ.
yes.
ಅವರು ಹೂ ಅಂದ್ರು.
ಒಂದೇ ಒಂದ್ಸತಿ ಆ schedule and
ಅವ್ರು ಹೂ ಅಂದ್ಮೇಲೆ ಇನ್ನು
nice.
ರೇಟ್ ಏನು?
Rate ಅಲ್ಲಿ they have quoted 2,350 as per their calculation, my lord. But in the report, you have shown it as 2,250. But your lordships got it, my lord.
Yes.
Yeah. Now I would like to go one step forward to say that it's only a proposed new rates. So for me, the old rate is applicable as of 1174.
And that you are applicable because your agreement was also prior to that. Your
Yes.
consideration was crystallized in the year 94.
Yes, my lord.
You can't apply a consideration subsequently for a consideration which got crystallized in 94.
My lord, consideration has crystallized only on the date of the sale deed is executed. My lord, with respect to that, I will read, as on the date of execution of the deed itself, it
Yes. ಆಮೇಲೆ ಇದು proposed new rates. When did it come into effect?
in the next consecutive year from the date of March.
The following year.
Falling from
96,
March.
97.
April, March.
ಅಲ್ಲಿ ನೀವು proposed new rates ಅಂತ ಹಾಕಿದ್ದೀರಾ.
We have also produced one calculation sheet. Guidelines value as on the date, my lord, the memo dated 22/2/2018 itself. my lord. We have also filed one memo where the guidance value of 2,250 itself is taken.
Correct, which is
That's
not right ಅಂತ ನಾನು ಹೇಳ್ದೆ. Because it's proposed.
Proposed, when did it come into effect?
Proposed is 350.
ಇದ್ರಲ್ಲಿ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
Here also the concept of same, the document in question is before this one for the residential area.
Prior to this proposal, it was 1,174, my lord, which is at item number 54. Which is 1,174 per square foot.
With effect from 12/6/96 ಅಂತಿದೆಯಲ್ಲ.
ಅದು ಪ್ರಪೋಸ್ಡ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Yes, proposed, but with effect from 12/6/96.
ಅವ್ರು ಹಾಕಿರೋದು ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋ ಸಮಯ, whether there is a notification to that effect, whether it is putting, because there's a, as per the Supreme Court judgment, it clearly states, which I'll just point out your lordships.
My lord, it has to be from 1/2/2095 to 1/2/2096, my lord. But here it was came 6 months later, my lord.
ಇಲ್ಲ, ನಿಮ್ಗೆ ಇವಾಗ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
ಅಲ್ಲ, ಅದೇ ಕೈನಲ್ಲಿ ಬರ್ದಿದೆ.
96/97
ಹೌದು
with effect from ಕೈಯಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ.
ಹೌದು, ಕೈನಲ್ಲಿ ಬರ್ದಿದೆ.
ಕೈಯಲ್ಲಿ ಬರ್ದಿದೆ.
ಆಮೇಲೆ ಕೆಳಗಡೆ ಪ್ರಪೋಸ್ ನ್ಯೂ ರೇಟ್ಸ್ ಅಂತ.
ಅದೇ ಪ್ರಪೋಸ್ ನ್ಯೂ ರೇಟ್ಸ್ ಹಾಕಿದ್ದಾರೆ. That is my objection.
ಸೊ ಈ ಕೈಯಲ್ಲಿ ಇರೋದು ಬಿಟ್ಬಿಟ್ರೆ this is only a proposal.
My lord, first one is 96, 94, 94, 95
Yes.
was existing, my lord. For 96, 97, it was proposal. As on that day, the proposal was into act from 96, 97, my lord. 94, 95, which came into effect from 1/2/1995, my lord. Which will change here from 1 to, that is in the starting months of 96 itself, but it came in the month of June, my lord.
ಸೊ ಅದಕ್ಕೆ ಅಫಿಷಿಯಲ್ ಎಲ್ಲಿದೆಯಪ್ಪ?
Official.
ಕೈಯಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟು.
Where is the notification?
Exactly. In fact, for that, my lord, I've produced a judgment of the Honorable Supreme Court, which I'll just read out if your lordships permit me.
Yes.
I've just handed over to the, ಕೊಟ್ಟಿದ್ದಾರೆ.
My lord,
At page 22, my lord. At page 22.
My lord,
Vijay
next
Lakshmi, BDA.
further.
Yes, yes. Vijayalakshmi
Proposed,
BDA.
it cannot.
Yes, yes, yes. ಅದರಲ್ಲಿ clearly ಹೇಳ್ತಾರೆ.
For plan sanction.
Yeah, plan sanction plus it has to be an effect. Last ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, my lord.
No order can be passed on a proposed legislation.
Proposed ಅಲ್ಲಿ.
That was
That's not,
proposed.
it is a well settled law. ನಿಮಗೂ ಕೊಡ್ತೀನಿ ಆ ಕಾಪಿ. ಇದರಲ್ಲಿ ಇದೆ.
So with ಇಲ್ಲಿ ಇರೋದು when did it come into effect?
My lord, please to turn page number.
ಸ್ಫೂರ್ತಿ if we accept.
Four maybe. A notice was issued from the district registrar.
ಯಾವುದು?
ಅದೇ ಪ್ರಪೋಸ್ ರೇಟ್ಸ್ ಅಂತ ಹೇಳಿದೆಯಲ್ಲ, ಅದರಲ್ಲೇನೆ 4ನೇ ಪೇಜ್. When it came into effect, the value of the building area may be calculated at the following rates which affect from
Page 4.
page 4.
Page 4 is this notification. ಇದು ಮೆಮೋ ಡೇಟೆಡ್ 8/11/24 ಅಲ್ವಾ? ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಅವ್ರದ್ರಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ 24/11/2021
I obtained a certified copy from their office.
24/11/2021 ನಲ್ಲಿ ಒಂದು ಮೆಮೋ ಹಾಕ್ತೀವಿ.
Yes.
Documents. In that, the starting pages are the same one which affect from 12/6/1996.
Yes.
Thereafter, my lord, when it came into effect, when it was communicated for others, when it is notice, the value of the building, notice was issued for the sub-register by the district register communicating that proposed rate will come into, which affect from 11/12/20/1995 and until further orders, which is
ಎಲ್ಲಿದೆ ಆ ನೋಟಿಸ್? Where is that notice?
Cannot be brought into effect for that.
And when was it issued?
page nation 21. 411.
Number ಇಲ್ಲ ಇಲ್ಲಿ.
I'll search. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇರುತ್ತೆ. Two memos are being filed.
ಎಲ್ಲಿದೆ ನೋಟಿಸ್?
Calculation sheet.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಶೀಟ್ ಇತ್ತಪ್ಪ, ನಿಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಗೆ ಬೇಸಿಸ್ ಬೇಕು. ವೆನ್ ಇಸ್ ದ
ಅದನ್ನೇ ಸೇಮ್. But this is the different. For roofing and other things.
ನೀವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಕ್ಕೆ ದಟ್ ನೋಟಿಫಿಕೇಶನ್ ಹಸ್ ಕಮ್ ಇನ್ ಟು ಎಫೆಕ್ಟ್ ಅಂತ ಹೇಳಿದೆ.
That's important.
Which effect from was signed also, my lord.
Signed on ಲಾಸ್ಟ್ ಪೇಜ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಡೇಟು ಇಲ್ಲ.
Last page. Only with respect to that, day after tomorrow, my lord. Only with respect to that calculation.
This is
Because, as of I was not there, it's, that's, sorry from my side. As of there are two
Counsel for the
calculation sheets.
Petitioner has filed a memo enclosing the amendment introducing clause 1 of Article 20 to the schedule to the Karnataka Stamp Act 1957, Wide Amendment Act of 1994. The same is taken on record.
In that case, there is also this regarding the Apartment Ownership Act, Section 3 and Section 2 of the Karnataka, the open. There it says it's as of 1/4/2010, my lord, which I've just produced it. I can show it. I share it with your lordships. Illondiದೆ. Don't put pretty. Last line, my lord. That paragraph. 2, where it relates to. Then 9. 9. Instrument of conveyance executed by a promoter, a landowner, or a developer by whatever name called, pertaining to premises flat other than premises flat referred to in clause A as defined in clause A of section 2 of the Karnataka Ownership Flats Regulation Act and section 3 of the Karnataka Apartments Ownership Act, which I have just brought out, my lord, where it says it is effective only from 1/4/2010.
1/4/2010 was the replacement.
It clearly states, my lord, 1/4/2010.
Of the words first instrument by instrument.
Yes,
Yours is first instrument.
yes.
So
So
as on
first
that date, it
instrument,
was first
I can
instrument.
get the benefit from 1/4/2010, no, my lord. I mean, mine is prior to that.
By this amendment, what happened is subsequent instruments were also covered.
Yes. They were covered as both.
If you were a
Whereas-
subsequent instrument in the year 1996, if you were the second sale, then the 94 amendment would not have applied to you. That lacuna was closed in the year 2010.
Yes. They have realized the mistake and then they have set it right.
Right, because only first instrument itto,
Ah.
second instrument baralla alli,
ಬರಲ್ಲ ಅಂದ್ಬಿಟ್ಟು
anta adella aitu.
So I thought I can
All
take.
those things, you know what happened. Now this, you are fortunately or unfortunately, you are the first instrument.
Yes.
So you are covered in 94 only by this amendment. For you, there is no escape. You are not the second purchaser.
Yes.
Only the valuation is what we'll have to look at.
Yeah, yeah. And one more thing, my lord, point number. Here in their calculation, they have said about 3B. Now 3B came into effect only from 1/4/1998, my lord.
98 andre you are covered. 98 you are not covered.
Not covered. Adike.
3B of
3B of their calculation.
ಅದರಲ್ಲಿ ಇದೆ ನೋಡಿ. Their calculation, my lord, which I have shared with your lordships at page 2. This is a report submitted by the respondent number 2, my lord, which I have furnished to you. ಅದರಲ್ಲಿ page 2 ಅಲ್ಲಿ last but one item, ಸ್ಥಳೀಯ ಅಧಿಕ ಶುಲ್ಕ 3B ರಂತೆ.
Serial number 15,700, which is on memo dated 22/2/2018.
So that has come into effect only from 1498.
In this memo, where is the calculation in this memo?
ಅಲ್ಲಿ ಇದೆ ಇದೆ. It is produced it, my lord, last
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
time.
22/2/2018, my lord.
ಇಲ್ಲಿದೆ. ಇಲ್ಲಿದೆ. Can I?
That is accepted, my
Yeah.
lord.
22/2/2018.
Yes, my lord. At
Yes.
page number 3, my lord. Column number 6, 4, my lord. 4th serial number.
ಕ್ರಯಪತ್ರದ
ಸ್ಥಳೀಯ ಅಧಿಕ
ಅಧಿಕ
ಶುಲ್ಕ
ಮೌಲ್ಯ.
3B ರಂತೆ.
ಎಲ್ಲಿದೆ 3B?
Here,
3B
ತೋರಿಸ್ಬಿಡಿ, ತೋರಿಸ್ಬಿಡಿ.
ಅದು ಬೇರೆ ತೋರಿಸ್ತಾ ಇದೆ.
I've shared it with your lordships, but I'm showing it once again. ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ನಿಮ್ಮ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Serial number 6 ಅಲ್ಲಿ ಇದು.
6, 3.
ನೀವು 4 ಅಂದ್ರೆ.
Oh, sorry. 6, serial number.
3B ರಂತೆ 15,700. What is this 3B?
That is that BMRCL, my lord, that additional
Yes.
surcharge came
Additional surcharge.
with effect from 1/4/1998.
That won't apply.
That will not.
ಇವಾಗ ನಿಮ್ದು 2,500 ಇದೆಯೋ ಏನು ಅಂತ ನೋಡ್ಬೇಕು ಅಷ್ಟೇ.
Yes.
Is taken on record. Counsel for the
4th, my lord.
under DGA seeks for and is granted 3 days time to place on record the date on which the enhanced guideline value for the year 96-97 came into force with documentary support thereof.
Yes.
Pre-list on 4th.
Before, Ganpati Bhatt.
ಗೊತ್ತಾ ಇದೆಯಾ? ಗಣಪತಿ ಭಟ್.
Total 14 word.
Paso.
Third pass.
HK Singh. Though counsel for the petitioner is present, none appears for respond number 1. If none were to appear for respond number 1 on the next date of hearing, matter would be taken up for consideration on the basis of submission made by counsel for the petition. We list on 6th.
35. HR Durga Prasad.
For the petitioner. Last occasion, the government lawyer said it.
Get ready. Now they are ready.
Please.
Ready. Here.
Last occasion, I already senior amount. At the
not
time of
even-
cutting remove the trees. At the time of removing and cutting the trees, the petitioner already paid the senior amount. Annexure B, my lord. The representation given by the petitioner. Senior amount of rupees 4,33,082.
Bane land.
Alienated Bane and Bane land.
Privileged.
In view of the amendment, now you can't charge. That is the
Get it.
judgment.
2020 minutes.
ಇಲ್ಲ,
Section 20, section 20.
220. Land Revenue Act.
This is unprivileged ಸಾಗೋ ಇತ್ಲು ಲ್ಯಾಂಡ್ ಸಾಗೋಳಿ ಬಾನೆ ಲ್ಯಾಂಡ್ ಎರಡು.
Bane land.
ಒಂದು
Even
ಇತ್ಲು,
the-
ಒಂದು ಇತ್ಲು ಸಾಗೋಳಿ ಇತ್ಲು ಲ್ಯಾಂಡ್, ಇನ್ನೊಂದು ಸಾಗೋ ಬಾನೆ ಲ್ಯಾಂಡ್. ಸರಿ ನಂಬರ್
ಇದು ಪ್ರಿವಿಲೇಜ್ ಸಾಗು ಬಾಣೆ.
ಒಂದು ಸಾಗೋ ಬಾನೆ ಇದೆ, ಒಂದು
ಹಾ.
ಸಾಗೋ ಇತ್ಲಿ ಇದೆ. Survey number 23, my lord, it is unprivileged sagu itlu land.
220 ಅಲ್ಲಿ when you introduce this amendment in the year 2013, landholder including Jamabane, privileged and unprivileged, Umli land in the Kurg district and add madidira.
All types.
All types will cover. Privileged, unprivileged. He'll be entitled to be registered as an occupant.
Of course. So for the trees,
Once he is an occupant,
before the,
he is an occupant, whatever was earlier also continues with him. He doesn't need to.
Can answer-
ಆಮೇಲೆ ಏನು plant ಮಾಡೋದ್ ಬೇಕಾಗಿಲ್ಲ.
already existing trees ಇದ್ರೆ that has to be.
It belongs to him, whatever forest permission ಎಲ್ಲ ಏನಿದೆಯೋ ಅದು ತಗೊಳ್ಬೇಕು. The
Yes.
permissions will have to be required, but you cannot claim it to be belonging to you as a state.
But while seeking permission, my lord, for cutting the trees, there was one of the condition that they have to deposit the amount. Accordingly, they would agreed and deposited.
Correct.
One of the conditions in the cutting.
ನಿಮ್ಮ condition itself was not proper because ಇದು ಯಾವಾಗ ಕಟ್ ಆಗಿರೋದು? When was the date?
1983.
Prior to amendment.
83 na?
Prior to amendment.
Prior to.
It's liable.
Kindly see the annexure C over.
Prior to amendment.
For a moment, for annexure C, my lord.
Yes.
Can I read you? ಮಡಿಕೇರಿ ತಾಲೂಕು ಬಿಳಿಗೇರಿ ಗ್ರಾಮದ ನವೆಂಬರ್ 23 100 ಸಾಗು ಹಿತ್ಲು ಮತ್ತು 29/7 100 ಸಾಗು ಬಾಣೆ.
ಇದು ಆಮೇಲೆ ಮಡಿಕೇರಿ ತಾಲೂಕು.
ಮಡಿಕೇರಿ.
ನಾಟ್ ಕೂರ್ಗ್.
ಕೂರ್ಗ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಮಡಿಕೇರಿ ತಾಲೂಕು. ಮಡಿಕೇರಿ.
ಕೂರ್ಗ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮಡಿಕೇರಿ.
ಮಡಿಕೇರಿ ಇಸ್ ಕೂರ್ಗ್ only. Sorry.
1984ನೇ ಸಾಲಿನಲ್ಲಿ ಮರ ಕಡಿತಲೆಗೆ ಅನುಮತಿ ನೀಡಿದ ವೇಳೆ ಪಾವತಿಸಿದ ಸೀನಿಯರೇಜ್ ದರವನ್ನು ಜಾಗವು ಪರಾಧೀನವಾದುದರಿಂದ ಮರುಪಾವತಿಸಲು ಕೋರಿರುವರು. ಈ ಬಗ್ಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರಿಗೆ ಈ ಕಚೇರಿಯಿಂದ ಪತ್ರ ಬರೆದು ಜಾಗವು ಪರಾಧೀನವಾದ ಬಗ್ಗೆ ಅಭಿಪ್ರಾಯ ಕೋರಲಾಗಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ನವೆಂಬರ್ 23 ಜಮೀನು 1897 1897 ಮತ್ತು ನವೆಂಬರ್ 29/7 ಜಮೀನು 1972 ಕಂದಾಯಕ್ಕೆ ದಾಖಲಾಗಿ ಪರಾಧೀನವಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. So earlier in the year 1897 is eliminated Bana land. There is not necessary to pay the seniorage amount or any fine amount to the government. ದಿನಾಂಕ 1/4/1964 ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್ 1964 ಜಾರಿಗೆ ಬಂದಿದ್ದು, ಅಲ್ಲಿಂದ ಜಮೀನುಗಳನ್ನು ಹೊಸದಾಗಿ ಪರಾಧೀನ ಜಮೀನುಗಳನ್ನು ಪರಿವರ್ತಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ಮೇಲಿನ ನವೆಂಬರ್ 23 100 ಸಾಗು ಹಿತ್ಲು ಮತ್ತು 29/7 100 ಸಾಗು ಬಾಣೆ ಜಾಗವನ್ನು ಪರಾಧೀನವೆಂದು ಸದರಿಯವರ ಕಚೇರಿ ಆದೇಶ ದಿನಾಂಕ 29/3/2010 ಪರಿಗಣಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನೀವು ಮರ ಕಡಿತಲೆ ಪಾವತಿಸಿದ ಹಣವನ್ನು ಮರುಪಾವತಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲವೆಂದು ನಿಮಗೆ ತಿಳಿಸಿದೆ. The 29/3/2010, my lord.
That
Kindly see the
87
annexure.
is in the Coorg land reforms. That won't be applicable.
Kindly see the annexure A, my lord. Annexure A, the order of the deputy commissioner. Page number 14 and ಅರ್ಜಿದಾರರ ವಾದ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆ ಹಾಗೂ ಕೆಳ ನ್ಯಾಯಾಲಯದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಮಡಿಕೇರಿ ತಾಲೂಕು ಬಿಳಿಗೇರಿ ಗ್ರಾಮದ ನವೆಂಬರ್ 23/25 83 ಎಕರೆ, ನವೆಂಬರ್ 25 465 ಎಕರೆ ಜಾಗ, 29/7 1945 ಎಕರೆ ಜಾಗವನ್ನು ಅರ್ಜಿದಾರರು 1960ರಲ್ಲಿ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಪಡೆದ ಜಾಗವಾಗಿರುತ್ತದೆ. ಹಿಂದಿನ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ನವೆಂಬರ್ 23 ಜಾಗವು 1897ರಿಂದ ಕಂದಾಯದಲ್ಲಿತ್ತು. ಮೂಲ ನಿಬಂಧನೆ ಸಾಗು ಜಾಗವಾಗಿದ್ದು ಹಾಲಿ ಅನ್ಪ್ಯೂಲ್ಡ್ ಸಾಗ ಎಂದಿರುತ್ತದೆ. ಬೈ ಮಿಸ್ಟೇಕ್ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಬೈ ಮಿಸ್ಟೇಕ್ ಇಸ್ ಹ್ಯಾಪನ್ ಯು ಮೈ ಲಾರ್ಡ್. ನವೆಂಬರ್ 29/7 ಜಮೀನು 1919ರಿಂದ ಸಾಗುವಳಿಗೊಳಪಟ್ಟು 1972ರಿಂದ ಈಚೆಗೆ ಕಂದಾಯಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಹಾಲಿ ನಿಬಂಧನೆ ಅನ್ಪ್ಯೂಲ್ಡ್ ಸಾಗುಬಾಣೆ ಆಗಿರುತ್ತದೆ. ನವೆಂಬರ್ 25 4 ಎಕರೆ 65 ಎಕರೆ ಜಮೀನು ಮೂಲತಃ ಅನ್ಪ್ಯೂಲ್ಡ್ ಸಾಗುಬಾಣೆ ಆಗಿದ್ದು, ನವೆಂಬರ್ 25ರಿಂದ ವಿಂಗಡಿಸಿದ 215 ಎಕರೆ ಜಾಗವು 1972ರಲ್ಲೂ, ನವೆಂಬರ್ 251 2 ಎಕರೆ 50 ಎಕರೆ ಮತ್ತು 29/7 13-23 ಎಕರೆ ಜಾಗಗಳು 1985 86ರಲ್ಲಿ ಕಂದಾಯಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಪ್ರಸ್ತಾವಿತ ಜಾಗಗಳು ಹಾಲಿ ಆರ್ಟಿಸಿಯಂತೆ ನವೆಂಬರ್ 23 25/1 25/2 ಎಂದು ವಿಂಗಡವಾಗಿ ಕಂದಾಯದಲ್ಲಿ ಮುಂದುವರೆದಿದ್ದು, ನಿಬಂಧನೆಯು ಅನ್ಪ್ಯೂಲ್ಡ್ ಸಾಗು ಹಿತ್ಲು ಮತ್ತು ಅನ್ಪ್ಯೂಲ್ಡ್ ಸಾಗುಬಾಣೆ ಎಂದಿರುತ್ತದೆ. ಬೈ ಮಿಸ್ಟೇಕ್ ರಾಂಗ್ ಎಂಟ್ರಿ ಇನ್ ದಿ ಆರ್ಟಿಸಿ.
ಅದು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್. ಇದೆಲ್ಲ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಮೈ ಲಾರ್ಡ್, 1897ರಲ್ಲೇ ಎಲಿನೇಟೆಡ್ ಬಾಣೆ ಲ್ಯಾಂಡ್, ಬಟ್ ಆರ್ಟಿಸಿ ಇದು ಸಾಗು ಇದ ಕಾರಣ ನಾವು ಬೈ ಮಿಸ್ಟೇಕ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ವಿ.
ದಟ್ ಇಸ್ ವಾಟ್ ಯು ಆರ್ ಸೇಯಿಂಗ್.
ಎಸ್ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು
ಫೈಂಡಿಂಗ್ ಅಲ್ಲ.
ಇಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು ಅನ್ನೆಕ್ಷರ್, ಕೈಂಡ್ಲಿ ಸಿ ದ ಅನ್ನೆಕ್ಷರ್ ಸಿ ಅಂಡ್ ಅನ್ನೆಕ್ಷರ್ ಎ. ಪ್ರಸ್ತಾವಿತ ಜಮೀನುಗಳು ಕಾಪಿ ಕೃಷಿ ಒಳಪಟ್ಟು ಕಂದಾಯಕ್ಕೆ ಬಂದಿರುವುದರಿಂದ ಇವುಗಳನ್ನು ಬಾಣೆಯಿಂದ ಹೊರತುಪಡಿಸಿ ಪರಾಧೀನ ಎಂದು ನಿಬಂಧನೆ ಬದಲಾಯಿಸಿಕೊಡಬೇಕೆಂದು ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಾಗಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಈ ಹಿಂದೆ ನಡೆದಿರುವ ವ್ಯವಹಾರಗಳು, ಪ್ರಸ್ತಾವಿತ ಜಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಹಳೆಯ ದಾಖಲೆಗಳು, ಬಾಣೆ ಜಾಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ವಿವಿಧ ನ್ಯಾಯಾಲಯಗಳ ತೀರ್ಪುಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ಪ್ರಸ್ತಾವಿತ ಜಮೀನುಗಳು ಈ ಹಿಂದಿನಿಂದಲೇ ಸಾಗುವಳಿಗೆ ಒಳಪಟ್ಟು ಕಂದಾಯಕ್ಕೆ ದಾಖಲಾಗಿರುವುದರಿಂದ ಚೆಕ್ಕೇರ ಕಾರ್ಯಪ್ಪ ಪೂವಯ್ಯ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ನೀಡಿರುವ ತೀರ್ಪು, ಅದನ್ನು ಅನುಸರಿಸಿ ಸರ್ಕಾರ ಹೊರಡಿಸಿರುವ ಸುತ್ತೋಲೆ ನಿರ್ದೇಶನಗಳು ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಿಂದ ಹೊರಡಿಸಿರುವ ಆದೇಶಗಳ ಆಧಾರದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಾಗುವಳಿಗೆ ಒಳಪಟ್ಟು ಕಂದಾಯಕ್ಕೆ ದಾಖಲಾಗಿರುವ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಪರಾಧೀನ ಜಾಗವೆಂದು ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಕೊಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ನೀಡಿದೆ. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಪ್ರಕರಣಕ್ಕೆ ಒಳಪಟ್ಟಿರುವ ಪ್ರಸ್ತಾವಿತ ಜಮೀನುಗಳನ್ನು ಪರಾಧೀನ ಜಾಗವೆಂದು ಪರಿಗಣಿಸಿ ಆದೇಶಿಸಿದೆ. ಇಟ್ಸ್ ನಾಟ್ ಡಿಕ್ಲೇರ್, ದಿಸ್ ಇಸ್ ಕ್ಲಾರಿಫೈಡ್. ಆಸ್ ಪರ್ ದಿ annexure C 29/3/2010 ಪರಿಗಣಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನೀವು ಮರುಕಡಿತಲೆ ವೇಳೆ ಪಾವತಿಸಿ ಹಣವನ್ನು ಮರುಪಾವತಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ದಟ್ ಇಸ್ ಕ್ಲಾರಿಫೈಡ್ ಬೈ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್, ನಾಟ್ ಫಾರ್ ಡಿಕ್ಲೇರ್ಡ್. And I already put it on citation over on that day in 1979. Last occasion I already
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಸೈಟೇಷನ್ ಹಾ, EG White.
EG White.
Yes.
ಅದರಲ್ಲಿ ಇದೆ. Para 5. Whether the title to the trees standing on the lands in question can still be said to vest in the state government in spite of the fact that the lands have become alienated ಬಾಣೆ. ಲಾಸ್ಟ್ ಇದರಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಪ್ಯಾರಾ ನಂಬರ್ 12.
Yes.
Accordingly, just ಇದನ್ನ ಓದ್ತಾ ಇದ್ದೀನಿ ಮೈ ಲಾರ್ಡ್. Accordingly, I hold that the government cannot claim title to the trees that have been grown on the lands in question after the lands become alienated ಬಾಣೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಲಾಸ್ಟ್ ಇದರಲ್ಲಿ ಸೆಂಟ್ರಲ್ ಓದ್ತಾ ಇದ್ದೀನಿ. ಪ್ಯಾರಾ ನಂಬರ್ 12.
ಹಾ,
Accordingly, I hold the.
ಎಲ್ಲಿದೆ ಅದು? ಇಷ್ಟು ದೊಡ್ಡ ಪ್ಯಾರಲ್ಲಿ ಎಲ್ಲಿ? ಅಲ್ಲೆಲ್ಲೋ ಇದೆಯಾ? ಹಾ.
Accordingly, I
Yes.
hold that the government cannot claim title to the trees that have been grown on the lands in question after the lands become alienated bane and the maliki of such trees, including the trees grown from the stumps or roots of the trees cut and removed west in the petitions, and they will be entitled to cut and remove the same without paying the value of the timber on obtaining the transport passes in accordance with the provisions contained in the Karnataka Forest Act. ಇದು ಎಲಿನೇಟೆಡ್ ಬಾಣೆ ಅಂತೇಳಿ 1897 ಆಗಿ ಹೋಗಿದೆ. ಬಟ್ RTC ಏನಾಗಿದೆ, ಬೈ ಮಿಸ್ಟೇಕ್ ಟೆನ್ಯೂರ್ ಚೇಂಜ್ ಆಗದಿರೋ ಕಾರಣ ನಾವು ಪೇಮೆಂಟ್ ಮಾಡಬೇಕಾಗಿದೆ.
Deputy Commissioner has said that.
Yes.
It is confirmed that it is alienated ಸಾಗು ಬಾಣೆ.
ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಹೋಗಿದೆ, ನಾವು ಕಟ್ಟಿದೀವಿ, ಪೇಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಿದೀವಿ. ವೆನ್ ರಿಯಲೈಸ್ ದ ಸೆಟ್ ಫ್ಯಾಕ್ಟ್, ವಿ ಆಲ್ರೆಡಿ ಫೈಲ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂಡ್ ಆಲ್ಸೋ ಬಿಫೋರ್ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
Annexure C.
Annexure C. That is
Yes.
out of the, I said they preferred an appeal is also dismissed. Annexure D. Annexure C, madam. Page 16, madam.
See, the Deputy Commissioner has passed an order on 29/3/2010
Please, madam.
saying that it's a alienated ಸಾಗು ಬಾಣೆ land.
Sagwali Bane.
ಸಾಗು ಬಾಣೆ land.
ಎಲಿನೇಟೆಡ್ ಸಾಗು ಬಾಣೆ.
Alienated ಸಾಗು ಬಾಣೆ.
ಸೊ ಕಂದಾಯಕ್ಕೆ ಬಂದಿದೆ ಅಂತಂದ್ಮೇಲೆ ಕಂದಾಯ ರೆವಿನ್ಯೂ ಇದು.
The responsible submission will
The question of the forest officer saying otherwise cannot arise. When the Deputy Commissioner who is the revenue in charge
please.
says that it is a alienated ಸಾಗು ಬಾಣೆ.
While seeking for cutting the trees, madam, seeking permission.
Mistake ಮಾಡಿದ್ದಾರೆ. Once you have said that it is ಸಾಗು ಬಾಣೆ, alienated ಸಾಗು ಬಾಣೆ,
Sagu-
can you retain a payment made under mistake? You can't retain, alva?
Sagu itlu and Sagu Bane.
Alienated ಆಗಿದೆ ಅಂತ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹೇಳಿದ್ದಾರೆ. ನೋಡಿ,
Annexure A.
annexure A. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be a purchase of land in survey number 23 measuring 25 acres and 29/7 measuring 13.23 acres situated Biligeri village, Biligeri post, Madikeri Taluk, Kodagu district. The petitioner had made an application to the Deputy Conservator of Forest for cutting 349 trees, which was so accorded on 1/2/1983. under condition that the petitioner would be liable to deposit the value of the timber proposed to be cut and removed. In that background, the petitioner valued the trees at rupees 4,33,082.35 and deposited the same. After the trees were cut and removed, the petitioner, realizing that the above land was an alienated Sagu Bane land, which had been assessed to land revenue, had made an application for refund of the money since there was no provision for the conservator of forest to levy a condition for deposit of the above amounts, since the land exclusively belonged to the petitioner, and as such, any produce on the said land belonged to the petitioner. The said request came to be rejected by order dated 25/4/2012 by the Assistant Conservator of Upa Aranya Samrakshana Adhikari andre Assistant Forest Officer,
Assistant Forest Officer.
Assistant Forest Officer,
Conservator of Forest.
Samrakshana Adhikari andre Conservator,
Conservative.
Assistant Conservator of Forest, contending that the earlier alienation of the Sagubane lands in the year 1897 cannot be considered under the Land Revenue Act of 1964, and as such, the amounts could not be refunded. It is challenging the same. The petitioner is before this court. Learned counsel for the petitioner would again reiterate that once the Sagubane land has been alienated and admitted to revenue, and the owner thereof has been making payment of the revenue, the land becomes the exclusive property of the owner, that is the petitioner herein. The state not being the owner of the land, the petitioner being entitled to the land in his own right, the state cannot assert any title on any trees which have been grown on the said land. And in this regard, it relies upon the decision of this court in 1979, 2 Karnataka Law Journal 233. More particularly, para 5 and 12 thereof, which are reproduced hereunder for easy reference. By relying on the above judgment, by relying on E.G. White's case, the submission of learned counsel for the petitioner is that once the lands have become alienated, the state cannot contend that the trees standing on the land should vest with the state government and levy any amounts. And on that basis, submit that the above petition is required to be allowed. Learned AG would seek to support the order passed by the Assistant Conservator of Forest, and contends that the
In the appeal means, D also, appeal is confirmed. C and D both.
Annexure C and D, my lord.
D no idea. D ಹೇಳ್ತಿಲ್ಲ ನೀವು.
Appeal not.
ಅಲ್ಲಿ ಮೇಲೆ challenging the order of the Assistant Conservator of Forest, the petitioner had filed an appeal before the Chief Conservator of Forest, which came to be rejected by order dated 4/4/2013 by holding that the petitioner himself, having accepted the condition for payment of the land, payment of the amounts, no refund could be sought for. It was further sought to be, the said order was further sought to be supported by contending that even as per the application filed, the petitioner had indicated the land to be Sagu Bane and not alienated Sagu Bane land. Learned AG seeks to support both the above orders by contending that the very application filed by the petitioner would indicate that the land is Sagubane land.
Not really.
And even as per the petitioner, when the application was filed, it was not shown as alienated Sagubane. The petitioner having accepted the condition, the petitioner cannot resile from the same. And as such, the order passed by the Assistant Conservator of Forest and Chief Conservator of Forest is proper and correct, heard so and so. The short question that would arise for consideration is whether a payment made under mistake by the owner of a alienated Sagubane land can continue to be withheld by the state when the mistake is realized by the owner and an application filed for refund of the monies. Insofar as the aspect of vesting of the trees on alienated Sagubane land is concerned, this court in E.G. White's case has categorically held that when a Sagubane land, when a Bane land is alienated, which would include a Sagubane land, the state cannot claim any interest in the trees or any malkis on the said land. That being the case, in the present case, it is clear from the order dated 29/3/2010 of the Deputy Commissioner, which has been produced at Annexure A, that the Deputy Commissioner has categorically held that the land's subject matter of the present proceedings are alienated Sagubane land and have been admitted to revenue, thereby conferring an exclusive ownership right to the petitioner. Once the land on the records of the Revenue Department is held to be a alienated Sagubane land, whether the petitioner made an application showing the property to be Sagubane land or alienated Sagubane land would be irrelevant, since the mistake is a bona fide, since it is only by a mistake that the land has been shown as Sagubane land, even though the land had been alienated way back in the year 1897. In fact, it was for the Assistant Conservator of Forest and the Chief Conservator of Forest to verify these from the concerned records and not go by the statement made by the petitioner itself. Whenever any application is filed by any person claiming permission to cut trees, there is a duty imposed on the permitting and the authority granting such permission to verify the details. If at all the details had been verified, it would have been clear that the land in question is a alienated Sagubane land and not just a Sagubane land, not an unalienated Sagubane land. This aspect has been made clear by the Deputy Commissioner in his order dated 29/3/2010. In that view of the matter, the respondent state cannot seek to take advantage of a mistake committed by a citizen in showing the land to be Sagubane land when it is alienated Sagubane land in order to retain the amount paid by a citizen to the state. Hence, I answer the point formulated by holding that so and so even mistake cannot hold. In the above circumstances, I pass the following order. A certiorari is issued, so and so is quashed. A mandamus is issued directing the respondent to refund the sum of rupees 4,33,082.35 with interest at the rate of 6% per annum from the date on which the deposit was made.
There are two survey numbers. There are two survey. One is Sagu Itlu and Sagu Bane.
Sagu itlu ella onde.
Serial number 36.
Here for the petitioners, my lord.
ನೀವು ಯಾರು ಇರ್ಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್. ಇವತ್ತು ಅವ್ರು ಯಾರು ಇಲ್ಲ. Today learned counsel for the petitioner appears, but none appears for the respondent.
Have it next week, my lord.
Relist on
Next week, my lord, so third of December. my lord.
Swati Ashok andre Anuradha ಅವ್ರು. It will be on 13th.
Your Lordship, I appear for Swati Ashok, Your Lordship.
Yes, madam.
Yes, due to some medical emergency, I'm not able to be in the court, ma'am.
13th.
Obliged, Your
Of counsel for respond number 1 and 2 relist on 13th.
Obliged, Your Lordship.
Yes.
37. Sitaramara.
I am for the petitioner.
ನೀವು ಯಾರು ಜೂನಿಯರ್ ಕಳ್ಸಿ ಅಂದ್ರೆ ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ ಮಿಸ್ಟರ್ ರಾವ್?
I appear for respondent.
Mr. Sitaram Rao is not well ಅಂತ ಹೇಳಿ.
Please, my lord, morning he informed us, my lord.
ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ ಮಿಸ್ಟರ್ ರಾವ್?
ಅಲ್ಲ ನಮ್ಮ ಕಲೀಗ್ ಸರ್
ಮಿಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಮನೆಯಲ್ಲಿ?
ಇಲ್ಲ ಹುಡುಗರು ಇಲ್ಲ.
At the request of the counsel for the petitioner, relist on 18th December.
Much obliged.
38.
For the respondent in this case.
I appear for the petitioner's counsel.
Yes, Mr. Shashidhara.
Annexure E, page 122.
Ready?
Please, ma'am.
ಹೇಳಿ.
Petitioner is running a petroleum outlet at Hassan district. On 22nd 5/22/2015, the inspection was conducted by the officials at Annexure E, page 122. But they have reported certain irregularities. Your Lordship will get the typed copy from page 125 onwards.
Yes.
I am producing that copy.
Type copy ಇದೆ. ಅದಕ್ಕಿಂತ ಬೆಟರ್ ಇದೆ.
Typed copy, there are mistakes.
ಇಲ್ಲ ಅವ್ರದೇ ಚೆನ್ನಾಗಿದೆ, ಕರೆಕ್ಟ್, ಅವ್ರದೇ ಚೆನ್ನಾಗಿದೆ.
ಅವ್ರದ್ದು ಚೆನ್ನಾಗಿದೆಯಾ?
ಹೌದು.
ಪೇಜ್ ನಂಬರ್
I will
R
Page 78.
78.
Children's inspection report is there. And
may I take your Lordship to
79.
79 is the irregularities.
Yes.
Let your Lordship kindly see. They have made certain 13A, may kindly be seen. Column. Right side remarks 40 ml short in both so and so MS and meter
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
79 bottom ಅಲ್ಲಿ 13A column.
79 ಏನ್ ಕಾಲಮ್ ಯಾವುದು ಇಲ್ಲ. 79 is the letter of 22/5/2015.
They had given 78 R3 is the 22/5/2015.
R3 starts at 79.
No, I was
ಟೇಬಲ್ ಇಲ್ಲಿದೆ. 13A.
13A ನಲ್ಲಿ. Kindly see right side ಮೇಡಮ್.
ಯಾವ್ದು ನೋಡ್ಬೇಕು? ಯಾವ ಕಾಲಮ್ ನೋಡ್ಬೇಕು?
13A ನಲ್ಲಿ
13A.
remarks columns. Remarks columns.
Yes.
40 ml short in both nozzles. Meter stopped at 7,000 so and so. 40 ml short in both nozzles. Meter stopped at so and so. This is in respect of both MS and then HSD. Next, their main complaint is, may take your Lordships to the bottom retail selling price. Your Lordship got madam? Price of MSD at rupees 72.49, but actually government selling price was 72.41. 8 paise excess charge martidru anta.
Yes.
About for 5 days. But that is one thing. And secondly, my lord, there was a difference in the stocks. That is what the main, again, second one allegation.
Gist of the allegation is at page 79 R3. Selling license was not made available, renewed.
Your Lordship are right. But for which?
RSP, stock register, not density register, not a stock variation.
Yes, minute. This is 1 to 9.
How do?
But for which my client at page 82, I don't know whether it is tallying, has submitted a reply.
Yes.
Meeting each one of these raise, of course, some mistake is also there. There is no dispute. There is a mistake in charging 8 paise, because earlier used to be the whatever the price at Hassan city, it is in this
selling license illa. You have applied.
ide.
You applied, it's not been given, and nimmed admission idella.
ಅಲ್ಲ ಅದೇ ಹೇಳಿದ್ದು ಅವರು ಅಪ್ಲೈಡ್ ಅಂದ್ರೆ ಇವರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಎಲೆಕ್ಷನ್ ಇತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಕೊಡೋವರೆಗೂ ನೀವು ಯು ಕಾಂಟ್ ಸೆಲ್.
ಇಲ್ಲ, ಈಗ ಆಯ್ತು ಅದೆಲ್ಲ ಆಗಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರು ನಾವು ಐ ಕ್ಯಾನ್ ಕಂಟಿನ್ಯೂ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. ಇಂಟ್ರಿಯಮ್ ಆರ್ಡರ್ ನಲ್ಲಿ interim order was granted by this honorable court on 26th of May 2015
Yes.
that the petitioner shall not be restrained from carrying on with the business, though he is liable to be penalized for having violated the conditions of sale. But subsequently, for last 8-9 years, if I'm correct, Millard, I don't know about the information, but there was no such irregularities by the petitioner. Nevertheless, Millard, she has submitted a reply. Let them consider those replies, Millard, and pass appropriate. That is what even the statement of objections.
Millard, on 22/5, the vigilance inspected the spot and made certain observations, which is at page 78.
Yes.
1 to 9. There was a 40 ml shortage in 5 liter can. When 5 liter can, on a 5 liter can, the petrol is put, it is showing 40 ml short. And dispensing the underground tank and the dispensing unit is not telling. Is actually excess selling it is showing. When that rod is dipped in the tank, what is it showing and what is the sales made in the dispensing unit? There is a difference. There is a difference in both MS and HSD.
Sale is lesser than what is available.
Yes, it is more than what he has sold.
ಅದೇ ಕಮ್ಮಿ ಅಷ್ಟು ಒಂದು
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಕಮ್ಮಿ ತೋರಿಸ್ತಾರೆ, ಇದರಲ್ಲಿ ಸೇಲ್ ಮಾಡೋದ್ರಲ್ಲಿ ಜಾಸ್ತಿ ತೋರಿಸ್ತಾರೆ.
ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದು ನಿಜ, ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. Because it was in their presence.
22/5, the notice was issued. He rushed to court on 25 itself.
ಅದಕ್ಕೆ ಎಸೆನ್ಷಿಯಲ್ ಕಮಾಡಿಟಿ ಮಿಸ್ ಶಶಿಧರ.
Please, no doubt. Right, it is not a serious malpractice. No doubt there are mistakes.
This is serious for a person who is going to spend 72 rupees a liter.
70 ಅಲ್ಲ 8 ಪೈಸೆ ಇಲ್ಲ 8
ಕಿಲೋಮೀಟರ್ ಶಾರ್ಟ್ ಬಂದಿದೆ ಅವ್ರ ಬೈಕ್ ಓಡೋದ್ರಲ್ಲಿ ಅಂತ ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ.
8 ಪೈಸೆ ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ ಜಾಸ್ತಿ ಅಂತ.
ನಿಮಗ್ ಗೊತ್ತಾಗಲ್ಲ.
No, my lord, there is mistake, no doubt. My request to lordship.
ಏನು ಜಾಸ್ತಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅದೆಲ್ಲ ನಿಂತೋಗಿದೆ, ಇವಾಗ ಎಲ್ಲ ಸರಿ ಹೋಗಿದೆ. ಅದು ರೂರಲ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋ ಔಟ್ಲೆಟ್. ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಬಿಗ್ ಸೇಲ್ಸ್ ದಟ್ ಟೇಕ್ಸ್ ಪ್ಲೇಸ್.
This notice, sir. And now the reply is also sent by him after filing of the writ petition and obtaining interim order.
Consider it in penalty.
The rate is the personal hearing to him. It's not let him appear before the authority.
ಪೆನಾಲ್ಟಿ ಇದೆ, ಪೆನಾಲ್ಟಿ ಇದೆ.
ಪೆನಾಲ್ಟಿ ಇದೆಯಾ?
ಪೆನಾಲ್ಟಿ ಇದೆ.
ದೊಡ್ಡ ಪೆನಾಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡಿ.
ಇಲ್ಲ ಒಂದು 50,000 ಏನೋ ಹಾಕ್ತಾರೆ ಅಂತ
ಹಾಕಿರೋದು 2005 MDJ, ಅದು ಅಪ್ಲೈ ಆಗೋದು 2013 MDJ.
ಆಗ್ಲಿ, ಅವ್ರದೇ ಆಗ್ಲಿ.
ಎಷ್ಟು ಮ್ಯಾಕ್ಸಿಮಮ್ ಪೆನಾಲ್ಟಿ ಎಷ್ಟು?
50,000. ಆಮೇಲೆ 15 ದಿವಸ ಔಟ್ಲೆಟ್ ನಿಲ್ಸಿ ಅಂತಾರೆ. ಈಗ ಆಗೋಗಿದೆ 8-9 ವರ್ಷ ಆಗಿದೆ. ಈಗ
50,000
ಆಗ್ಲಿ.
Let him do that.
No, if they does anything in future, my lord, or anything complaint.
Penalty, let the authority impose the penalty, 50,000 or 2 lakhs, whatever it is. They are ready to give.
We'll only say the maximum penalty.
Please.
This is an admission.
Please.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that without providing an opportunity to the petitioner, penalty is proposed to be imposed on the petitioner in terms of vigilance inspection carried out on 22/5/2015 and the reply which has been issued subsequently on 4/6/2015 has not been considered.
Exact filing of the petition.
Bada, 4/6/2015. When was the petition filed? 25/5.
25/5. 26th is the interim.
On the petition being filed, this court had granted interim relief. And during the pendency of the above on the filing of the petition on 25/5/2015, this court had granted interim relief on 26/5/2015. During the pendency of the above proceedings, the petitioner has replied to the notice on 4/6/2015. In that view of the matter, And the considered opinion that interest of justice would be met by directing the respondents to consider the said reply and pass necessary orders. Since the reply indicates admission on part of the petitioner as regards certain of the allegations made, it would always be open for the respondent to impose such penalty as may be permissible under the applicable rules.
So ಹೇಳಿದ್ರಿ in any event it should not exceed 50,000 ಅಂತ ಹೇಳಿದ್ರಿ.
ಇನ್ನ ಒಂದು maximum ಅಂತ ಸೇರಿಸ್ಬಿಡೋಣ. Such
ಇಲ್ಲ,
maximum.
ಅಲ್ಲ ಅಲ್ಲೇನಾಗುತ್ತೆ ಅದು ರೂರಲ್ ಔಟ್ಲೆಟ್ ಅಷ್ಟೊಂದು ಸೇಲ್ಸ್ ಆಗಲ್ಲ ಅವ್ರಿಗೆ. ಇಟ್ ಇಸ್ ಇನ್ ಬಿಟ್ವೀನ್
Sales ಆಗಲ್ಲ ಅಂತ ಅದಕ್ಕೆ 8 ಪೈಸೆ ಜಾಸ್ತಿ ಕಮ್ಮಿ
ತಪ್ಪದು
ಎಲ್ಲ ಮಾಡಿದ್ರೆ
ತಪ್ಪದು
ಹೆಂಗೆ?
100% ತಪ್ಪದು.
A rural area people don't have the money, Mr. Siddharaj.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ತಪ್ಪು
Because of
ಅಂದ್ರೆ
the interim order, we are
No, I'm-
passing this order. Otherwise, for the first time coming, we would not have given you this.
I am not justifying the action.
ಅದಕ್ಕೆ ಬಿಡಿ.
Please, madam, oblige.
39, TA Karumbaya.
Mr. Karumbaya. ಬರ್ತಾ ಇದ್ದಾರಾ?
ಬರ್ತಾ ಇದ್ದಾರೆ.
ಕೊಡಿ ಇದು.
That site number 19 was allotted to petitioner in the year 1972, my lord, with a condition at annexure A, my lord. It has to be constructed within 2 years, but he has failed at page number 11, my lord.
ಇವಾಗ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದಾರಾ?
ಇವ್ರು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ. ಅದು ಒಂದು ಸಂಸ್ಥೆ ಒಂದು ಹರಿಜನ
ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್, ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್.
ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಹರಿಜನ ಎಜುಕೇಟೆಡ್ ಅನ್ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್ ಅಂತ ಇಲ್ಲ, ಅಸೋಸಿಯೇಷನ್ಗೆ ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರೆ ಮೆಂಬರ್ಸ್.
5 acres 11 guntas. 5 acres 11 guntas and not used.
Not used, only around 10 sites were not used. 10 sites were re-allotted in the year 2015 for the same society. 2015 at page number
None appears
18, my lord.
for this
And
petition.
even the beneficiary is not made as a party, even the society is not made as a party in this petition. Kumar is the allottee, my lord. At page number 20, serial number 10, site number 19, Kumar. He is also not made as a party. They states in the petition that he is fifth respondent, but in the petition I am not getting that.
None appears for the petitioner. Learned AGA submit that the persons would be aggrieved by, would be affected by an order passed in this petition have not been made parties.
The society and the Kumar, who is the
Namely,
beneficiary.
society and allotee of his site. If none were to appear for the petitioner on the next date of hearing, petition will be liable to be dismissed for non-prosecution. Released on 13th December.
40,
Appear for the petitioner, my lords.
Yes.
My lords, seeking time to need the clarification from client, my lords. Since the prayer has become infructuous, we need to seek clarification from the client, my lords. Kindly 1 week time. My lords, prayer might have become.
13/4.
Yes, my lord.
And there is no interim order.
Yes, my lords. Since the prayer is taken in 2000.
And you did not comply with the interim order also. Interim order ಆದ್ಮೇಲೆ comply ಇಲ್ಲ, ಅದನ್ನ vacate ಮಾಡಿದ್ದಾರೆ.
My lords, 1 week time may be given. We'll seek the instruction from.
Not necessary. 2015, why should we keep? Petitioner is before this court seeking for the following leave. Though interim order was granted on 3/8/2015, the same came to be vacated on 16/3/2017, was held to have been automatically vacated while order dated 16/3/2017. What has been challenged in the present proceedings is a notice under section 13(4) of the Surface Act. No interim order having been granted, the petitioner having alternative efficacious remedy, the petition stands dismissed.
41,
May I appear for the petitioner? Yes. Lord petitioner, Lord files a suit for declaration against the fourth respondent, my lord, before the civil court.
Respondent number 4 is retired.
My lord, what happens, my lord, is the fourth respondent is a private party.
Fourth respondent is a private party. Injunction is granted in my favor before the civil court. He approaches the special tahsildar and makes an application for giving police protection. Special tahsildar, my lord, has given police protection against the interim order passed by the court. Therefore, my lord, I have challenged the same.
CPC proceeding.
Illa illa.
Suit ಅಲ್ಲಿ
Suit alli,
Huh.
suit is for the relief of declaration of title
Yes.
and for permanent injunction.
Hmm.
My suit as against the fourth respondent.
Hmm.
Interim order came to be granted during the year 2011.
Your suit, you filed OS 5938
Please, my lord,
for injunction.
injunction, declaration and injunction.
Huh.
That suit, my lord, interim order came to be granted during the year 2011.
Yes.
Subsequently, my lord, during the year 2015, fourth respondent has filed an application before the special tahsildar to grant police protection in his favor. Special tahsildar directs the jurisdictional police to give police protection
Against the order.
against the order. That was challenged before this court. This court, by an order dated 30th October 2015, was pleased to grant interim order.
Hmm.
And subsequently, my lord, I placed on record, the judgment has also been, suit has also been decreed
In your favor.
in my favor. I am all to be declared. Thereafter, I got the land converted. Property is being developed now.
The petitioner is before this court seeking for the following relief. The petitioner had filed a suit in OS number 5938 of 2010, seeking for, suit was for,
Declaration and permanent injunction.
declaration and permanent injunction, wherein ex parte ಆಗ್ಲಿಲ್ಲ.
He contested.
ಅಲ್ಲ, ex parte interim order ಇಲ್ಲ.
Ex parte interim order ಇಲ್ಲ. ಆಮೇಲೆ after
After
contest.
hearing the parties, the trial court allowed IA 2 and 3 filed by the petitioner who was a plaintiff therein, injuncting the fourth respondent herein who was the defendant therein from interfering with the possession of the petitioner and also demolishing the compound or sheds standing on the property. At that stage, defendant number 4 had approached the jurisdictional police, the jurisdiction tahsildar,
Special tahsil.
namely respondent number 2, who had directed respondent number 3, police inspector, to provide protection to defendant number 4. It is challenging the same, the petitioner is before this court. On notice having been issued to respondent number 4, though a counsel had entered appearance, the said counsel has subsequently retired from the matter. Today, I learned counsel for the petitioner submits that the suit in OS number 5938 of 2010 has been decreed in favor of the petitioner, and the same has attained finality on account of no appeal having been filed to the knowledge of the petitioner. His submission is, post the said decree, the petitioner has taken upon the development of the property. Well, in view of the said submission, and the consider opinion that only a formal order to quash the direction issued by the special tahsildar would have to be passed, since there's a decree in favor of the petitioner. In that view of the matter, I pass the following order. Writ petition allowed, a certiorari is issued, so and so, at annexure Q, he is quashed. The special tahsildar, ಇದು ಯಾವಾಗ ಅವ್ರಿಲ್ಲ ಇವಾಗ.
2015.
The first respondent is directed to instruct, and the principal secretary of the Revenue Department is directed to instruct the concerned tahsildars coming under his jurisdiction to not to issue any directions contrary to the orders passed by the civil courts and or other courts. Since in the present case, the special tahsildar has issued a direction to the police to act contrary to the injunction order passed by the civil court in OS number 5938 of 2010.
Grateful.
Forty-two. Aditya Shetty.
Yes, I would request for some time, the filing the memo, producing the document
But if my lords were to recollect,
Affidavit filed by them, my lord.
the issue is about, my lords, the overhead water tank, a portion of it.
Portion of,
Regarding replacement.
My lords, my
Yes.
lords were
Amount.
kind enough, my lords, to ask the government if they can exchange a portion of that land with a portion of my own land which lies adjacent to it. Now, what the government essentially says, my lords, the government is not ruling it out. What the government says, my lords, that there is a procedure which is mandated, which I totally agree,
Phase
my
two,
lords. May I seek for some time, my lords, because there are
under
certain,
section 2 of the Forest Code.
yes, two, and my lords, if my lords were to see the forest conservation rules of 2022, it provides for an exchange mechanism. It's rule, my lords,
The state government will not be
We have
the,
no any.
state government alle.
the state government will only be the inspection and recommending authority.
How's-
Ultimately, they are.
Order has to be passed by the central government.
Yes, yes. Of course, there are only two material, my lords, if I can persuade my lords. The coordinate bench of this honorable court, my lords, are directed for a survey. A survey report, my lords, is there, my lords, with the records of the government.
Now they are saying they won't have an objection. If you file an application, they'll give you a favorable.
May I just, of course, that is the option, my lords, which I have to bow down to. But before that, my lords,
That's the only option you have.
may I just persuade my lord.
Yes.
My lords, if my lords were to see the report,
Hmm.
the revenue department conducted a survey, and what they found, my lords, that the boundary is not demarkable exactly. That's what the
Correct.
survey says. And my lords, there are certain photographs, my lords, which were placed on record as far back on, my lords, on the 8th of October 2015. Certain photographs, my lords, which would depict, in fact, not.
We cannot now decide what is
They have filed
forest land.
affidavit, they admit the
Correct.
fact that, my lord.
No, my lords, I bow down.
You have yourself said that there's a little bit of forest land
Is within the
which
forest land.
comes under the
Forest land.
shadow of your water tank or whatever.
Yes, yes.
That you'll have to do it, otherwise
Boundary.
your water tank will go.
Then in that case, my lords, may I seek some indulgence, my lords, because if that is so, then the petition itself can be considered as a request. My lords, if my lords were to direct the government,
You have to file a application to the central government,
yes,
who is not a party here.
my lords, may I make the submission, my lords? As per rule 9(2), my lords, the DFO, if the land is under 5 hectares, rule 9(2), if my lords were to see,
Rule 9(2) of
of the forest conservation rules of 2022, my lords.
forest. Ilva, book. Rule 9?
Rule 9, my lords,
Huh?
Rule 9, clause 2. My lords has. The user agency shall make an application to the state government or union territory administration for approval of the central government under section 2 of the Act for de-reservation of forest land, use of forest land for non-forest purposes, or for assignment of lease in the specified online forms to be notified by the central government. Then, my lords, 3J, my lords. I'm sorry, 4J.
Could you
Rule
next page?
4J.
Just one.
I'm sorry.
Page 23, could you? Yes,
My lords has rule 4J. my lords.
yes.
It says, proposal involving forest land of less than 5 hectares shall, after examination at the level of the divisional forest officer, be forwarded by him directly to the.
Just one.
I'm sorry.
19.
May I just pass this on?
Page 20 ಅಲ್ಲೆಲ್ಲ ಇರ್ಬೇಕು. ಯಾವ್ದು ಬೇಕು ಅಲ್ಲಿ. Yes,
4J.
There is no 4J.
ನಾನು ಕೊಡ್ಲಾ ಸ್ವಾಮಿ.
4E ಇದೆ ಇಲ್ಲಿ.
ನಾನು ಡೌನ್ಲೋಡ್ ಮಾಡಿದೆ ಈಗ. After my learned friend served on.
Only 4E is available.
4J ತಾವು ನೋಡಿದ್ರು. If it is under 5 hectares, the DFO himself can, let's consider antiga. He can forward his recommendation to the nodal officer.
9-4J na.
Yes, yes.
We are looking at 4J.
No, I'm sorry. 9-4G. It is hardly, my lord, maybe a few square feet and kantade, not more than that.
But it's all governed by 9-2.
Absolutely,
So the application has to be made to the central government.
absolutely,
Who
true.
the application has to be processed is different.
Yes, yes,
The processing by the divisional forest officer will happen.
yes.
But 9 ಆಗ್ಬೇಕಲ್ಲ.
9 ಅಲ್ಲ 9 ಅಲ್ಲಿ 9
9-2 ಆಗ್ಬೇಕು.
yes 9-2 says, my lords, I can apply to the state government.
No,
Yes, may I just read it out? my lords?
application to the state government or union territory for approval of the central government under subsection 2
Yes,
as per the specified online forms.
yes. So
So
I
you
need to
online
make,
form, you have to make that application.
yes, yes,
So you do that application.
Very
Wherever once it is made online, it will go to all the concerned authorities.
very well,
So it's not physical.
very well.
Electronically, it will get distributed.
Till such time, my lords, if my interest is protected,
Learned counsel for the learned AGA has filed a memo dated 28/11/2024, which is taken on record. The submission of learned AGA is that it is for the petitioner to make necessary application in terms of subsections. Then
rule 9,
rule
9-2.
Sub-rule 2 of Rule 9 under the Forest Conservation Rules 2022. For the purposes of de-reservation of any forest land.
Please.
And if the same is filed, it would be considered by the appropriate authorities. Faced with the above situation, learned counsel for the petitioner submits that necessary application will be filed
Within 2 weeks, my lords, a
within
fortnight.
on or before 13th December 2024.
Very well.
If such an application is filed, in view thereof, I have the considered opinion that the above petition can be disposed of by issuing suitable directions. If an application is filed by the petitioner by 13th December 2024, the concerned authorities to consider the same and pass necessary orders as expeditiously as possible. Needless to say, until such orders are passed, no further action to be taken in pursuance of the notice dated 3rd October 2015 at Annexure M.
I'm so great. Pradeep Patil.
Examination permission. Today is the last day. Purnima. The NKT accepts notice for respondent 2. ಒಂದು ನಿಮಿಷ ಪೂರ್ಣಿಮಾ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ಲಿ ಲಕ್ಷ್ಮಿ, ಇದೆಲ್ಲ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಆಗತ್ತೆ, ನೀವು ತಗೊಂಡು ಹೋಗ್ಬಿಡಿ. NKT accepts notice for respondent number 2. Ms. Mamta Kulkarni accepts notice for respondent number 1. ಅದು fee payment and delivery. Released on 20 ನಾಳೆ ಅಲ್ಲ,
ನಾಳೆ ಮೇಲೆ
29th.
along with the WP 9203.
Connect with WP
9203.
92
I'll give man.
ಕೊಡಿ.
Serial number 2, Abhishek Malipatil.
Same. NKT for
Respondent number 1, my lords.
respondent number 1, Mamta Kulkarni for
two.
respondent number 2. Notice to respondent number 3 is dispensed with for now. Same, collect the fees,
Please,
release tomorrow along with so and so
request for the hand delivery.
and delivery.
Parshuram A.
For the petitioner, same. Same thought. NKT for one. Mamta Kulkarni for respond number 2. Notice to respond number 3 is dispensed with for now.
Hand delivery.
And delivery,
Please.
we list tomorrow.
So great. So we'll tag these matters along with Milord.
Yes. All of them will be taken up tomorrow.
List number 1, serial number 43. NR Nayak.
Mr. Nayak? ಬರ್ತಾ ಇದ್ದಾರಾ? None appears for the petitioner today. Relist on 18th December.
44. Jagdish Badiga.
Yes, Ms. Badiga. Ready?
MOU.
There is a direction by this court to produce the
MOU.
MOU.
But MOU, they were unable to find my lord, it was destroyed. That report is given. My lord.
1/12/2020 order.
MOU was.
We'll consider as if there is no MOU. Produce ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ no MOU. It will adversely affect you. MOU ಇಲ್ಲ ಅಂದ್ರೆ.
ಇಲ್ಲ MO ಇಲ್ಲ ಅಂದ್ರೆ petition has to be allowed.
What is this matter?
It is the communication given. My lord.
Sale deed has been executed in favor of the petitioners.
Nobody has a MOU. When the income tax department has this DR has this.
Weeding out of old records. But anyway, this statement made by them will inure to the benefit of Mr. Badiga. Minor significance. Kept pending the local audit report for want of replies. So no further replies were received from the department in this regard. Meanwhile, as part of weeding out. Learned AG submits on instructions in presence of the letter received by him from the deputy commissioner. Yeah, ಎಲ್ಲಿ ಇದು? ಅಲ್ಲ, ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿ, district registrar, Jayanagar, Bangalore, that the MOU which had been directed to be produced has been destroyed during the weeding out of the old records. Hence, the MOU not being placed on record, the matter would have to be considered dehors any contention regarding the MOU.
The date may fix it, my
It
lord.
is rather strange that a document has been destroyed during the weeding out process without maintaining electronic digital copy thereof. Hence, the first respondent is directed to instruct all concerned coming under his jurisdiction to henceforth not destroy, before destroying any records, to make an electronic digital copy thereof.
ಅಲ್ಲ ಇದು ಒಂದ್ ಐ ಸಾರಿ ಅವ್ರ ಹತ್ರ ಇರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲ ಇದು, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇತ್ತು.
ಯಾವ್ದು ಇವ್ರು ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಸರಿ.
before destruction of the same, either as weeding out process or otherwise. Yes, ready?
Copy of that may be communicated.
Learned AGA to communicate the same to the first respondent.
First respondent ke direct communicate madari.
Registrar Judicial is directed to communicate the above direction to the first respondent. And a compliance report to be filed within 2 weeks, 3 weeks from now, on or before 18th December. Yes. ಏನಿದು?
Your lordship will get the sale deed at annexure B.
in that sale deed, at page 23,
Next year, B na.
B.
Yes.
In page number 23 ಅಲ್ಲಿ, clause 6, 2,15,000 consideration to
Page 26,
23.
23.
The
Yes.
consideration shown is as 2,15,000. 2
2
crores
crore
50
15 lakhs.
2 crores 15 lakhs. On that, I paid the stamp duty and registration charges.
Yes.
Now the respondents claims that in the MOU, 3 crores have been shown, so pay the difference amount. That is the dispute.
ಅಷ್ಟೇನಾ dispute?
ಅಷ್ಟೇ ಇರೋದು.
ಅದು MOU ಇಲ್ಲ.
Para number 4 of my statement of objection.
MOU ಇಲ್ಲ. Petitioner is before this court seeking for the following leaves. The petitioner, being the purchaser of a property bearing survey number 79/5A measuring 22 guntas, situated at Dodkal Sandra village, Uttaralli Obli, Bangalore South Taluk. Wide, a registered sale deed dated 4/8/2008 had made payment of stamp duty and registration fee of a sum of rupees 75,45 by valuing the same at rupees 2,15,00,000. Subsequent thereto, after a lapse of more than 5 years, the second respondent, the district registrar and deputy commissioner of stamps, had issued a notice on 12/9/2013 under section 46 capital A of the Karnataka Stamps Act 1959, claiming that there is a deficit stamp duty paid and that the petitioner is required to make payment of stamp duty on 3,00,00,000. The said contention on part of the second respondent being on the basis of a memorandum of understanding said to have been executed between the vendor and the petitioner as purchaser, which had been produced before the income tax department.
Hello.
This court,
Produced ಅಲ್ಲ, ಅದನ್ನು when the income tax department seized from the vendor.
which had been seized by the income tax department from the vendor and was available and communicated by the income tax department to the district registrar. This court, noticing the said aspect, had called upon the AGA to secure and produce the agreement of sale dated 11/8/2008 styled as MOU, while it's order dated 17/3/2022.
ಅಲ್ಲ, first order 1/12/2020.
1/12/20.
1/12/2020, first order.
1/12/2020.
1/12/2020. The same was reiterated on 28/5/2021, 17/3/2022, 18/4/22, 8/6/23, and 8/6/2023. Today, the learned AGA has produced a letter addressed to him by the district registrar, Jayanagar, Bangalore, stating that the MOU, the said MOU has been destroyed during the weeding out process. ಇವಾಗ ಅದು ಆವಾಗಲೇ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಲ್ಲ, ಇಲ್ಲೇ ಹಾಕ್ಬಿಡಿ. In view of the categorical submission made now on instruction that the MOU is not available, the very basis of the claim of the second respondent being on the said MOU, that the value of the property has been shown as rupees 3,00,00,000,000 has not been established by the respondent number 2. In that view of the matter, there being no other basis for the claim made by respondent number 2, I am of the considered opinion that the petition is required to be allowed. As such, I pass the following order. So on, so such, should I quash? Though the above matter is disposed for reporting compliance, relist on 18/12. Register judicial to forward a copy of this order to respondent number 1.
Serial number 45, adjourn 46. P.N. Jayadeva.
Petitioner in this case.
ಯಾರಪ್ಪ ಈ ಕಡೆ?
The temple matter, my lord. Mismanage ಮಾಡಿದ್ದಾರೆ. ಅದು mismanagement ಏನು ಅಂತ opinion ಕೊಟ್ಟಿದ್ದಾರೆ. But despite that, they are giving notices, my lord.
Who is on this side? You are seeking for a declaration that the Act of 97 is already decide ಆಗಿದೆಲ್ಲ.
ಒಂದ್ಸಲ ಡಿಸೈಡ್ ಆಯ್ತು. ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ವಿತಿನ್ 1 month ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡಿದ್ರು. 1 month ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡಲೇ ಇಲ್ಲ ಅವರು. They didn't seek for extension time also.
La prayer AA, in prayer AA does not survive consideration. The challenge to the constitutional validity.
That is pending in the Supreme Court.
You're pending ಇದೆಯಾ?
Supreme Court pending ಇದೆ.
Hindu religious and
ಅಲ್ಲಿ ಏನಾಗಿಲ್ಲ, pending ಇದೆ.
I will verify, my lord. A week's time.
ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಪೆಂಡಿಂಗ್ ಇದೆ, ಅಡ್ಮಿಟ್ ಆಗಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಟು ಮೈ ನಾಲೆಡ್ಜ್.
AGA seeks for and is granted. Because both A and B ಆಗಿರ್ಬೇಕು. Seeks for and is granted a week's time to obtain instruction, make its submission. Released on 13th December.
47. Vinav Ramanan.
My lords, I am appearing on. My lords, am I audible, my lords?
Yes, please.
My lords, I am appearing as a proxy counsel for respondent number 2, my lords, in this matter. My lords, I have been accommodated to ask for a short adjournment, your lordships. The main counsel is in hospital, my lord, due to
There is
emergency.
no need, we are dismissing the petition. Despite the order dated 6/11/24, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting.
Please, your lordship, much obliged.
48, adjourn 49. Harish Bandari.
Mr. Bandari? ಬರ್ತಾ ಇದ್ದಾರಾ? None appears.
It's only with respect to 2015 communication, madam, with respect to advertisement.
Erection of hoardings.
Hold on. 43.
The period has already expired.
Yes. In 2016 itself, the contract expired. Thereafter, they have filed in 2016 one more writ petition, two more writ petitions that were also disposed of. So it doesn't survive as a tender. What we have called, that was challenged in 2016.
But ಇದು already 27th February 2019 ಒಂದ್ಸತಿ dispose ಆಯಿತು. ಮತ್ತೆ recall ಆಯ್ತಾ? It was recalled. The very same submission you made, it was dismissed on that account. Then it was recalled because there was another.
I have to appear, my lord, because we don't have paperwork. I have only copy of statement of objection filed in this matter, connected matters. Maybe another one chance of appearance may be given.
None appears for the petitioner today. If none were to appear, dismissal relist on 13th. under the caption.
50. Ashok Nayak.
Petitioner, kindly have this matter after the.
ಯಾವತ್ ಬರ್ತಾರೆ ಮೇಡಮ್?
So this is the details of the,
ಯಾವತ್ ಬರ್ತಾರೆ ನಿಮ್
January he is coming.
ಫುಲ್ ಡಿಸೆಂಬರ್ ರಜಾನ?
Yes. Because
Leave
it's
letter ಬಂದಿಲ್ಲ.
10 crore of amount at the release of the 10 crore of amount.
How can he go for 1 month during court working? At the request of counsel for the petitioner release January ಮಧ್ಯದಲ್ಲಿ ಯಾವ್ದು?
Obliged. January 20th. Serial number 51.
Kindly press time.
Respondent.
Yeah.
ಬರ್ತಾ ಇದ್ದಾರಾ petitioner?
ಬರ್ತಾ ಇದೆ.
None appears for the petitioner at the request of the respondent released on 18th December.
52 urgent 53. Janardana ji.
So Janardhan?
ಬರ್ತಾ ಇದೆ.
None appears for the petitioner today, released on 18th December.
54. Shanmukappa.
54.
Solar rooftop agreement. Some other cases are also listed before this. May kindly be adjourned.
Connect with, ಯಾವತ್ತಿದೆ date?
Maybe I.
Connect with so and so and release so and so. ಕೊಟ್ಬಿಡಿ. None appears for the petitioner.
55.
Yes, madam.
For the petitioner, my lords.
Ravi Shankar RH.
My lords, the short grievance is that, my lords,
Huh?
the second petitioner, my lords, through her husband, lodges a complaint, police complaint against the petitioner for medical negligence. The police refers the matter to the Karnataka Medical Council, my lords. KMC has initiated an inquiry, my lords, which your lordship would kindly get it at Annexure D, my lords. Simultaneously, what happens is a second respondent, my lords, she files a complaint before the first respondent. And the first respondent, which is the National Commission for Women, they issue a notice, an impugn notice, which I'm challenging before your lordships.
When the
Which is
matter
why
is pending
in
before the KMC.
Please, my lords, and adalde district commissioner go hakadru, alli they lost the case, my lords. In KMC, my lords, it is pending. She doesn't even appear. It's nothing but harassment to the doctor, my lords. They go on receiving, my lords, not to eulogize or yesify the power of this honorable court, but this honorable court alone can stop such harassment against the doctors, my lords. May I take your lordships through this, through the National Commission for Women rules, my lords?
Who appears for the NCW? Ravi Shankar RH. Idara or in a panel alli?
I have no idea.
Mr. Kumar, National Commission for Women. You will appear. Shri M.N. Kumar is directed to accept notice for respond number 1. Ravi Shankar RH ಯಾರು? ಅವ್ರ ಹೆಸರಿದೆ ಇಲ್ಲಿ. ಅವ್ರು ಇದಾರ ಪ್ಯಾನೆಲ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
Memo of appearance is filed in 2017.
ಚೇಂಜ್ ಆದಾಗ ಯಾರು ವಕಾಲತೆ ಹಾಕಲ್ಲ, ಏನ್ ಮಾಡೋದು?
What happens normally, if it is, the list is not continued, retirement memo ಹಾಕ್ಬೇಕು.
ಹಾಕಲ್ವೇ?
I will have it checked.
ಎಲ್ಲ ಆದಾಗೆಲ್ಲ DSGI ಅಂತ ಕರಿಬೇಕು ಅಷ್ಟೇ.
I will have it checked and I will make.
ವಕಾಲತ್ ಹಾಕಲ್ಲ, ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಲ್ಲ, ಅಪಿಯರೆನ್ಸ್ ಹಾಕಲ್ಲ.
ಅದಕ್ಕೆ ನಾವು ಏನ್ ಮಾಡಿದ್ವಿ,
ಎಲ್ಲ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್, ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಆದ್ರೂ ಇಲ್ಲಿ ಹಿಡಿಬಹುದು.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಲಾ ಸೂಟ್ಸ್ ಅಂತ ಒಂದು ಸಾಫ್ಟ್ವೇರ್ ಇದೆ. ಅದು ಮ್ಯಾಟ್ರ್ ಅಸೈನ್ ಆದ ಕೂಡಲೇ ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿಬಿಡ್ತೇವೆ. ನಮ್ಮ ಹೆಸರು ಕಾಸ್ ತೋರಿಸೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. ದಟ್ ರಿಫ್ಲೆಕ್ಟ್ಸ್.
Limbs is only to say what is the allotment made and how many cases are there. That doesn't give you the.
It will, in Supreme Court, even we can file online, except High Courts. We can file even online through using that. It pulls everything. As far as High Court is concerned, it is not yet been.
ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿ CCMS ಹೆಂಗ್ ವರ್ಕ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ಕೊಡಿ ಅವ್ರಿಗೆ. CCMS ಅಂತದ್ ಏನಾದ್ರು ಅವ್ರು ಮಾಡ್ಬೋದು.
It works well.
And many a time this name is shown, we don't know whether he's on the panel continuing or not. 2017, what to do?
I'll have it checked minutes, I will take in second.
He is also directed to take notice. Registry is directed to print the name of Sri M.N. Kumar as also that appearing for respond number 1. He seeks for and is granted a week's time to obtain, to 2 weeks' time to obtain instruction, make a submission. As to how the first respondent could exercise jurisdiction over a complaint filed by respondent number 2 when the matter was pending before the jurisdictional authority, namely the Karnataka Medical Council,
Request for a
released on 13th.
13.
Can't be exercising this. Commission is not for that.
Now, there are so many commissions.
Obliged.
as time and again, certain nothing, orders are passed, man, that's still it. There are,
The concerned authority is KMC.
2 weeks.
What,
Role and responsibility and
ಜಾಸ್ತಿ ಹೇಳೋದು ಬೇಡ.
Obliged.
Somnath,
Next time is only notice, madam.
despite order dated 23 dismissed.
57, Ramachandran case.
For the respondent.
So Ramachandran. ಬರ್ತಾ ಇದ್ದಾರೆ? None appears for the petitioner, those counsel for respondent. 57, madam. Counsel for respondent number 1 is present. Released on 13th December.
58, Maya Holla.
Your Lordship, I appear for the petitioner in this. I seek for a short accommodation in this, Your Lordship. Any date next week, Your Lordship.
Counsel for the petitioner.
For the response.
Here Umapati. Though counsel for respondent number 2 is present
Yes, ma'am.
and ready.
No, ma'am.
Both counsel for petitioner and respondent number 2 seek for a short accommodation. None appears for the party. The party in person is not present. Released on 18th December.
Grateful.
59, adjourn 60.
60, I am appearing, madam.
Yes, madam. Yarge, madam.
Hello, I appear for the petition in the case. Well, now for the first time, they raised some office objections. I have to comply with.
In the second matter.
I will comply with.
Amendment
my lord.
application to be shown. Learned counsel for the petitioner in WP 7506 of 2021 seeks for and is granted 2 weeks' time to comply with the office objection.
ಅಲ್ಲ, ಒಂದ್ week ಅಲ್ಲೇ ಮಾಡ್ತೀನಿ
1 week's time to
ತಮ್ಮಂದನ್ನೇ
comply
ಮಾಡ್-
with the office objection.
Grateful,
Released
madam.
on 12th
Yes,
December.
madam.
61, Kevin.
My lord, I am for the petitioner in 61.2, my lord.
61.2,
My lord.
Vinod.
The specified banknotes exchange, my lord, outside the rules, they will have to go to the government of India as directed by the
Demonetized.
Honorable Supreme Court. Last time your lordship directed.
Demonetized.
Demonetized.
But in my case, there is a specific order passed by the learned magistrate.
No,
Despite that, my lord, endorsement issued by the matter has to be heard. Matter may have to be heard, man.
Magistrate ಏನಂತ ಆರ್ಡರ್ ಮಾಡಿದ?
ಅದು ಏನಾಗಿತ್ತು? It was confiscated. The Andar Bahar
Gambling.
Police Act.
Hmm.
Then, my lord, the proceedings were quashed by this honorable court. We applied to the learned magistrate to
Return the money.
that was allowed. We gave representation to RBI. They have refused to.
Number ಎಲ್ಲ ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇದೆಯಾ?
Then, my lord, the honorable magistrate has ordered for exchange of, my lord.
So that is in the
61.1.
61.1. What about 61?
My lord, 61.1.2 also same, my lord. My cash was seized during election, my lord. And the criminal proceedings is quashed, my lord.
61, ಒಂದ್ ನಿಮಿಷ 61 ಕೇಳೋಣ.
My lord, I'm going to respond number 2 in 61.
61 ಅಂದರ್ ಬಾರ?
Other than
ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದು you have to go there. You will have to show why you are carrying all that information. You have to give to the RBI. Illi at least there's.
No, my lord, the point is, during her absence, There is a credit of SBN done already in her account.
Yes.
Yeah, that disentitles her from encashing further amount after coming back to India. There is a regulation with that. That's why they will all have to go to.
During
before
her
the-
absence from India, there was
Yes,
already
there
amount
is a
deposit.
credit made, 6,000 rupees.
ಅಷ್ಟೇ.
In SBNs.
ಇವಾಗ ಎಷ್ಟು? ಇವಾಗ ಎಷ್ಟಿದೆ?
2 lakh, something, 2 lakh 45,000. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ, I don't know. They will have to examine, the government of India will have to examine. She came back somewhere in the first week of January. After 2 months, she has come to the bank and tendered this money. We don't know how the source and all that. Anyway, there is.
She has a salary of 6,000 rupees and you want to deposit 2,41,000 rupees. From where did you get it? 6,000 rupees save ಮಾಡಬೇಕು ಅಂದ್ರೆ 40 ತಿಂಗಳು ಬೇಕಾಗತ್ತೆ. Full amount save ಮಾಡಿದ್ರೆ. How can it be? You make a representation to the, as per the division bench order. Insofar as these, we'll have to consider if there's a requirement to go there when a judicial order is there.
My lord, judicial order was made after that specified date.
Maybe.
My lord, that order, my lord,
Maybe,
cannot
but if the-
override the rules, my lord. The
There
Supreme.
is seizure made by an authority and the amount is kept in safe custody of a court. And that amount has been returned by the court to them. Would the rules come in the way? Because they had no cession over the amount. They had no way of they could deposit within the time period.
No, my lord, the order was passed before the specified time. The petitioner took a long time to take back the money. And my lord, the note numbers are also not specified in the order.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಶಾಸ್ತ್ರಿ ಅವ್ರಿಗೆ ನಂಬರ್ಸ್ ಇದಾವ
ಇಲ್ಲ ಇಲ್ಲ ಏನು ಇಲ್ಲ.
ಸೀಜರ್ ಮೆಮೋ ಅಲ್ಲಿ ಇರತ್ತಲ್ಲ ನಮ್ಮ
ಸೀಜರ್ ಮೆಮೋನಲ್ಲೂ ಇಲ್ಲ, ರಿಲೀಸ್ ಮೆಮೋನಲ್ಲೂ ಇಲ್ಲ, ರಿಲೀಸ್ ಆರ್ಡರ್ನಲ್ಲೂ ಇಲ್ಲ. And there is a specific rule. My lord, contrary to that rule, my lord, no order can be passed. That is the reason why the government is seasoned of these matters. Let them go there.
For everything, they cannot be going there.
Not the two orders are there, my lord.
Are the notes identified by the number?
Number ಅವರು ಪೊಲೀಸ್ನವರು ಮಾಡಿ.
ಯಾವ್ದಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ? ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಇದ್ರೆ we'll exercise our jurisdiction. But if there is no identification, then it will have to go before them. They'll have to consider your representation.
As per the division bench judgment.
ಹೌದು.
Paragraph 9, 10 and 11. my
If
lord, are
there's
relevant.
a clear identification of the numbers as the time of seizure and at time of return to you, and it is the same notes that you are depositing,
Then there is no problem.
we'll excise and direct them instead of you going all over the place. Because it was in the custody of the court, why
Correct.
should they be made to suffer? But if there's no identification, you will have to go through
Whatever notes that were seized,
Are
same notes have been returned.
whatever ಬೇಡ ನಮ್ಗೆ ನಂಬರ್ ಬೇಕು. WP number 40508 of 2017. He was a number for the notes and same number. you are
Comply with
depositing.
the judgment of the division bench.
ಮಾಡಿ.
Verify ಮಾಡಿ.
My lord, in my case, my lord,
Senior.
an amount was
Senior
released
number
on
ಇದೆಯಾ?
2018, my lord. 2018, my lord. And it was seized in 2011, my lord.
No, he is saying that.
ಆಯ್ತಪ್ಪ ನಂಬರ್ ಇದೆಯಾ?
Number, the police, my lord, they have not mentioned the number in PF, my
ನಂಬರ್
lord.
ಕೊಟ್ರೆ we'll pass an order. Otherwise
That is not my fault, my lord. Police have committed some irregularity, my lord. My lord, keeping the note in my house, my lord, it's very difficult, my lord.
you have a remedy to go before the Union of India as per the order in WA 200185 of 24. Only manner where we can short circuit the process is if you have the number. Otherwise, no.
Otherwise, lordship may kindly direct the police to receive the cash and renumber it and submit to the magistrate.
ಅದೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೀವೇನು?
My lord, there is no, because it's not my fault, my lord.
You go to the Union of India, they'll consider it. Both all the councils.
That amount was seized, my lord, large amount, 12.5 lakhs, seized during that election period of transport.
Whatever the amount may be, is nice.
Yeah,
If it
comply
is
with the rules.
identified, no problem.
Comply with the rules.
If it is one note or
100 notes.
1000 notes, it doesn't matter. Learn 61 ಏನಪ್ಪ? 61, learned counsel for the petitioner submit that she had deposited the demonetized notes on her return to India. If that be so, she would be covered by the decision of the division bench in WA number 200185 of 2024. He seeks for and is granted a week's time to obtain instruction, make a submission. 61.1 and 61.2.
They are
Both the counsels appearing for the petitioners in both the above matters submit that the demonetized notes had been seized by the jurisdictional police authorities for as regards under alleging that there are certain offences committed by the petitioners. A trial having been held, the petitioners have been acquitted in those offences.
Quashed, my lord.
The criminal proceedings against them have been named the acquitted or quashed.
Quashed.
Have been quashed. Acquitted. Quashed. And thereafter, the amounts having been returned by the court is sought to be deposited with the bank. The learned counsels for the petitioner are called upon to place on record the serial number of the notes which had been seized by the jurisdictional police as entered at the time of seizure, and the note number of the notes, number on the notes when they were returned to them. And if it is the same notes which are going to be presented in the bank for clearance. If the above details are not available, the petitioners in these matters would also be governed by the judgment of the division bench in WA number 200185 of 2024. Relist on 6th December.
as per the judgment of the
Relist on 12th December.
as per the judgment of the division bench, with those details they must apply to the government of India. ಇಂತ ಬರ್ದಿದ್ದಾರೆ division bench.
ಹೌದಾ?
Police have committed the malord mistake.
ಹಾಗೆ ಬರ್ದಿದ್ದಾರೆ.
ಇದ್ರೇನು ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಕಷ್ಟ.
That is what the division bench.
Police have committed the mistake.
ಅದಿದ್ರೇನು ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. All of you go there. There's no point having it another day.
That is what they.
No point in having it another. Even with the number you have to go to the.
Yeah, that is what the direction given by the.
We'll reserve that
Our
liberty.
writ petition may be disposed of as per the division.
Giving that. ಎಲ್ಲ ಹೊಡ್ದಾಕಿ. Petitioners in each of the above matters are before this court seeking for the following reliefs. Learned counsel for the Reserve Bank of India submits that the division bench of this court has extensively dealt with the matter in the judgment in WA number 200185 of 2024 and directed that any person who wishes to deposit a demonetized note would have to comply with the guidelines laid therein, reserving liberty to the petitioners to approach.
We have got a order of the learned bench.
Barala.
11th
comply-
observation.
To comply with the same, the petitions stand disposed. ಅದೂನು ಅದೇನಪ್ಪ ನಿಮ್ದಂತೂ ಇನ್ನೂ ವರ್ಷ ಅವ್ರದೇ ಕಳಿಸ್ತಾ ಇದೀವಿ ನಿಮ್ದು ಎಲ್ಲಿ ಬಂತು. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಆರ್ಡರ್ ಇದ್ರೇನು ಅವ್ರನ್ನಲ್ಲಿ ಕಳಿಸ್ತಾ ಇದೀವಿ, ನಿಮ್ಮನ್ನ ಎಲ್ಲಿ ಕಳಿಸ್ಬೇಕು? ನೀವು ಅಲ್ಲೇ ಮಾಡಿ. We are bound by the division bench order.
May I make a mention?
Yes.
Serial number 64, there is urgency, my lords. Serial number 64 is a
There is
case where the
urgency.
company's directors have been disqualified beyond the period of 5 years, which is impermissible. We are not able to file our annual
Before
returns.
relist on 6th.
Little earlier date, second or third, my lords, kindly, under the orders.
6, please.
My lords, kindly list under orders, my lords. Please. Under orders, my lords.
60, 69. Relist on 6th.
But 31 passed over matter.
Vacate stay ಎಲ್ಲ ಮಾತಾಡ್ಬೇಡಿ.
Passed over matter, but still number 31.
62 interim.
73, my lord. 73.
Vacate ಎಲ್ಲ ಮಾತಾಡ್ಬೇಡಿ.
73, my lord.
ಹಾ.
My account has been freezed, my lord, by the bank.
73,
3.
Hearing for the bank.
73 relist on 6th.
63, my lord. 63.
ಲೈನ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದೀವಿ.
63, my lord.
ಹಾ.
Sir, some urgency, my lord.
63 6th.
28 is a settled matter, but even the connected matter was moved in the morning by filing a fresh petition, my lords, on the 482.
It is come today.
But in fact, the office informs us that because fresh matter is filed under 482, it will go to the roster bench. There may be need to make
Connect 28 with the criminal petition number,
fresh matter filed.
so and so, ashte.
Please.
71, my lord.
And relist on 4th and Taktivi.
Please,
You see
please.
that.
71, my lord, any date?
81,
6th.
81 maybe.
6th.
Serial number 71, my lord.
ಏನಪ್ಪ ಹೇಳಿ ಬೇಗ ಹೇಳಿ.
Date may be given, my lord.
6th.
My lord, 64 under orders, my lord, please.
On 6th.
My lord, 31 is passed over.
Orders, my lord, please.
I will just push it to January then.
Sorry, my lord.
My lord, seal number 31, my lord, passed over by this one. And date may be given. Seal number 31.
Vacate stay ಬರಲ್ಲ ಇದು.
81 maybe.
ಏನಿದು?
53.
ಹಾ, ಹಾ.
Madam, 53.
ಹಾ, ಹೌದು.
Madam, 53. Madam, 53.
81 last number.
53, 18 December.
81.
Court officer 47.
ಯಾವತ್ತು ಬೇಕು?
ಯಾವತ್ತು ಕೊಡಿ ಮೇಡಮ್?
Court officer, serial number 31.
62.
71.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರ ಕೇಳ ಇಲ್ಲೆಲ್ಲ ಅಟೆಂಡ್ ಮಾಡ
62.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲ ಅಟೆಂಡ್ ಮಾಡ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿ. 28 ಕೇಳ್ಬಿಟ್ರು.
Madam, serial number 31.
31 ಯಾವತ್ ಬೇಕು ಮೇಡಮ್?
Ma'am, next week, any date.
31.
ಹೌದು.
Next week
Serial number 31.
31 6th December.
47 madam ಹಾಗೆ 47.
Dismissed. 47 dismissed. Vivek sir.
Dismissed.
62. Okay.
71.
Yeah.
ಯಾವ ಕಡೆಯಿಂದ ಬರ್ತೀನಿ? 62 ಯಾವ date?
62.
ಯಾವತ್ತು?
62 ಯಾವ ಡೇಟ್?
6th December.
IIT extended. yes.
Yes.
6th December. Thank you, madam.
66, 67, 68, 72,
71, madam.
71 ಅಡ್ಜನ್ ಅದು 6th December ಅಭಿನವ್ ಕೇಳಿದ್ದು 6th December 72, 74, 74 ಯಾವತ್ತು ಬೇಕು ಸರ್?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವಾಗ?
ಅದೇ ರೀಚ್ ಆಗಲ್ಲ ಹಿಂಗೆ ಕಾಯೋದೇನೆ.
ಹಂಗಾರೆ 6
6
ಅಲ್ಲ 6 ರೀಚ್ ಆಗಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ.
ಗೊತ್ತು ಆಗಲ್ಲ. 22 ಅಲ್ವಾ ಮ್ಯಾಟರ್ ನಿಮ್ದು? ಈ ರೋಸ್ಟರ್ ಇರೋದೇ ಅಪ್ ಟು 22 ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸೊ ಲಾಸ್ಟ್ ಅಲ್ಲೇ ಬರೋದು, ರೀಚ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ನೀವು ಯಾವತ್ ಕಾಯ್ತೀರಾ ಆ ಡೇಟ್ ಹೇಳಿ.
ಅಲ್ಲ ಎಲ್ಲ ದಿನ ಪ್ರತಿದಿನ ಕಾಯ್ತೀನಿ ನಾನು.
6
ಬೇರೆ ಇನ್ ಬಿಟ್ವೀನ್ ಕಮ್ಮಿ ಇರೋದು ಯಾವ್ದಾದ್ರು?
ಆಗಲ್ಲ, ಎಲ್ಲ ದಿನಾನು 100. 71 ಯಾವತ್ ಬೇಕು? 6th December. 77, 78, 79, 80 ಅಷ್ಟೇ. 64 64 6th December. ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಈಗ? ವಿವೇಕಾನಂದ ಸರ್ ಇದಾರಲ್ಲ ಇಲ್ಲ 6th December. ಅದ್ ಹೆಂಗಿರುತ್ತೆ ಹಂಗೆ ಬರುತ್ತೆ. ಇಲ್ಲ ಆರ್ಡರ್ಸ್ ಬರಲ್ಲ, ಅದು ಬರಲ್ಲ. ಏನಾದ್ರೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅವಾಗ ಬರುತ್ತೆ ಆರ್ಡರ್ಸ್ಗೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.